everyone. We are going to be starting our program now. I will be the MC here. So I would just like to say how happy I am to be starting this panel, presenting the president of the panel, Ângela Maria de Moraes, Appellate Court Judge of the Maranhão Supreme Court. She's very well known, very beloved, a fantastic judge, and the National High Court were very happy to have her here with us. In the panel, we also have Appellate Court Justice Rowan Wilson, that is from the state of New York, the first Chief Justice or President of that court that is of Afro-American origins. And it's also a big honor to have him here among us, especially because it is his first visit to Brazil, but the first of many. And lastly, we have here on our panel two extraordinary colleagues, Chief Justice Stevan Arnold Majiedt, that I have known for quite some time when he was still a judge of the Appellate Court and was then raised to the Constitutional Court of South Africa, someone for whom I also have great admiration, and a federal judge, Adriana Alves de Santos Cruz, who is an undeniable leader in the Brazilian magistrate, federal and state magistrate, but above all, what I admire in Adriana is her integrity and character. All of that together with a great legal knowledge and balance. These are characteristics of an excellent judge. It is an honor to have you here, Adriana. Today, she is General Secretary of the National Justice Council and participated directly with Federal Judge Edivaldo, who is directly responsible, but it is a team of an organization team, and Adriana was one of the coordinators. By the way, when I imagined this event, the first person that I approached was my General Secretary and Adriana Cruz. And we've already created a WhatsApp group about the event, and that is what we have here now. So without further ado, I pass the floor, hand the mic to our president, to Appellate Court, Ângela Salazar. Thank you very much, Minister or High Justice. Good morning to all. I would like to greet those that are here at this table, our dear High Justice, President of the National High Court. I would also like to congratulate the organizers of this event, the person that was ahead of imagining this event, Hernan Benjamin, Chief Justice Hernan Benjamin, and to make us think about this subject is so dear to us. I say this because when we look at the past and we see our present, we try to organize our future. I also congratulate those who fight and believe in better days, promoting justice and citizenship to Afro-descendants. I thank once more to our dear Chief Justice Hernan Benjamin, a person who I've learned to admire for his sensitivity, his courage and determination, especially in promoting an event of this nature, a historical event in the Brazilian Judiciary branch. So I'd like to thank for the invitation to preside such an important panel that is going to deal with racial equity in compared right or legal laws, Brazil, US, and South Africa. But before handing the floor to our dear speakers, I would like to note here at this point that racism in Brazil, we know very well, has its deep roots in European colonialism, constituted through slavery submission of African people, the non-effective inclusion of Afro-descendants in the economic, political, and social and cultural structure in the post and after the end of slavery that lasts even nowadays. And it is within this context and this societal model that our justice system is structured, that operates so as to maintain the inequalities. If, from our point of view of our citizen letter, the Afro-descendants conquered the equality of rights, however, Chief Justice, in their daily rights, in public spaces and private spaces, they are still discriminated against and unequally treated. The racist and prejudiced logic is extremely strong in the Brazilian society's mind, which for certain puts forth obstacles within the human rights of a Brazilian society. Racial equity is one of the fundamental pillars to build a democratic society that is just, free, and fraternal. However, it is only possible to reach this with effective institutional policies and the commitment of the Black and non-Black people. Today, we have the opportunity to know the policies to face this subject under the look of 3 countries that are marked by structural racism within their history. So I'd like to hand the floor now to our dear speaker, Appellate Court Judge Rowan Wilson, for 20 minutes. Appellate Court Judge Rowan Wilson is president of the Court of the State of New York, graduated from Harvard in '81 with a Bachelor in Arts in Law and at the Harvard Law School in '84 with a Juris Doctor, where he was an editor of the Harvard Civil Rights and Civil Labor Review. I apologize for the pronunciation. So the floor is yours, Mr. President.
Thank you, Judge Salazar. And if I'm invited back for the 5th racial equity seminar, I will be able to speak Portuguese. So if for those of you who were here yesterday, you heard your Chief Justice Barroso say that he always had 3 points, and it had something to do with tax law. So I always have 3 points that has nothing to do with tax law. It's because I was told you must at the beginning say how many points you have and what they are, and if it's more than 3, no one will pay attention. So the 3 points that I wish to discuss today are the following, and let me see if I can manipulate this. Here we go. So first, the history of racial discrimination in the United States, and this is 250 years condensed into 10 minutes. Next, a sort of snapshot of statistics of where we are in the United States. And then finally, what we have been doing in New York to try and achieve racial equity. And so let me say this as a preface, because this is the main point I wanted to deliver. there are times when the United States has been a global leader in many things, and there are times when the United States has made mistakes and has faltered on the path to justice. And when those times have occurred, others have had to step up. Sometimes it has been individual states. Many times it has been my state, the state of New York. But this is also an opportunity for the people of Brazil, where the United States has moved a little bit backwards nationally. While we in New York are doing what we can to fight that trend, I think Brazil is in a prime position to serve, to help the rest of the world, including the United States, see the correct path forward. So, moving first to the history of racial discrimination in the United States. If you were here also yesterday, you heard Cardinal Turkson say inalienable rights. And the inalienable rights, the first iteration of that you really see is in the United States Declaration of Independence, that the Creator has endowed each of us with inalienable rights, including the rights to life, liberty, and the pursuit of happiness. But that's now almost 250 years ago. So how is it that 250 years later, we in the United States are still struggling? And the whole first part of what I'm going to talk about really is about a struggle. So when you think about the United States Constitution, which is still the Constitution that we operate under, there have been amendments to it, not too many of them, but the document itself exists in the form it was in 1789 when it was ratified. When it was ratified, slavery was legal in the United States. And there are three provisions I want to draw your attention to. One is a provision that's called the 3/5 clause. And briefly, it said that people who were enslaved counted as 3/5 of a person for the purpose of representation. They didn't, of course, get to vote, but the people who owned them got the benefits as if they were 3/5 of a person in representation in Congress and in federal spending and things like that. The second provision prohibited the federal government from stopping the slave trade until the year 1808. So that's 20 years after the Constitution was ratified. Meaning that the agreement that these states made was that for 20 years, slavery would continue, for at least 20 years, the importation of slaves. And the third point is something called the Fugitive Slave Clause. In the Constitution of the United States, if a slave escaped to another state, to a free state where slavery was abolished, that state was obligated to return the person to that person's owner in the slave state. And Congress then passed a fugitive slave law, an act that followed this, this provision of the Constitution that provided criminal penalties for people who harbored fugitive slaves. And there's something about that that I will refer to in a bit. So it was not simply African Americans or the enslaved population who's been treated unjustly in the United States. When the colonists got there were approximately 15 million indigenous Americans living there, and by 1900 there were fewer than 250,000. There are other ethnic groups that have had difficulties when they came to the United States. None, I think, as severe as the Native Americans and the African Americans. We then come up to a decision that, again, Cardinal Turkson mentioned in a little bit of detail yesterday, the Supreme Court's decision in Dred Scott. And although what he mentioned was sort of the holding of the decision that Mr. Scott here, being not a person, could not sue in the federal courts, I wanted to put up a little bit of the language of the decision, because this language is what we call dicta. It was unnecessary to the decision, but the Chief Justice of the United States Supreme Court went out of his way to say the African race had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race. This is the dominant spirit of the times. This is what the Chief Justice of the United States Supreme Court said at the time. All that really would have been necessary to say, because those courts, the federal courts in our system, the United States courts, are what we call courts of limited jurisdiction. They can only hear a dispute between, well, other than federal questions, between a citizen of one state and a citizen of another state. So all they needed to say was that Mr. Scott was not a citizen and therefore he couldn't sue in the federal courts, but they went out of their way to include this demeaning language. There is perhaps the most famous dissent in our history by Justice John Marshall Harlan in this case, which eventually became the law of the United States, but it took a century. So Cardinal Turkson also mentioned the Reconstruction Amendments, but those are modifications to the Constitution. They're amendments to the Constitution, but they were not easy to come by at all. What preceded them was the Civil War. which was the bloodiest episode in American history. The war lasted a very long time, but even after the war, even after the North defeated the South, the Union States defeated the Confederate States, these amendments were not easy to come by. The way that they were adopted was the winning side, the Union, replaced all of the governments in the states that had lost with governments that the North controlled, and then required that those governments, which actually had a lot of African Americans in them for a very brief period of time, ratify these amendments to the Constitution. The 13th Amendment abolished slavery. That was a relatively easy one to get passed. The 14th Amendment was much more difficult. It was originally supposed to not just make African Americans citizens and to make anyone born in the United States a citizen, but it was supposed to include the right to vote, and it was thought that would be too difficult to accomplish, so that was moved into a separate amendment. The history of the 15th Amendment is in some ways the most interesting. It was passed only really because of those losing states, the governments that had been put into place in those losing states voted for it. Several of the northern states did not vote for it. These are the states that did not have slavery. They still did not want to give African Americans the right to vote. So New Jersey, for example, Ohio, for example, voted against this amendment. And New York voted for it and then withdrew its vote in favor of it, and then we voted for it only after it had passed enough states to become an amendment to the Constitution, a fairly ugly chapter in New York's history. I mentioned that others were, I'm not going to discuss the Chinese Exclusion Acts much, but this, even after you had the Reconstruction Amendments, you still had very racist policies implemented by the United States government. The United States government had also, right after Reconstruction, passed a Civil Rights Act, but then the United Supreme Court, 3 years later, in a decision called Cruikshank, said that the United States Congress did not have the power to stop violence against African Americans or others, racially based violence, if that violence was just engaged in by private people. The Supreme Court also decided another infamous case, Plessy versus Ferguson. The facts of that case are, briefly, a man who was 1/16 African American and the rest white wanted to ride in the car that was reserved only for whites in a train, and he was fined because that was in violation of a Louisiana state law. That went up to the United States Supreme Court, which said, no, that's fine. You can separate people based on race. And of course, the supposedly equal facilities were never equal. They were just separate. What I think is also very important is that during this period after Reconstruction, all the way up to the 1960s, and really in some ways beyond that, there was a campaign of terror waged against African Americans. There were various massacres, race riots, lynchings, white mobs, the Ku Klux Klan. I referenced one smallish city in the South, Birmingham, Alabama, where 4 little girls were blown up at church on a Sunday. There were 50 other bombings of African American homes, businesses, and churches, all sorts of violence throughout the United States, not really just confined to the South. There was violence like this even in California, even in Oregon, even in the Western states. And this is after those amendments were in the Constitution, guaranteeing racial equality, guaranteeing the right to vote. This is the very sad history of the United States during that period. You get then to Brown versus Board of Education, which didn't sort of come from nowhere. It was a long campaign of litigation by the National Association for the Advancement of Colored People that first was attacking various states for having unequal facilities, building up to this decision in Brown that said that separation of school children is inherently unequal, no matter what the facilities are like. And this was really a landmark decision in the United States. This was, after I think the Reconstruction Amendments, the most important event in United States history towards racial equality. It was followed very swiftly by other Supreme Court decisions. I haven't mentioned one of them here. For example, in 1965, the Supreme Court outlawed state laws that barred people of different races from marrying each other. That had continued all the way until after I was born. 5 years after I was born, in many states, it was still illegal for people of different races to marry. The Congress then also started acting in favor of civil rights with the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And in the United States, the period of the 1960s towards almost the end of the 1970s was really almost a golden age of the movement towards equality. What then happened was the Supreme Court started retreating, first in a decision called Regents of the University of California versus Bakke that said quotas in education are illegal, unconstitutional. Universities could still, under Bakke, take race into account, but they couldn't have quotas. But this was really the first step towards backsliding from the advances that had been made from Brown. You then get to the more recent decisions of the Supreme Court that have weakened and in some ways stripped the Voting Rights Act of its force, that have reduced protections for in employment, and that also very recently essentially eliminated affirmative action programs in education in a case against Harvard University that the Supreme Court heard a couple of years ago. So when the United States government has retreated, one of the strengths of our system is that we have individual states that have some measure of power themselves. And so to give you some examples, when in 1873, the Supreme Court of the United States held that Congress could not stop violent mobs from attacking African Americans or discriminating against them unless the state was involved in that action, New York passed a civil rights statute that guaranteed equal treatment to all people in various fields, in employment, in inns and theaters, in schools. And to give you an example, shortly after the law was passed, a privately owned skating rink denied a little girl who was African American the ticket to skate, and the state actually sued on her behalf, and she won. New York has a modern human rights law. It's been amended recently. New York City also has one. And between the city and state laws, we really feel we have the most progressive statutory human rights protection, not just for African Americans, but for discrimination of all sorts. It's very different from federal law. It's very much more protective. And so where we've seen the federal government has fallen down, New York State has stepped up statutorily. So skipping run to a little bit of statistics, and I won't take too long on these. I think these are fairly obvious. The problems that you have when you start with a slave-based society, one that has slavery baked into its constitution, and then required a civil war and lots of brutality to try and get as far as we've gotten, means we have not gotten as far as we had wanted to when we had the Declaration of Independence. So when you look at the poverty rates, you can see that people of color are less wealthy. When you see household net worth, zero and negative, only 8.6% of the white population has a zero or negative net worth, but for blacks, it's 23.6%. When you look at, I have to explain this for a second. The United States is a very carceral nation. We imprison lots of people. We imprison more than per capita, more than twice as many people as Brazil or South Africa, 5 times as many people as Portugal, 6 or 7 times as many people as France. We just put a lot of people into prison. And who are those people? Well, they are black people. When we look at people serving life sentences, they're black. When you look at people awaiting execution, they're black. When you look at people who are incarcerated in prison, they are black. And when you control for things like education, prior crimes, criminal history, and other factors, and you take people who are the same in those dimensions and then ask, what do their sentences look like? They are much more severe for people who are black than for people who are not. So in the face of that, what can we as New York done, and what are we doing and trying to do as a state to counteract this? Well, we have all sorts of access to justice initiatives. We have language access initiatives, access for disabled people. For people who are unrepresented by lawyers, we spend close to $150 million as a state in civil matters. In criminal matters, you're constitutionally entitled to a lawyer. That was one of the things the Supreme Court in the 1960s decided. Before that, you weren't. But in civil cases, you are not. But so in civil cases, so people's right to housing when they have a dispute with their landlord about conditions or they're being evicted, in consumer debt cases, in family law cases where they're not entitled to counsel as a matter of constitutional law, New York State is by far the leader in providing money for representing those people where they can't find lawyers. Even so, it's not enough money, so we have things like websites with forms on them. We have court-based help centers. We have virtual court centers that are located in churches and are located in museums and are located in libraries, or if you can't get to a court, you can still get to one of these places where there are people there who can help you navigate through the courts virtually. Lawyers provide pro bono volunteer services. There are lots of different ways that we are attempting to provide access to people who are underprivileged and not really able to afford lawyers and to access the justice system. We do other things as well. We go to, we have built and are building more of these community justice centers, which are much smaller. They try to treat low-level crimes not as crimes, but as problems people have. We also have a lot of courts that deal with addiction as addiction instead of criminal behavior, deal with mental illness as mental illness instead of criminal behavior. Even though it's a crime that brought the person to the court in the first place, we try to address the underlying problem, which is not criminality. It could be addiction, it could be mental health, it could be a family domestic violence problem, where counseling and support and medication and other resources are what the person really needs and not imprisonment. And of course, these are mostly people of color because it is poverty, it is the history of racial discrimination that creates these conditions that we need to address. We also have worked hard to promote diversity of the judiciary. Right now in New York State, about 1/3 of our judges are people of color, Black or brown people. We have programs on how to become a judge that we tailor to underserved communities. We have what we call a special master's program where lawyers can come and sit with a judge and do some of the things that a judge does with the guidance of the judge, and we try to then encourage those people to become judges. We train our judges. We train them in a variety of things, including diversity. We have commissions that focus on women in the courts. The Franklin Williams Commission focuses on people of color in the courts and people of color as lawyers who come to the courts. The FILA Commission is for LGBTQ advancement of people to avoid discrimination against them as well. And we also do things with the public. One of the things that we do that I wanted to show you is we train jurors when they come in for jury service. We show them a much longer video than I'm going to show you. I'm going to show you just a little clip of it about implicit bias, about even people who think that they are not biased have biases. And we try to explain to them what those are using scientific methods so that when they serve as jurors, we can at least have them confront that bias and think about whether they are biased. So let me show you this tiny little clip.
In this video, we are going to explain how the way our brains work can sometimes stop us from acting as fairly towards other people as we would like. Take a look at this image. How many triangles do you see? Usually people see anywhere from 1 to 13, but the answer is actually 0. The complete triangle has 3 sides, and none of these are complete. However, when you looked at the image, your brain filled in the gaps without you even realizing it. You automatically completed the triangle, seeing 1 or more triangles, even though no complete triangles are really there.
And that's what people's brains do with racial discrimination. Even when they don't think overtly they're discriminating, they're filling in gaps. They see a Black person and assume, oh, maybe this person is dangerous because in my experience in the media and other things I've seen. And so we try to get jurors educated on this so that they can confront those biases and so that we can have unbiased juries. But we also train people on implicit bias in other ways too. I was going to close with the following thing. What you do see, which is interesting, is that in our 20 largest cities, they've had mayors of color. So what you see is a shift in the population of the United States. And you see on the political side of things that things are changing. And in Queens, which is one of the 5 boroughs in New York, many people consider it the most diverse urban place on the planet. There are something more than 250 different languages and dialects spoken there. And that's part of New York City. The rest of New York City is also quite diverse, and that gives us a great strength in New York State. 60% of the population of the state is in New York City or around New York City. So we have a great diverse population to work with, as you do here. So sometimes I think that it's people who are not from the United States who can best see what we are and give us advice. And you Brazilians maybe, I think, can do that for us. But one of the people that I've always looked to is a Frenchman named Alexis de Tocqueville, who wrote a long treatise called Democracy in America. He visited in 1827, and this is one of his observations, that there are but 2 alternatives to the future. The Negroes and whites must either wholly part or wholly mingle. If it be allowed that it is impossible to foresee a time at which the whites and blacks will be so intermingled as to derive the same benefits from society, must it not be inferred that the blacks and whites will, sooner or later, come to open strife? Well, we've had that open strife in many iterations over the years, some in forms of riots and lynchings, some in the form of the Civil War, some in the form more recently of the Civil Rights Movement and peaceful demonstrations, not strife in the form of violence. And what you can see from the chart on the right is that this is one of two charts. I didn't give you the other one, but the United States is moving to a majority non-white population. It is still majority white, but inexorably it is moving to become a majority non-white population where there are also going to be many more people who are of mixed race. And one of the interesting things about the availability now of genetic testing for ancestry is many people who think that they're white go and get one of these tests and find out, you know what? They're not exactly all white. And this starts, I think, the process of opening people's minds about what race actually is and what racism actually is. And so I do think that we have, although we have a great deal of difficulty and we've had a great deal of struggle, we have a bright future. When I visited Chief Justice Benjamin's private chambers, he has three large posters there, one of Mahatma Gandhi, one of Nelson Mandela, and one of Dr. Martin Luther King. And I wanted to leave you with one of my favorite statements from Dr. King, which is that the moral arc of the universe bends towards justice. Two caveats to that. One is that it isn't quite as smooth as an arc. It's a little bit bumpier than that. You take some steps backward, more of them are forwards. But the more important caveat I wanted to add is that it doesn't bend on its own. It requires all of us to bend it. We in New York are trying to bend it, even though our national government is perhaps taking a step backwards. And we're looking to you and to Brazil and to the leadership of people like your Chief Justice to help us bend the arc for the rest of the world.
We'd like to thank Appellate Judge Juan for bringing to us the human rights guarantee policies for the Black people in the United States, especially in the state of New York. Thank you for this opportunity. I now pass the floor to Justice Stevan Arnold Majiedt. He is a justice in the Constitutional Court of Republic in South Africa. He previously was an appellate judge in the Supreme Appellate Court, where he worked ever since 2010, and in the Supreme Court, Septentrional Supreme Court of Kimberley in Western Cape. And you have 20 minutes, Justice.
Bom dia.
Good morning.
That's about the only Portuguese I know. I'm absolutely delighted and honored to be here for this very important first symposium. And also, of course, to see my old friend, Chief Justice Herman Benjamin again. And let me at the outset recognize my colleague from New York State, Judge Rowan Wilson, and all other colleagues in the room, and also our ambassador from South Africa. And the ambassador just left at this time when I wanted to say that he's here. Oh, here he is, Ambassador Vusi Mavimbela. Now, he was one of the people, I must tell you, that when South Africa grew tired of talking to the apartheid government, that was around 1960, when I was born. It was a tumultuous year for South Africa because then was when people got shot at Sharpeville, which is a black township in the north of our country in Johannesburg, Greater Johannesburg. Many people got shot that day because they had peacefully protested against the past laws. All black people were required to carry passes where to show that where they come from, and when they were in a white area after dark, without that, if they were without that pass, they were prosecuted, but they were not allowed to be in a white area after dark. People protested, and the police massacred many people that day at Sharpeville, most of them shot in the back. And that is when the liberation movements in South Africa decided to take up arms. And the armed struggle ensued, and the PAC, POCO, P-O-Q-O, started the Liberation War, and soon thereafter, not POCO, APLA, and soon thereafter, the ANC's armed wing, Mkhonto weSizwe, started the armed war. And of course, that was led in the absence of President Nelson Mandela, who was incarcerated at that time. And Ambassador Vusi Vamimbela was one of the combatants of Mkhonto weSizwe. It means in English, spear of the nation. And he was one of the soldiers who fought the war for us. And he got trained in many countries in the East, in Cuba, and elsewhere. And I wanted to recognize him because it's through people like him that we were liberated, that we got our freedom. Thank you, Ambassador. This is an important symposium. Race is a very difficult topic, particularly when you have to speak about it from a privileged perspective. What do I mean by that? Last night I was so impressed by all the presentations we had. Cardinal Turkson explained to us in very frank and brutally honest terms how the Vatican and the Catholic Church in general had shied away from a discussion on slavery and enslavement of people for many, many years. People were prohibited from discussing it. And that is a frank assessment that we need. But more importantly, when you speak from a privileged position like my friend Herman Benjamin spoke, and Chief Justice Barroso last night, they admitted frankly that they are the beneficiaries of racism in Brazil. And that is an important assessment and concession to make. And once you've said that, then you then move to the next step to say, but it's very important that we eliminate the scourge. And last night, many people quoted Nelson Mandela, who is truly the father of our nation. And when that lovely singer of yours last night, Shiko Cesar, spoke about how he sang in Cape Town, which is a southern city in our country, for those who don't know South Africa that well, spoke about how people got emotional when he sang that Mandela song. And they said, Madiba, Madiba, that is his clan name. It's a name that, his pet name for us. He's truly the father of the nation, and I got a lump in my throat. And so let me quote Madiba, Nelson Mandela, when he said about racism, we must eliminate the scourge of racism once and for all. Now, this is an important topic, and I'd like to commend and congratulate the STJ and Chief Justice Benjamin and all the partners in arranging the symposium, because it's important that we must speak about it. And I'm afraid to say, I regret to say that my country, coming from a terrible, terrible history of colonialism and apartheid, have not begun speaking about the scourge of racism, and we need to do so soon. So this is an important topic that all of us must grapple with. And I'd like them to put up the first slide, please. Could you put up the first slide for me, the separate one? It's there. There we go. I want to explain to you how apartheid. Now remember the colonialists, the Portuguese came to South Africa. Along the coast, the east coast. They had a look in the 1400s. They walked around there, and there are some remnants of them in the east coast towns there. And they weren't much interested, and they carried on, and I think they found Brazil much more interesting than South Africa in the area, and that's how you got colonized. But the Dutch came in the 1600s, and they colonized us. And so for many centuries, black people have been oppressed. But then apartheid came in 1948, and it institutionalized racism it made a law of it all. And this is how we were classified. So I want you to understand when I speak about these terms later on in the presentation that you understand where I am. So we had black people that apartheid divided us into compartments. White people right up at the top, and they were the dominant group during apartheid that benefited from systemic privileges, and they were way above the rest of us. And then we had generically black people underneath. But apartheid masters were sly. They divided black people even further. And they had the policy, they never enunciated it, but they had a policy of divide and conquer. So they divided us as blacks into these groups. Colored people, and I put it in inverted commas because I don't like to be called colored because that's what the racists decided I should be. God made me a human being. If you must classify me, then I'm not white, then I'm black. But colored people were mixed race people. So people like myself would be colored. Let's call them brown people. And they were positioned between white and black. They also face social and economic discrimination, but not as severely as African people who are come to last. So we were below, and we were more or less on the same rung as Indian people. Now, Indian people were, like my forebears, brown people as well, some brown people, come from the island of Indonesia, the island of Java that was part of Indonesia. And they were most of the brown people that came to the Cape. And of course, the indigenous people of South Africa, the first people were my forebears, were the Khoisan. It's one of the, if you Google Khoisan, it's one of the most ancient civilizations known to human history. And so those are my forebears, Khoisan people, Malay people, we were brown people, classified colored. And we had more or less the same rights as Indian people who were brought in from India to the East Coast, to Durban, to the KwaZulu-Natal province on the East Coast, for laborers in the sugarcane industry, sugarcane farming, which is well known to you in Brazil. And so Indians and brown people were more or less on the same rung, way below whites. And then right at the bottom below, brown people and Indian people were African people. Those would be Ambassador Mavimbela's ancestors and others. They were the most marginalized group. They were excluded from urban development, education, and political rights, and they were severely oppressed. So the oppressor was clever. You oppress the one far more than the others, and so that they build resentment amongst themselves. Divide and rule. And we had to overcome this, and we had to establish policies and laws. And could you bring up the next slide, please? This is how we did it. We have a constitution. In 1993 was the interim constitution. The final constitution is a 1996 constitution. It's the supreme law. And people say, when I travel all over the world, people say it's one of the most progressive constitutions in the world. And some of our people say it's too progressive for a developing, emerging economy in Africa. Be that as it may, then you have national acts. They bind the whole of the country, but they must be subject to the Constitution. So you can't have laws that are contrary to the Constitution. They are declared invalid. Then we have provincial acts. Unlike you, we have states, and the United States have states. We have provinces with a high degree of autonomy. But those acts in turn cannot conflict with national acts or the Constitution. And then finally, at local government level, we have municipal bylaws. Could you bring up the next slide, please? And this is how our courts look. I'm in the Constitutional Court, which is our apex court, is the highest court, is as constitutional and general jurisdiction. And then you have a Supreme Court of Appeal, the second highest court. So the Supreme Court isn't supreme. And the Constitutional Court isn't a court that only does constitutional cases. That's the unique history of South Africa, because the Constitutional Court originally was established as a new court with new judges, because we kept the judges under apartheid. We said we will not dismiss any of those judges. Of course, they had to swear a new oath to uphold the new constitution. Many of them, not many, some of them didn't take that oath seriously, but that's a topic for another day. But we established a special new court. Mr. Mandela was the one who constituted that new court through a democratic process, and that was our first constitutional court that dealt only with constitutional matters, and later the jurisdiction was expanded in 2013. Under the appeal court, you have the high courts. They sit in the provinces. We have nine provinces, so every court has a high court, and then you have the magistrates court at local level, at municipal level. And when a law is declared to be in conflict with the constitution, any one of the high courts or the appeal court could declare a law unconstitutional, but it must be confirmed by the constitutional court. And only the constitutional court can declare conduct of the president as unconstitutional. And so that is our structure. And then the last slide. That is our equality clause in section 9 of the Constitution. By the way, I should have told you right in the beginning this. You see the symbol of the tree there, and you can see people standing underneath it. That's the symbol for the Constitutional Court. It symbolizes the African tree that shades and covers all people. And that is the symbol of the Constitutional Court. Section 9 is a longer section, but I've only cited these two. Everyone is equal before the law and has the right to equal protection and benefit of the law. And equality includes the full and equal enjoyment of all rights and freedoms. And to promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by an unfair discrimination may be taken. And we have that policies. We have affirmative action as the main policy, and also Black economic empowerment, of which I'll say a bit later shortly. Let me just say generally that we also have in the employment sphere that I'll speak to just a little bit about later, we have the Employment Equity Act. And that Equity Act is designed to achieve racial equity in the workplace. Now, could you put up the composite slide, please, the one with all four? I'm going to keep this on as a background there, and I hope you can see it, just for you to follow as I give this presentation. We are a very difficult society. We are diverse, but the World Bank, is one of its most recent reports, I think 2 or 3 years ago, did an analysis, an economic analysis, and the World Bank says that South Africa is the most unequal society in the world. The gap between rich and poor is the biggest in South Africa than anywhere else in the world. Now that's a worrying feature. South Africa is a very rich country. For a long time, we had the most gold reserves in the world. We had so many diamonds underground, and that's the area where we used to live for a long time in the area. The province, the state that I come from, where I was born, Kimberley, that you have in diamond dealing now, you have what they call the Kimberley process. It comes from the name of that town. And so we had the most diamonds for a long time. Presently, we have the most iron ore and manganese in the world. And so it's a very rich country. And yet our people are desperately, desperately poor. And so what went wrong? We had all these wonderful policies, but policies and laws are only as good as the people who have to make them work. And so what has happened is that we had a wonderful president under President Nelson Mandela. When the country was on the brink of civil war, in the run-up to the 1994 elections, we had Mr. Mandela, who was able to calm things down so that we could have our first democratic elections. And we had a very strong government. He only stayed for one term, unfortunately. In Africa, we have struggled to get people to go out of office. We struggled to get him to stay in office. But he only did one five-year term, and then came President Mbeki, and things went fairly well under him. And then we had the disaster under the former President Zuma, where things have gone very, very wrong in South Africa. And so let me turn to Black economic empowerment. It is legislated in the legislation, and it is also a general policy that says that when you procure goods as the state, you must give preference to Black suppliers. When you do mergers and acquisitions and sale of shares as a corporate, as a private company, you must reserve 26% of your company for Black firms. So that was meant with good intentions, but it went horribly wrong because a few political elites have hijacked the whole thing. And so you get super rich, a very few super rich Black industrialists and business people today, but the majority of our people live in abject poverty. Affirmative action has different problems. Affirmative action has meant that in the courts, we have affirmed not only Black people, but also women, because women were terribly oppressed under colonialism and apartheid, even strangely white women, and physically challenged people. But primarily the focus is on affirmative action for Black people. When I say Black, I mean all Black people, African, colored, and Indian. But there's resistance to affirmative action. People say it's reverse discrimination. And this is the point that I made earlier, that I admire the two Chief Justices who spoke last night and was able frankly to say, I concede that I'm a beneficiary of this vicious system that doesn't recognize the equality of people. But we must do something to set it right. In South Africa, there is resistance to it. Now, it's not open resistance. There's subliminal racism, and there's resistance to change. I always draw the analogy. I mean, football is the thing that I think the people in Brazil understand the best. And we are far inferior to you than football in South Africa. But let me draw this analogy. When you have two sides playing against each other with a gradient of a field that slopes, let's say 10 to 15 degrees, it's a significant slope. And the one team has to play uphill for 45 minutes plus extra time. And then you say, well, this is not right. It's halftime. Let's set matters right. First, you can't say now you play on a level playing field. That's not setting matters right. You've got to let the other team play for 45 minutes plus extra time on the same slope. Now, what has happened in South Africa, we have changed the slope after 1994 under constitutional democracy. But now the team who has been playing downhill for the first 45 minutes plus extra time say, oh, no, you can't have that much time. You've had 10 minutes, it's enough. Let's stop this, let's get the slope level again. They want us to stop affirmative action and equity in the workplace and all other spheres after this year our democracy is 30 years old, after 30 years. And the argument is that apartheid started in 1948. Well, that is a blatant lie. It started when the colonialists came to South Africa in 1652 and started oppressing us immediately. One of our Nobel laureates, Archbishop Desmond Tutu, a wonderful man, says this in his jokingly way. He's a very, very funny man. He says, when the white man came to Africa, we had the land and they had the Bible. It's a pity Cardinal Turkson isn't here. Because when the white man came to Africa, we had the land and the white man had the Bible. And when the next day when we woke up, a few years later, they have the land and we have the Bible. And so we have a long way to go in South Africa to address these challenges. We have the Employment Equity Act and other legislation to overcome the obstacles of the past and the inequities and inequalities of the past. And I've mentioned the Employment Equity Act. The Employment Equity Act requires employers to have equity plans in place to show how they're going to apply affirmative action, but it must be applied in a reasonable constitutional way. Now, many commentators say that the Employment Equity Act is deficient. Now, that's something for the legislature to sort out. All I can say is that all our courts, especially the specialist employment courts, the labor courts, and we as the highest courts, have consistently enforced the affirmative action and the equality action provisions in the Constitution. So much so that the politicians in South Africa say that the judges want to govern, especially judges of our court, because we wield enormous powers. People find it quite strange that we as a court could sentence a former president to prison, President Zuma, for contempt of court. He didn't stay long, but that wasn't our fault. It's a court with enormous powers. We wield those powers without fear or favor or prejudice as the Constitution demands, but we do it circumspectly because we understand that, contrary to what politicians allege, judges can't rule. We are unelected. We have no mandate from the electorate. But we swear an oath to uphold the Constitution, and we do it without fail, also for employment equity and in all other spheres of the workplace. There are many cases that I can cite about employment equity, about affirmative action, and so forth. And another aspect that I would like to, as I draw to a close, to mention is that we have strong hate speech provisions, and we have a South African Human Rights Commission that enforces the human rights clauses in the Bill of Rights in our Constitution. And our hate speech legislation is quite drastic, it's quite far advanced. And hate speech will always be with us for as long as there's resistance to this change that we must have. And so let me conclude. One of the things that apartheid did was to lead people into the mistaken belief that if you have less pigmentation cells in your body than others, you are superior. You are superior in sport, you are superior in law, you are superior in medicine and everything else. And last night, the Cardinal said something that really stuck with me. He says, if you're a Christian, as I am, and you believe in the Bible, in the story in Genesis, then all of us come from one womb. So how could we be different as far as intellect, rights, dignity, and so on are concerned? And it comes as no surprise, ladies and gentlemen, that South Africa's Constitution has as its founding values, right up in the preamble, dignity and equality, because of where we come from. And so our history is much the same like yours and that of the USA. And I think this is a very important first step on a journey to, as Mr. Mandela says, eradicate the scourge. You know, there's a saying that all of us know that the journey of 1,000 miles starts with the first step. But it's like getting up in the morning or going on a diet to try to lose weight like I do all the time, or start exercising. It's just to start doing that first thing. And so, as I conclude, I want to say that yesterday, we were very privileged, Judge Wilson and I, and also Professor Ines, who's not here at the moment. We were invited guests of Chief Justice Benjamin when we inaugurated the STJ Park. And we planted a number of trees there. And as we all know, trees give life because it gives oxygen. And let this first symposium be that first breath of oxygen that will sustain us on this journey towards eradicating this scourge of racism. It's an important step. It's a very, very important step. And as I started, I'd like to end off with a quote from Mr. Mandela, but I'm going to try hard, and I'm going to try and quote one of your favorite Brazilian sayings. And please excuse the Portuguese. Água mole, em pedra dura tanto bate até que fura. Mr. Mandela, I said I'll end with him, and Mr. Mandela said, famously, quote, "It always seems impossible until it is done," close quote. Let us keep walking. We've given the first step. Let us keep walking resolutely, diligently, and with that hope that just as Judge Benedito Gonçalves mentioned yesterday, it's not a fear of racism. It's a hope that we will overcome it, because that is the choice we've deliberately made when we started this symposium. Thank you very much, Chief Justice.
Quero agradecer a participação do ministro.
I would like to thank Minister Stevan for his participation in this important panel, and say that Your Excellency has allowed us to get to know the fight and the whole process of those people to secure equality formal equality, but not between Africans in the citizen letter of that country, but also implementing through affirmative actions. Thank you very much. I would like to pass the floor to Judge Adriana Cruz, that I would have to say she doesn't need to be introduced because we all know her huge curriculum, but just not to break protocol, in a very shortly say that she's a federal judge of the Second Region and General Secretary of the National Council of Justice, CNJ. She's part of the Executive Committee of the Human Rights Observatory of the Judiciary branch. In his actions in human rights, she received in 2021 the second Majiedt Prize for Human Rights. She was one of the creators of the Judges and Black Judges meeting. So, Dr. Adriana, the floor is yours for 20 minutes.
Só vou marcar o tempo aqui para não me desorganizar. Bom dia a todas as pessoas que nos acompanham. Gostaria de saudar a desembargadora Ângela, ministro Herman, tão querido, tão amado, e saudar também os nossos visitantes. É uma honra estar com os senhores aqui à mesa. Eu vou, como o ministro pontuou, hoje eu estou como secretária-geral do Conselho Nacional de Justiça, e a nossa função, na verdade, é auxiliar o ministro Barroso. E como seguindo o meu chefe, né, eu também dividi a minha fala em 3 pontos. Eu começo a minha fala, eu vou organizar a minha fala pontuando com os senhores raízes, persistências e a forma de enfrentamento.
I'm going to talk to you about persistent racism in Brazil, focusing in the justice system and the legal order, so that we can understand this trajectory that we have been undertaking or on. So I'd like to start with 3 points that are very marked points, some numbers, the theoretical framework from which I'm going to talk, and a legal affirmation. I would like you to think in the numbers that for many here is more than well known, but how much that has made us immune and insensitive to the scandals we have lived on a daily basis in Brazil. These data that I present are related to 2021, but they could very well be from 2020, 23. Certainly, they will unfortunately be also the data of 25. In 21, I here have the violence, the acts of violence that brought us this 36,000 registered homicides officially registered for Black people in Brazil. 77% of the homicides in Brazil are of Black people. This number is a number that comes from a historical series that unfortunately unaltered.
In its majority, Black young people between 19 and 29. So we have killed off our youth, and the Amnesty International has a campaign, keep the young youth alive, because our youth is being literally decimated. Every 100,000 inhabitants in Brazil, 31 homicides are of Black people in comparison to 10.8 of non-Black people. We have a lethal death risk that has increased between 2010 and 2021 of 2.9%. The chance that a Black person has to die for murder. This risk in the state of Alagoas is 36.6 larger, and data related to Black women is also scandalous. We don't see in the policies to tackle several violences against women that have been disseminated as creating concrete impacts for Black women. So domestic violence policies, even though they should be celebrated, they are not reaching this universe of the population. Black women still die more. They still are more assaulted. They die more in labor. They receive less anesthesia during labor. They still don't have prenatal care, and it's enough to say that the first decision contrary to Brazil in the committee that follows the Convention Against Discrimination Against Women was the cause of at the time when a Black mother died, and she checked all boxes: young, Black, poor, and living in a vulnerable community. Her name was Aline Pimentel. And where does that come from? How is it structured, and how is the law and the judicial system in Brazil embraces this reality? Because if it still happens without any change throughout time, we have a justice system that has been ineffective in dealing with this reality, not because the justice system can prevent these practices in and of itself, but because it signals to those who practice the type of crime that they have a license to kill because they will not be punished. They have a license to discriminate because they will not be held accountable. This is the role that we have, and that Justice Herman Benjamin has been advocating for in this court, which is known as the Court of Citizenship. So the seminar happening in this space, in this house, as the first formal event in the Herman Benjamin administration, I think this signals this breath of fresh air that this administration brings, a hopeful outlook, so that we can begin a different trajectory. We have built many things, but we still need to institutionally and as a group, and not through specific situations as we have done, because we're few and we don't have enough manpower, so we act where we can. So we need to have a more convincing institutional response. As we sit here, this week a man was thrown from a bridge by a police authority. The country should have stopped. But in the last few days, I have been involved in a big event. I didn't follow the media, and when I was surprised yesterday by this news, and life is carrying on normally, and people are discussing, saying this topic is very complex. It's not complex at all. When a police authority, an agent of the state, considers it acceptable, and someone considers it to be acceptable that this person would not be punished, when they took a man, overpowered that man with force, and threw that man from a bridge. Brazil should have stopped, but we're still carrying on. Well, these are our numbers, and this is where we're at. The theoretical framework based on in my reflections here is that of Sueli Carneiro, a philosopher and political activist. And in her dissertation, in her academic papers, she reflects about the raciality device. She mentions Foucault, and she even questions that choice, saying that it is the possible and reasonable dialogue at the frontier. And based on Foucault, she tells us, quote, the existence of a raciality device operated in Brazilian society in such a way that through the articulation of multiple elements configures raciality as a domain that produces powers, knowledge, and subjectivities through the denial and interdiction of powers, knowledge, and ancestrality. This paragraph sums up everything. It sums up why man was thrown from a bridge, why we have the number that we have for the participation of Black people in the justice system as active actors, be it lawyers, judges, or anywhere in the magistrature, and explains the systematic denial of rights in theory and in practice by the Brazilian justice system. Yesterday, Professor Inai really facilitated my job here. I'm not a historian, but the fact is, our abolitionist process happened as it did, as a concession policy. The formal abolition of enslavement came when there was no political environment to uphold slavery, but there was no concrete understanding that the people who had been enslaved and had been kidnapped, children and adolescents that were kidnapped from Africa to come to the Americas, there was not understanding that they were people, or that the indigenous people who are here should not be enslaved and decimated as they were. The abolition and slavery process and of supposedly formal equity didn't happen through an awareness raising process, but because of the political context, internal pressure, and international contexts, and that was it. And starting with that, our entire legislation, and here I look at the roots of our legal system, it is structured based on this logic of reproducing and upholding that pre-abolition status quo in a segregation logic, much like in the US. And here our realities are pretty similar. The legal system provided for some devices to guarantee the status quo to be sustained. We lived under the phantom of the Haitian Revolution that guided the political choices of our legislator. It's enough to say that when there was the proclamation of the Republic, the criminal code was amended before the Republican Constitution. So we need to deal with that contingent of people. We need to contain that group of people. And that is how the justice system was created. That is our DNA. These are our roots. An abolition that was declared just because it had to be. There was no longer a possibility of formally maintaining that reality. And the creation of many provisions related both to the criminal system and the provision of civil rights, so as to maintain that population in the place where they were, and to maintain the segregation and to maintain that social reality unaltered. That is our DNA, and that is our original sin, so to speak. We have here a series of elements that can illustrate that reality, and just to mention a few, the entire criminalization process of the African-based religions, the demonization and the lexicon of the dominant religion to criminalize African-based religions. It was only 2 or 3 years ago, Professor Thula will probably mention, that we were able to recover the sacred objects that were still maintained as seized goods in criminal processes in Rio de Janeiro. So these objects were only returned to the African community through an intense mobilization of the people who practice that faith, especially in Rio de Janeiro. And currently, these objects are in the Museum of the Republic in Rio de Janeiro. But very few years ago, they were still seized as criminal evidence. So that is how our system is constituted. The Black person was considered as an object, and they couldn't make choices within the enslavement system, but they were also amenable to being held criminally accountable. So we had the possibility of choosing and acting differently, and that's why we could be held accountable for crimes committed against white people, but we didn't have that same free will to make decisions on our lives and to pursue our happiness. So the justice system and the law in Brazil filters the Black person. They enter the legal system as a person through the criminal system. But they don't have access to property and to the possibility of changing the state of things where they come from, which is slavery, through a legislation that comes right after abolition, the land law. And here we have Professor Wallace Cole, that is someone very appropriate to talk about indirect discrimination. Because when we establish the forms of access to property, even though it doesn't say explicitly that Black people can have access to land, it is structured in a way that prohibits Black people from having access to land. And our Chief Justice mentioned the affirmative action, and the very land law comes as a very potent affirmative action based on public resources. And here, the very literal Article 18 says that government is authorized to sending a certain number of free colonizers to establish agricultural properties or to work in public administration or in the creation of colonies in the places where they are most convenient. Making the necessary measures so that these people can find employment as soon as they arrive in Brazil. So we have a state policy that with public resources, where we exported colonizers from Europe. So there was a law at the time saying that everyone who comes from Europe will contribute to the prosperity of the Brazilian nation. So public resources brought people from Europe to make the population wider, like Professor Lina certainly mentioned today. And it was prospected that in 2011 we would have a completely wide population. And all of these issues that also Professor Inai listed. And this is our legal DNA.
Curiosamente, nós vamos ter o desafio de hoje,
we have the challenge today, and here I move on to step 2, talking about the persistence, to unveil in our practices and in our action in reason to this provision that vetoes access to rights. We have the challenge, the current challenge, to unveil how these practices that were explicitly structured way back then still remain today. So we need to have our eyes wide open and see the situation. And here I mentioned a doctoral thesis by Guilherme Ramos, and he does a study about the satellite cities in Brasilia, and he draws a parallel with the satellite cities, and he looks at the townships in South Africa, and he tells us his perspective is a perspective of the urbanism field, but it is very much related to rights because it's right to land, it's right to education, it's the possibility of not spending half of your day in public transportation to be able to work and study and live. It's the stealing of people's time. So looking at urbanism is looking at that distribution and the form in which relationships are established. So he looks at the 50s, the 70s, how Brasilia was structured, the center of power where we're at today, to maintain Black people in the places where they supposedly should be. And here, emphasis on the supposedly. And we look at these same practices and that same dynamics in other Brazilian cities, like my city, Rio de Janeiro. Anywhere you look, the communities, the favelas are a reproduction of that reality. So I suggest the reading of his work that brings us that rapprochement and tells us how the colonial practices are established and renewed in all spaces where colonialism has been established. So I was saying that our current challenge is identifying that persistence and how it once again is established through the criminal justice system, through access to land and access to education. And when it comes to the criminal justice system, we have a very evident case of the Brazilian prison system, which in its majority is composed of Black people. And we usually say that the huge difference between Brazil, the US, and South Africa in terms of segregation and racial relationships happens because of the absence of explicit segregation in Brazil, which is actually not true if you look at the reality. It is evident that our system is explicitly segregatory, and it is this provision that also mimics racism and these practices that causes us to have this double effort to state the obvious, which is the Brazilian indigenous and Black population is submitted to a differentiated process in treatment by the state and exposed to discriminatory processes that are extremely violent, and our effort of shedding light on that. So we have a criminal justice system that is majority, that is Black in its majority, but there are states where 90% of the population is, there are cases where 90% of the prison population is Black and is arrested for drug trafficking. So imprisonment also has its roots here, a much more efficient system because we don't even have a third strike system. It's a first strike system. The first time the person is in prison, they enter the system and they will never leave. That scarlet ladder follows them throughout their life. So our system is much more efficient because it doesn't need to say explicitly third strike, you're out, because it's first strike, you're out. So our criminal justice system and most of our processes, and here Justice Herman talked about the challenge of habeas corpus. In Brazil, I am a criminal judge in Rio de Janeiro, and most of the processes are based on people being caught red-handed. So we have experts like Professor Zaffaroni that say that these crimes that cause imprisonment are usually small crimes So the practices of preemptive imprisonment, of cautionary imprisonment, and all processes and devices and resistance to custody hearings, all of these are persistences. And that system, the pre-abolition system, is still present today. And in the access to land system, the land conflicts, I think we don't need to talk about them in depth, but I'm just going to make reference to our foreign guests to say that land conflicts currently impact the Black population in an increased manner, and also Quilombola and indigenous populations, and the climate violences that impact these people who live from the land and who are the ones that also protect it. So there is a double violence here because you have processes of climate violence, and I say here because these are intentional acts that have led us to these disasters that are not accidents, that impact this population in a differentiated manner. And on the other hand, we have the attack to these communities, which are also the protectors of these territories, the watersheds, and the entire vegetation that may avoid the climate disasters that are created by those who attack it.
So we have a double violation there because of racist practices that we see now in the environmental racism and access to education as well. So these practices, if they were forbidden to have the presence of Black people in schools, some legislations immediately pre the abolition prohibiting free Black people, leprous people, etc. That is the line, the similarity that the legislation was establishing. We now have, despite all the effort of the Supreme Court to have affirmed for twice already the constitutionality of the affirmative actions in the Act of 41, we still have allegation of reverse racism. We saw part of the Brazilian middle class that is rising up against affirmative actions in the processes of residence selection, alleging inverse racism or reverse racism. And here we also get close in some measure, although our institutions are still maintaining this policy, but it's necessary that we always be careful with the American reality. I want to underline the decision that Mr. Wilson brought to us about the change of the Supreme Court understanding on affirmative actions, recognizing its impossibility with the constitutional rights in the case where there was called the Students for Fair Admission for the selective process that are fair. So the irony or where we're using the key of or equality, isonomy of equity to keep privilege, to use that to actually keep privileges. So I think this is our challenge as a justice system to face these and reaching the end, how to face this. So today we have, beyond this action of our constitutional court, of this court itself, in judging on criminal issues, recognizing people that changed the understanding how person recognition should be done, just for those that are from the criminal part, from the penal code, established a procedure that for many years was established as a procedure that should be used only as a suggestion, as a guideline. That was the understanding. If the magistrate would not use that procedure for the code to recognize people, that would not necessarily make the process void. And with what Minister Schietti said, Rogério Schietti, alters this, establishing the obligation and the obligation of this, where a whole recognition of people is done with several rulings and prisons of innocent people that start appearing and being reverted. So from this leading case, if we could so call it, the National Council of Justice instituted a working group that produced a report and a resolution from the National Council on the recognition of people with the objective of avoiding these false identifications that are marked by the biases that Justice Wilson mentioned, and that will alert the magistrate and try and minimize the possibility of unfair sentencings, reminding, of course, that it's not directed just for Black people, but they are usually the ones that are in that position. And just getting to the end here, I just wanted to underline to you and bring a very clear example of this issue on recognizing people, because I think it's very a very good portrayal of how the system works. I'm here with Dr. Carding, my dear colleague, Sonia. She's not here today, but all probably know Minister Edilene. And when I got here last year in July, Minister Rosa asked me to work on the transition. And then in September, I actually took on as the General Secretary of the Council. I like to joke that the multiverse was installed itself in Brasilia because, why? Because people think that I, Dr. Karen, Alcione, and Minister Edilene, they think that we are the same person. So they always would confuse me with Karen and say, oh, I was at a table with you yesterday. I was at a panel with you yesterday, and I already knew, no, it wasn't with me, it was with Karen. No, it wasn't with me, it was with Alcione. So the person spent hours with that other person, and she meets with me and see in front of me. And we'll see, she's here, you'll see that the only thing that we look like really is the skin color. It's not even the same tone, but we have a voice and way of dressing and everything completely different. She's calm, and I'm very fast, but they still think we're the same person. And people are calling me minister. Why are people calling me minister? Hi, minister, or justice. Hi, justice. Oh, and I think, oh no, they're confusing me with Justice Edilene. I'm here with Justice Mauro Campo, and they said justice, and I said people's minds are exploding because we're occupying the same place. So people cannot identify magistrates that live with them on a daily basis. And they do not want to observe a procedure that is foreseen in the Penal Process Code. That is a law that must be observed in an obligatory manner. So with the authority of the Inter-American Court, we signed the Inter-American Convention of Human Rights, the San Jose da Costa Rica Pact, the Inter-American Convention Against Racial Discrimination. It was ratified. It's a law that must be observed by the Brazilian magistrates. And it starts saying that the member states affirm themselves aware that racism uses and advances and alters its practices to remain present and active. The Brazilian state said that it is aware of that reality. It is aware of these racism procedures that is so well pointed by philosopher Sueli Carneiro. We have a long way to go. I'll just request that they please put here, we have a pact for racial equity here in the judiciary. 100% of the courts took on the commitment to take on anti-racist actions, and this pact is divided in a few axes, and with them it's the data. I bring here a racial monitoring panel that was launched a few weeks ago, and we can now monitor the number of people, of Black magistrates, Black civil servants, we have access to defendants that are in procedures. It is enough that we put on the panel monitoring racial justice. We can show, please use this data, produce research with these numbers. you can identify as well where you have the criminal proceedings per court, per house, in all the courts, as long as they are properly tagged in this sense. And for that, it's important that not just magistrates and civil servants do this, but also those who are in litigation in the judiciary that identify them as such. Because we cannot have the data if this data is not presented by those who come to the courts, be they lawyers, public ministry, public defense. And so we have this racial justice monitoring panel. And I bring this because it was very important. It was the census of the judiciary of 23 that showed the very small presence of Black people in judiciary. That was the turning point of racial equity policies that which we were observing pragmatically became noticeable in numbers, visible in numbers, so that we can work on the policies in an effective manner. From there onwards, the Black magistrates got together. I'll put it that was one of the creators. No, I wasn't. I was an intense collaborator and active, but it was created by colleagues, Civis, Reginaldo, César. I was there in the beginning, but we presented to the National Justice Council a letter requesting all this that we now see reality. So this journey that the Chief Justice put us upon, we have been on it. And we have been doing what we can with the arms that we have. So we are very few, but we will be more. I am the first Secretary General, but I will not be the last one. We are the first in many things, and certainly will not be the last. And for that is what we're working for. And just to finish, just last week in the National Justice Council adopted the protocol with racial perspective. That was the result of a working group with many professors, judges, members of the public ministry, prosecutors, and also, so we have the QR code there, and it is divided. It has a conceptual part. It has a step-by-step guide for magistrates, exactly so that we can remove these biases that affect our judgment. We're going to very soon produce its version in English and Spanish, or we will share it with our colleagues worldwide so that they can use it in however way they find it pertinent or useful. And it also raises some points per different sectors of the judiciary. Of course, it's not complete. It was today approved by the resolution by unanimity by the Justice Council. This was something that was unthinkable 10 years ago, to be very conservative. So we've advanced, but as Lucia Javier de Criolla, that is always ready to bring us back to reality, says, congratulations, come on, let's celebrate, but this is, now is when the work starts. So let's not concentrate on the racist act itself, because that distracts us, but let's work towards removing it, be it in magistrates and activism in civil society, be in academia. Do your homework. We're trying to do ours. We are here, far from perfection, far from something that is even minimally at the level at what the Brazilian society deserves in this state of barbarianism that we live in. But let's do what is right. And I apologize because I know I went way over my time, but I would like to end citing the Archbishop in our Quilombola leadership. He said, those who have never been at crossroads do not know how to choose paths. And we are at a crossroads in a country that discriminates, that treats badly, that kills Black and indigenous people, and we are in a justice system facing this reality. I cannot believe a bigger crossroads for those who have chosen to dedicate their lives to the judiciary and the legal rights, Professor Conor West said that justice as a love presents itself in the public sphere so let's know to get up from the table when justice is no longer being served. Thank you.
Queremos também agradecer com incontida
So we'd
alegria
also like to thank
sua participação, nos
for your
trazendo
participation,
a realidade
bring us the reality, raw reality of Brazil in regards to Black people in Brazil. Now, when I say Black, I mean Black and mixed. From a formal point of view, now we must advance far more from a material point of view, and I don't see other alternative if we do not have this point of view of the teaching, the integrants, the participants of the legal branch, of the judicial branch, public safety, magistrates, defense, advocacy, so that we can change or reduce these inequalities. So I would like to thank once more the participation of our speakers of the US, as well as those from South Africa, and to finish saying, paraphrasing Martin Luther King, yes, we can. Do not give up of your people, of your beliefs. Thank you very much. I'd also like to thank Supreme Justice here. I would like to thank Appellate Judge Salazar and the speakers. We had an opening of the day that was completely extraordinary. So many lessons and thoughts put forth here by people who actually know in depth this subject. I forgot to mention in the opening yesterday that we're going to publish a book in Portuguese and English with the work during this event, because of course it's important to have the event, but to maintain this and have this in writing, that is important. And concluding, what I take from this wonderful panel is firstly that inequality, racial inequality in our country faces a first challenge. It's lots of them, but there's a first one, which is of recognizing that we have racial inequality. Or those who still think that we are a country with great diversity and that we live in a sort of Shangri-La of paradise. There is no paradise for the poor, for the vulnerable, and those excluded. Shangri-La or paradise is for that small minority of which I am part of and my family throughout history. The second challenge that we have is to avoid the underestimation of the inequality, because there are a big number of Brazilians that recognize racial inequality but say, look, this is just another problem, because we have many others: poverty, hunger, lack of education, of health. We have to fight this kind of understanding that is erroneous. It is not just an additional problem. It's an existential issue to and for all of us. All the other issues, however big they may be, come after this existential problem. Another aspect that I think we can take from this rich panel we've had is that racial inequality And I'm going beyond this, isn't just an existential problem. We're dealing with a beast, with a monster, which is a difficult word, but sometimes we must use difficult words even in law to characterize that which we are facing. And it is a beast with many faces. And it's already difficult for us, especially the vulnerable, to deal with beasts. But when the beast is multifaceted, the policies, including the legal ones, are even more difficult, because at one point he shows one face that then turns into another face, and it's a permanent fight that works in order to destabilize those who are trying to face this beast. But it is important to recognize the monstrosity of racial inequality. It's a monster, a beast, first because it is inequality, and it is a beast in second place because it's the form in the separation due to skin color. So it's a beast squared. And all of this translates to us, and then the need for the system that we propose in some vectors. Firstly, that racial inequality operates by separation, by discrimination. That is, by the destruction of the humanity, because it is the only one. So we are going to fragment and break. And so, in this case, fragmentation of Black people because of skin color.
The second vector, which also needs to be tackled, as was said here, is that this system or anti-system works through oppression, because there are domination systems that work through convincing, but here it is through oppression, and it is by using the state as a form of oppressor, a state that belongs to everyone. Therefore, it is the usurping of the state by those who discriminate and benefit from racial inequality, and an appropriation of the state, which belongs to everybody. But in this appropriation of the state through violence, we're also sending a coded message that individuals can do the same. They can use the same type of violence, and so ensue lynchings, some which happen in public squares in Brazil. No one here brought the numbers of lynchings that happen in Brazil. And it is important that in the next seminar, someone talks about the public lynchings that happen all over Brazil, in São Paulo, in Rio de Janeiro. And the victims of lynching are usually, in its huge majority, Black people. So this is the second vector that we must tackle: oppression, state violence, legitimizing private violence. And lastly, I think we can extract from this panel that all of that is done not against the law, but with the law and through the law. These are laws that we must tackle, because the ones that are openly discriminatory no longer exist. But discrimination is everywhere in the legal system, and it is up to us judges, through the interpretation system and through the understanding of the justice system in its broader sense, to prevent that diffuse discrimination and that diffuse racial inequality prospers and continues in judicial proceedings. As judges, we are currently the rule of law judges, but we have been the judges of the enslavement period. And it was us, judges, that upheld slavery in Brazil. And it is important for judges to remember that. It is not exactly a cause for shame for us judges. It would be a shame if we closed our eyes and ears to the people who are telling Brazil's story and for us to say that we have nothing to do with the past or even the very recent past or even the present racial inequality. And that's what I ascertain from this magnificent panel. And thank you to Appellate Judge Angela Moraes, the President of the New York Court of Justice, my colleague from the Constitutional Court of South Africa, and also my dear Adriana de Cruz. And I am shocked that someone confuses the two of you. I'm even wondering if it's really you standing in front of me right now. Perhaps it's a Jelani, who knows? I'm kidding. We had a sensational panel. Congratulations, everybody.
Já vamos iniciar o próximo.
So we will now begin the next panel, and I'd like to invite, first and foremost, our panelists to take their seats.
Eu convido o
I would now like to invite
o
I
desembargador
invite Appellate Judge Marco Aurélio Bezerra de Melo, who will preside over this panel, Professor Thula Pires, Professor Adilson Moreira, and Gabriel Sampaio. They will be introduced by Appellate Judge Marco Aurélio Bezerra de Melo, my friend and director of the Magistrate School of Rio de Janeiro and an appellate judge in the Court of Justice of Rio de Janeiro, and he writes about the Quilombola population in Brazil. And sometimes I think he has such advanced perspectives that I feel like a conservative person when standing in front of him, almost as someone from the past when I'm faced with Marco Aurélio Bezerra de Melo's position. And he is an extraordinary legal practitioner, and I am sure we're going to have a very wealthy discussion. And I would also like to ask Professor Adilson to take this seat here, and I will now move to the audience.
Tudo bom, professor? Quanto tempo? Tudo bom? Tudo bem, tudo bem. Bom dia a todos, a todas.
Well, good morning, everybody. First and foremost, I'd like to thank Justice Antonio Herman for inviting me to participate in this event and congratulate His Excellency, my dear friend, and to say here publicly that in the day of Justice Herman's inauguration, I was very emotional to see him presiding over this court. I was absolutely sure that we would have a democratic, inclusive administration that wouldn't shy away from issues like we're doing here right now. I think that in this auditorium of the of the National High Court of Brazil discussing racial equity is a landmark that makes us all emotional. Such a relevant debate. I would also like to acknowledge, just to try and complement what Appellate Judge Adriana said. Angela, I apologize, said, and Dr. Karen? No, Dr. Adriana, my dear colleagues, that the post-abolition issue had a much more cruel preceding fact, which was the coincidence with a 14-day gap between the Eusébio de Queiroz law that tried to abolish slave trafficking. So Brazil was preparing for the abolition of slavery, which, as we saw here, both in the US and in South Africa and also in Brazil, was very inconclusive. But that same country that was preparing to abolish slavery through the Eusébio de Queiroz law, at the same time, it concentrated land through the Land Act 601 of 1850. The Eusébio de Queiroz Act is from September 4th, 1850, and the Land Possession Act is just 14 days prior to that. So this absolute formal lack of access to land for Black people, as some scholars say, the favelas or the slums are the new slave quarters. It was very well orchestrated. Dr. Adriana brought Article 18, the whitewashing process that Brazil tried to engage in, because we had just abolished slavery, and we had previously enslaved people who were able to act in society. For example, a Quilombo, an escaped slave community in Rio de Janeiro, provided flowers, sold flowers to the city of Rio de Janeiro. So there were Quilombos, escaped slave communities, that even during slavery were able to interact with the local economy. So there was a population mass that should have had access to land. Many, many people. And what does Brazil do with public resources? They bring Europeans and provide them with pieces of land, significant pieces of land. An example that we would never find, and perhaps that's good from a karmic standpoint, so to speak, a Black person that is a huge landowner, unless they acquire that land at a later date, because the lack of access to land was absolute. Like Dr. Adriana said, causing this complete lack of equity. I'd also like to highlight the importance of, and it has been said here that our topic is racial equity, but that all of us and our Constitution recognize that inequity, racial inequity is a reality, and the Constitution does this in its third article when it says that all of us have the obligation of building a society that is free, solidary, and fraternal. And what is being said here? That we're not free, we're not solidary, and we're not fraternal, but that we should build that society. And that's what brings us here. The first panel that I watched, all of us have many things to do, we're all very busy, and it's hard to be in all places. Like Justice Herman said, I am the director of the School of Magistrature, and I'm also a judge. So I'm always very busy. But coming here yesterday would have been completely worth it only for the first panel that I watched. And I learned a lot, and it's always good for us to reflect if we spend our entire time being productive and being notified, we get too distracted and we no longer have time to be distracted. I apologize. It's a challenge for me on this topic to be the mediator of the panel, but well, I've said too much, but we currently have a panel of wonderful scholars. Here beside me, we have Thula Pires, the professor coordinator of the graduate program in PUC in Rio de Janeiro. She's also a ballerina. She has a doctorate in constitutional law and a professor of the law department at PUC, where she coordinates the graduate program in law in the interdisciplinary core of production and memory of African descent. And she was a professor in the Walter Gammon Institute in Cape Town, and she also was an advisor for Amnesty International Brazil. Here we also have Adilson Moreira, a professor in the São Paulo Law School, FGV. He has a master's with Harvard University and also a master's with the University of Minas and a degree in psychology in the University of Milan. She also has a postdoctorate with Yale University and a professor in Stanford University. He's also an assistant professor in the Law School of São Paulo in the Getúlio Vargas Foundation. And here we also have Dr. Gabriel Sampaio, Director of Incidents at Conecta Human Rights, and he also coordinates the Climate Justice Corps in the Climate Sovereignty Fund, and he also is a member of the Organization for Combating Authoritarianism, and he's also a member of the Human Rights Committee. And I have huge admiration for that committee. And he's also a member of Strategic Legal Action in the Moraes Network, has a master's in law with PUC. He's also a member of the Ombudsman of Policies in São Paulo. He was the Secretary of Legislative Matters in the Ministry of Justice, superseding Justice Minister, and a counselor in the Criminal and Penitentiary Policies Council and the International Human Rights Council, and the National Director of the Human Rights Council. He, as you can see, has a very extensive resume. So from that, you can see the panel that awaits us. And first of all, I'd like to pass the floor to Thula Pires. Good morning.
Alô, alô, foi? Bom dia.
Good morning. I'd like to start by giving myself description. I'm a Black woman. I have white glasses on. I have dreadlocks that are partly tied. I am wearing a striped red dress, and I would like to thank Herman Benjamin for inviting me, and also Marco Aurélio Bezerra de Melo for welcoming me to this panel. And I would also like to acknowledge my fellow panelists, Adilson Moreira and Gabriel Sampaio. We have met many times in this fight against racism, and also I would also like to try and share with you some of the challenges that this panel is proposing to us. It invites us to think about strategies, efficient strategies for racial equity in the judiciary branch. And we can talk about this in many ways. We can think about different strategies depending on where we're at, what roles we occupy, and what is expected from us when it comes to these strategies. So I'd like to start by highlighting some strategies that brought us here today. And this is also about honoring a long path that allows us to not only have this discussion at the National High Court of Brazil, but also that allowed for many of the judiciary policies that have been implemented in the last few years, especially in the last 2 years, when it comes to racial equity. And why is that? Because one of the aspects that are specific to racism is also the sequestration of the public agenda, of the collective agenda of social movements, for that policy and these new realities to be possible in these institutions. And that's where I want to start, because it doesn't make sense for us to think about new strategies or about emphasizing some of the strategies that must be consolidated within the justice system if we don't recognize firsthand the people who allowed and have worked historically to allow institutions to address these policies. So the first strategy that the Black and Black women's movements carry out historically in this country in relation to the promotion of racial equity in Brazil is what I like to call the use of law against law. One of the central figures when we think about equity in Brazil is Esperança Garcia. Esperança Garcia was an enslaved woman who dared to mobilize the legal system against the legal system in a freedom litigation within a system where slavery was protected. So we have Esperança Garcia as an example of an important strategy to mobilize law against the law system, but that strategy is re-updated in the same way as racism. So if we consider Luis Gama and also Esperança Garcia, we can also mention a series of other initiatives that were promoted by strategic legal action. And I would like to say that this is done in Portuguese, which is a category created by Aurélio Gonzalez, to identify not only how much the influence of the African culture was fundamental in the national identity of Brazil, but most of all in the way through which we learned to give names to the things in the world. So she has very important work in the language field about how language defines how we interpret the world and how we position ourselves in the world. And she, through the idea of Portuguese, calls our attention to the impact of the African monarch in the production of language in Brazil, its significant impact in naming things and interpreting the world. And this seems to be fundamental for me, especially when we talk about the justice system, that deal not only with normative provisions and with the mobilizing of language in a very central dimension to define what will be protected and what or who doesn't deserve protection, but especially in the type of interpretations we engage on. And the more we deny that influence and deny the possibility of recognizing in these provisions and their possible intervention, this influence, the more we distance ourselves from a possibility of strategic litigation. So we have a long-standing tradition of political litigation that has moved the justice system forward and pressured it to judge on certain matters that we sometimes don't even understand how was possible in that specific legal context to have decisions or opinions of that nature, but this has to do with that courage and the strategies that the Black movement and the Black women's movement have used in the law field. In addition to that, we have, especially starting in the Indies, another strategy which has been growing ever since, and here I refer to a conceptual dispute that we have engaged on about what is law made for, and what can we do with it. And I think that law for Black people is not when we deal with data, like Judge Adriana Cruz just mentioned, to me, that does not mean a lack of efficiency or a deviation in the law application process. I work with the idea that this is a very well-formed manifestation of law in the terms that it was made to act on. Law was not built in Brazil to protect Black people because of something that Herman Benjamin highlighted in the last panel, because we're not even recognized as people.
Because of the humanization that Black people go through in this country, that means that we're not recognized completely as people with full rights. If we are not people with full rights, there is no possibility through the law judiciary of having a protection of these people for the things that we're trying to work and fight for. Because, why do I say this? Because when we're talking about the discussions on the law schools in Brazil, and this first one happened in the Constitution of 23. By the way, we are in the 200 year of the Constitution of 24. 200 years that we've had this nation be a state of constitutional law. I have not seen what this represents and the impact it has in the year of 2024. If not even in the round days of centenaries of 100 years, we did not propose to discuss seriously what legacy this is and what permanence it places in the society that we live. It's going to be harder day by day to advance in the direction that we must advance. I close my parenthesis. Here's the message, and hashtag message. So the Constitution 23 was the first constitutional moment that we discussed the need of having law schools in Brazil, and not for nothing. There was a reason why they were the first ones that were founded here. And we have a transplant directly of Portuguese law to Brazilian law with the entire colonial structure there consolidated in that. So it's an independence that is going to be followed by a legal institutionalization structure of colonialists, not just the habits of the Portuguese law, but the kind of diplomas that were given, but also in the formation of this elite or this intelligentsia that would deal with the public functions in Brazil or attributes. So at that point, we can notice why, when we look more seriously at the formation of legal teaching in Brazil, we can understand that the degree of lack of legal protection that Black people live in this country means exactly this very well finished understanding and construction of how the judiciary is built. And the one thing is to realize this and to notice the permanence and the re-update of these forms of the legal sector remaining in this same relation of the be or the being, and the people that remain in the non-being, in that category of non-being. One thing is to notice this and the other thing, another thing, is to be accomplice to it. So that is why the second strategy seems fundamental to me, because this is a moment where we're going to have a conceptual discussion of what law or should be and how we must think of law, because it's not because it was built in this way that we have to continue this whole series of things with the limitations that were imposed. Then we're going to have the work in 1980, the first work that we recognize as from the legal field in social rights, is when we start undoing a lot of the myths that were talked about already here between yesterday and today, among which that there was only legal segregation in the US and South Africa, and that Brazil did not go through that. A good part of the first works on law and social rights is going to be dedicated to this undoing this myth, because their works are going to be done within a context that the movement of Black women and men is also going to see that on the political agenda, we're trying to undo this myth in a broader sense with all its interfaces in the field of law and conceptual discussion. These authors dedicated themselves to do the same thing, but within the specific discussion related to law. And so these strategies of a conceptual discussion of what law can and should be, thinking in racial equity. We did not end with the works of Doria Onis. They have continued. We can identify today a significant series of authors that follow in the same thought, and especially with the advent of affirmative action to enter university, especially when they enter in postgrads in law, we see a much broader work on this same line and this conceptual discussion. This is a strategy that was built also by the Black movement, and it is important that we understand and that the people that act in the justice system know of this contribution. Why? Because a good part of us were educated almost the same way as those from 1823. And you can see that I'm not that old, right? But you can see, right? So we will possibly sit down and talk about the kind of education we receive, and we would notice that we have basically the same education. If we talk with people from before or after, we see there's very little changing in this scenario. So it's necessary that we not only continue discussing these aspects conceptually, but that those that act in the justice system broaden their repertoire. It's for a long time that we can't say this anymore, especially nowadays. It's really not nice to say nowadays that we just do not have the subsidies to treat a certain subject. We have qualified subsidies discussing law conceptually in all the areas of right. If you haven't found it, it's a research issue. You haven't found it. So nowadays we really cannot say that anymore. And lastly, I wanted to highlight some strategies in the field of more direct political incidence in creating national and international policies. This movement of Black women has never rested. If there's something that they never stop fighting for, it is facing, including the non-application of a lot of norms we have. And then if I take a very recent story, so that I don't have to talk about the degree of applicability, because I think that from Salinas to nowadays that everyone knows what norms I'm talking about and is accompanying the non-application of these norms. At least upon Salinas from here to now, we have not stopped discussing normative elaboration, be it in infra-constitutional level or constitutional level in this country. Before that, that was already true, because our articulation, our coordination, especially in the field of constitutions, it has been from the very first constitutional experience. But obviously, the Constitution of '88 is going to be fundamental benchmark in the kind of coordination, a new design, and mobilization in that sense. And we do that in an international environment as well. I'm going to set a very symbolic example that was very fundamental, not just for racial policies that were developed here in the 21st century, but also how much the action of Black men and women in Durban was important for the impact that the convention has in other countries that are signatories. Why? Because this is a political discussion directly, not just running after, so to speak, of the update on racism, as Adriana says, but also why? Because in many moments we are writing procedures where racism is not necessarily re-updated and is a request demanding a kind of response. So this is an important strategy that has not been abandoned, even when the justice system does not do its part in conferring how applicable this is to these normative enunciates. But we continue offering to the entire Brazilian society all the time further tools so that we can advance in this direction. And then in the international, mixed with the national field, I want to end this part on the strategy, mentioning the importance of internalizing with the status of international norms with the inter-American fight against racism. From January 2022, this country has another constitutional benchmark framework to face racism. This means that magistrates present. If from December 2022, any proceeding that you participated in and that involved Black people, if you did not mobilize the CG, this thing, it means that your decision or ruling was most probably contrary to the Constitution. The CID does not apply itself just to cases regarding racism. It is far broader than that. And it is a convention, and so therefore our constitutional framework to face racism incorporates a series of conceptual discussions we've been having up to now. One of them we mentioned a lot. We mentioned today in regards to indirect discrimination, then multiple aggravated discrimination. That is the one that we know more as intersectionality. And all of that is mostly identified as a constitutional framework to face racism. I want to mention this in other organizations of the legal career, and I repeat it here. Do not make the Constitution now altered by the CID what you did with the racial equality statute, or the bylaw. Who of the magistrates mobilized the racial equality bylaw in their proceedings or rulings?
Como pretendíamos demonstrar.
As I wanted to show.
Todo mundo de maiores comentários a respeito. Agora, o que a gente precisa dizer é...
So what I want to say is don't do the same thing with the Brazilian Constitution, especially after the alteration of the Constitutional Block of 2022. This is not a request.
Isso não é pedido. Esse é mandato constitucional.
This is a constitutional mandate. It's an obligation. This comes as part of your function.
Se a gente segue, né? Então queria colocar pouco
If we follow, so I wanted to place some of these strategies that are long-term strategies, all of them updated by the movements, the Black social movements. But I also wanted us to go back a little bit to what we need to do from here onwards, such as some strategies, many of which, I don't know how long I've gone now. I forgot to press start. I'm going to pretend. Let's say I spoke half of my time.
E agora do que a gente precisa pouco botar atenção em alguns aspectos.
So let's talk a little bit and pay attention a little bit to some aspects that we've been already doing, that I think our strategy is to strengthen and consolidate, and others that we might need to think and have a little bit, be a bit more bold and do it in another way. A first strategy that seems fundamental, because in a country that is still marked by the ideal of racial democracy, to advance, we must design, or we must demonstrate. And we can only use these policies when we can produce data and diagnostics that present a scenario of racial inequity with a level of qualification that is irrefutable. And facing this, we have slightly more efficient mechanisms of pressure to develop policies, be them public policies in the executive as well as in the judiciary. It is necessary that we have pay each time more attention and have care with producing data and diagnostics. I think that on this point we have advanced a lot. Those who follow the census of the magistracy saw what the census of 2013 was, and how the silence of a response to the vast majority of Brazilian judiciary was screamed when they didn't want to do their identification, when they boycotted the census of 2013. But those who saw the census and everything that was possible, and it was possible to provoke with that census, and the kind of research that allows us to monitor that Judge Adriana showed us, we see the difference from one scenario to another, and how much investment in data production, if done in a constitutional way, how much results it can have, concrete results in policies, but also in the way how people start perceiving the institution where they work. Because this changes, and it's difficult for the person to follow feeding this delirium if she deals with a date that is right in front of them, that is saying a lot. And I repeat, even when there is a silence, and people think that silencing this data means to boycott, I have to say, we have learned to read the silence. We are also giving us precious information. I must let you know, perhaps you're offering us less strategic information if you actually do your self-declaration, because we know how to read your silence. And we have methodologies to do this, because silence is not an exclusive strategy of negating Black people in Brazil. The academia is working on this for quite some time to read the census here in the US and South Africa and many other places. So that is in and of itself also information. It is necessary that we also invest in the diagnostics. When we are stuck in the day-to-day, any function that we exert, is very difficult to stop and think about the flows of our work and how we can improve this flow. That's true, regardless of the amount of processes or procedures with which we have to deal. It's very hard in the middle of the day-to-day that we be able to sit and about the flows, where the bottlenecks are, where we can improve our function, what can we do differently, how can and many of the initiatives that we see within the justice system, that we have an attempt of improving some of these bottlenecks, are preceded by diagnostic production about that phenomenon. Within this, the National Justice Council has had a very important role, because we have an investment in research in the last years that has been very big, and that has many cases made possible important results in the entire career. So I think we must think about the production of data and diagnostics as a strategy for promoting racial equity, because they cannot just show us where we need to improve, tell us where there is an issue, or there are clear and obvious ones, and we must have the courage to make a certain practice possible, stop it and finish it once and for all, something that is unjustifiable thing that remains from legal colonialism.
And with that, being able to promote racial equity where it is necessary. Another strategy that I consider important is in the training. And when I'm talking about training here, I'm talking about everything that is mentioned in the selection processes, because we know that this impacts the profile of our judges, but also in what is considered important by law schools in legal training as a whole. So you have a possibility of defining the topics that are mentioned in the public selection processes to impact the profile of the people accessing these careers, and also producing an effect that goes beyond magistrature and that strengthens teaching and discussion of these topics in law schools as a whole. We know that. And so thinking about legal training as a strategy is important to promote racial equity, because we can do that with the references, the literature used in the selection processes, and also in the continuous training of legal practitioners. We see the incorporation of topics that were not mentioned a couple of years ago, and we still have a lot to do in that sense. And in terms of continuous improvement, there is one thing that I think is fundamental, which is moving away from that Eurocentric definition of knowledge and of who can inform this training. And why is that? Because we still demand almost like canon status for people to be recognized as able to influence the judges that are entering the career. And we need the leaders of movements, social movements, and traditional communities to be a part of that training process, because these are the people who have the correct qualification to get other people to properly understand what a specific human rights violation means, and also what is the meaning of certain practices, of certain actions within their respective forms of being, living, and existing. So we need to have the ability during training to recognize these aspects. And why is that? Because this will make us, or tends to increase our sensitivity faced with a public hearing request, for example, because if they remember that certain topics or certain aspects only make sense because of the fact that they had a direct contact with a leader from a specific community, this will be something that is in their memory, and they will know that this can't be decided on without listening to that community. And this will influence the requests for amicus curiae also in a more qualified manner, because the current practice is a very superficial analysis looking at the mission of the organization, when in fact there are many people requesting amicus curiae so that they can impact that process, and they are characterized in a more evident manner if you know the issue, and much less evident if you don't know the issue and you're not used to dialoguing in a plural manner with that type of topic. So it is important that we do not sustain the dichotomy that legal knowledge can only be produced if you have a law doctorate. Legal knowledge can also be produced by those who can appropriately define what is a violation of rights and how specific rights can be perceived. The very amplitude of the law field, depending on the group we're talking about, is much more well defined by members of that group than by members of people who do not than by people who do not know the forms of existing of that community. And also in the training field, it is important to expand the doctrine repertoire that we have, right? We still see in judicial decision the mobilization of a very conservative hermeneutics due to the very inability to integrate the conceptual disputes and discussions that are more current, but also because people are not honest enough to incorporate the meanings attributed by the victims to the violations that are being discussed. This conservative hermeneutics still maintains decisions on the faith of many people without considering these people. And in the judicial field, since I'm out of time, I'll be very quick. I'm sorry. In the extrajudicial field, I think we have some initiatives, but we need to look at them more carefully, like restorative justice. This is something that can add much to the promotion of racial equity, but has been oversimplified in many courts. I'm extremely concerned with what many courts have referred to as restorative justice, things that are not restorative at all. So we need to address these instances, but also be careful of considering restorative justice more seriously and of invoking that term in the with the correct meaning. And also, I think there's a lot to do in terms of protocol, like Judge Adriana said in the end of her speech, because protocol, one of its goals is the goal to try and build together with Brazilian judges the possibility of perceiving the racial bias in different demands that come for analysis. And we must do that, and obviously we count on these judges in the application of the protocol. And with the possibility that these judges, by applying the protocol, offers us the possibility of improving it, but we won't be able to improve it if the judges are not partaking in the protocol's provisions. And lastly, I was going to talk about judiciary policies, but that is the topic of the next panel, and I went over my time, so thank you for your attention, and see you soon.
Vocês acham que eu deveria controlar o tempo?
Do you think I should have been more strict about her time? Does anyone here think that? Thank you, Dr. Thula, for your wonderful reflections. And we had the cherry on top in your conclusions when you talked about the International Convention for the Combat of Racism. This is fundamental. 2022 is probably like yesterday in legal terms, because in Brazil, it takes us a long time to apply new legal norms. But these ones are very relevant. And also the importance of data and diagnosis for the implementation of public policies, the change in the literature that is mentioned in the selection process. Now we have a discipline referred to as anti-discriminatory law. And in our magistrate school, we did a training course only for that law. And also in the training of current judges, we have hired Black professors, and Dr. Thula will be propositioned to be a part of our faculty in the magistrate school, because we have many courses on that topic with very good results, because we see often that people are more ignorant than evil. Usually, a homophobe is first and foremost ignorant, just like a racist or someone who discriminates someone else's religion. When they're exposed to the light of knowledge, this light that shines in this wonderful panelist we just heard from, the cancer of ignorance is dissipated, and we become less and less homophobic, less and less racist. So thank you for your words once again. Now we will hear from Dr. Adilson Moreira. I already read his extensive resume, who is very well known through his work here in our country. You have the floor. Good morning, everybody. First and foremost, I'd like to acknowledge Appellate Judge Marco Aurélio, in the name of whom I acknowledge my fellow panelists. I was invited to speak in this specific panel that discusses possible contributions to tackle racism in the judiciary branch. Obviously, this is an extremely complex topic, like Professor Thula just mentioned. I want to make my small contribution, a contribution that is completely based on one of the last books that I published, by the name of Racial Literacy, a proposal to rebuild Brazilian democracy. I will defend the theory that we can definitely move forward in the quality of the provision of legal services in Brazil if we pay more attention to psychology, and more specifically, a field of psychology which is social psychology of discrimination. And how can psychology contribute to the tackling of racism? Well, first, when we talk about the provision of legal services, we are obviously talking about justice. We're talking about what is fair. We're talking about people who go up to the judiciary branch or are brought before the judiciary branch, and they expect the judge to solve that legal issue in the most appropriate manner. To that end, the judge first must be attentive to the importance of equity and the equal treatment of all. As judges, must be attentive to the different meanings of equality, the formal equality, the material equality, the notion of equality as a recognition of inequality, as has been said by many authors. Another very relevant parameter for the appropriate provision of legal services, which is very obvious, is the commitment that the judge must have to freedom, also in its different dimensions. Because guaranteeing equality and freedom is also a way of protecting such an important aspect of human existence, which is people's dignity, human dignity, which is a founding principle of our constitutional order. An appropriate legal service provision, it's a fair legal service provision because it considers aspects of material justice related to the specificities of that case, related to the appropriate application of legal norms and constitutional norms to what is being discussed. An appropriate legal service provision should also take into account the several procedural aspects related to the case in question. But what are the obstacles tackled by appropriate legal service provision? One of them is the very form in which the law is structured, or the very legal logic. And a very characteristic aspect of the legal logic is the idea of rationalization and generalization. So we have this idea that within a case, different social actors operates. We have the parties, but also several other stakeholders that are part of the administration of the justice system, starting with police officers, going through police chiefs, and then to a prosecutor, and then through a judge. And the basic assumption is that all of these people operate in a rational manner. All of these individuals are capable of applying legal norms in a neutral and objective manner. But that's not reality. Human beings do not act rationally. Judges, prosecutors, police chiefs, police officers, these are individuals that are socialized within a society where we have racial stereotypes that are very pervasive. 24/7, 30 days a month, and 365 days a year. We are constantly bombarded by stereotypes and false representations of humans. But how does that affect the quality of the legal service provision, of the jurisdictional practice? First, we have the issue of the war on drugs. Brazil, as was previously said, is one of the #1 countries in the world in terms of imprisonment, and an element that is always present in decisions related to mass incarceration, which is the idea that the police officers were just doing their jobs, that they are public officials that operate in good faith, and therefore not even the public prosecution service or a judge has any reason for doubting their testimonies. This is what appeared in the very famous case of Rafael Braga. The judge argued, well, look, guys, the police officers didn't know Rafael Braga. Therefore, they didn't have any motive to discriminate against him. Many judges also argue that police officers are state officers, and we need to have the assumption that they operate in good faith and in a rational manner. And if we question the testimony of police officers, we will be violating the very Constitution. Many also use this argument in the case of theft. We have seen many members of the public prosecution service resorting to the Supreme Court to guarantee that a Black woman or a Black man that stole a package of cookies or a gallon of milk because they were hungry, for them to be convicted. And these judges say, oh, they need to go to prison to think about their actions and things about that nature. We also have the problem of the racist jokes, and it is very common. I have read hundreds of legal decisions on this that say that, well, this is not a case of racism, of racial injury. because of the subjective absence of the crime. There was no intention to offend or to cause harm because we are a country where racism doesn't exist, this is irrelevant, and etc. So these are some of the examples that are very common and very present, examples that show how our judiciary system systematically fails in providing appropriate legal services. So we have the following issues that must be considered. First, we must be attentive to the fact that certain social groups, and in the case of Brazil, South Africa, and the US, we must be attentive to the fact that there is a racial animosity, which are the central cultural element of the public culture of these three countries, even though this happens differently in each country, but it is a common element of the public culture of all of these countries. Our judiciary system has no knowledge on how the circulation of stereotypes compromises or reproduces racial stratifications in every way, and how this belief that social actors are always operating in a rational manner or in an appropriately motivated manner produces social inequalities.
So, what does psychology have to do with this? How can psychology contribute so that the judiciary system, legal system, can actually exert its functions in a better way? The first thing we need to learn to know how it is that human beings think. We humans, our mind is constantly being bombarded by a constant process of stimuli, sensorial stimuli, sexual ones, physical ones, and so that our experience can make sense, our mind is constantly going through a process of categorization. We are always classifying people, situations from socially learned categories such as race, gender, class, sexuality. And we are always making generalizations from these categories. This process of categorization and generalization are at the basis of what we call mental structures or schemes. So the structures are the patterns through which we perceive reality, understand ourselves, and understand the other. Mental structures are at the basis of social cognition. So when we talk about how the legal system analyzes domestic violence, for example, it is important to understand what is behind this. What is behind it is exactly social cognition, how men and women, and especially men, internalize the idea of who they are, what they are, their functions, also the function of the other, of what it is to be a woman, of the woman's function, and any behaviors that go against these cognition or expectations generate frustrations that generate the domestic violence. These stereotypes and mental outlines are behind our prejudiced attitudes, that determine the daily behavior of our police force, for example. They are behind the way how members of the public ministry also interpret and perceive people of different social groups. And prejudices are anticipated judgments that we do in regards to certain people because they are of a certain group and having certain social obvious traits. So I have a black person in front of me. I'm a police officer and I'm facing a black person that is carrying drugs. I will immediately start from the presumption that she's not a user, that person is not a user, but rather that they are a trafficking, and therefore I will then accuse them of association to traffic and drug trafficking. So prejudice are permanent ways of generalizing expectation of behaviors that affect the black population, that are reproduced by the judiciary, the legal system, and that impede having a adequate legal service. So next to prejudice, we also have the stereotypes. And what are stereotypes? False generalizations that we make about members of certain groups. Stereotypes have a dimension, a descriptive dimension. So they designate supposed characteristics of members of certain groups. So if I'm an employer and a black person comes to me with very dark skin, already will start from assumption that this person is not qualified. Because this descriptive dimension of prejudice makes me have an inadequate evaluation of the professional competence of this person, starting from their appearance. Stereotypes also have a prescriptive dimension. So designate the place and functions that people can occupy. So when the police of the state of São Paulo circulates documents obliging that or giving a guideline that police officers stop and search all the black people that circulate in high-class neighborhoods of Campinas, what is at play here? The assumption that black people, especially black men, can only be delinquents. It does not go through these people's mind that there could be people living there, that they are workers, that they went to undertake whatever function, or that they're simply walking in that place. Stereotypes also has a relationship dimension. When I affirm something about a person, I am affirming the opposite about correlated groups. So why the difference of sentencing between racial groups? So why does the black man that has whatever amount of drugs, be it 1 gram or 2 grams, or will be accused of being associated to trafficking, and a white man that has 100 to 200 grams, far larger quantities, will be considered as a simple user, because it comes from the assumption that white people are morally perfect, that white people are naturally honest. And racism has this role of always reproducing positive images of white people and negative images of black people. And this impacts Firstly, in the policing, in public safety, in the acquisition that a public ministry will do, and eventually in the sentencing, in the ruling. So this dimensions the stereotypes of the social psychology of discrimination will determine, for example, the perception of the judge of the danger, how dangerous the individual is, if they will be able to answer the procedure in prison or outside, or if he's going to declare the preventive imprisonment immediately. So why does knowledge of social psychology of discrimination is extremely relevant for a adequate jurisdictional application? Because officers, prosecutors, appellate judges, ministers must know the social dynamic with important aspect of Brazilian social dynamic, which is how racism operates, and a specific aspect of the operation of racism, that the animosity against Black people, and how this animosity influences individuals in a conscious and unconscious manner, how this animosity structures the institutional culture of the judiciary, of the public ministry, of the ministry police, and sometimes even of the public defense, because a lot of public attorneys already start analyzing the case from the quality of how this individual inserts itself in society. So, summing up, how can the Brazilian legal system guarantee a jurisdictional service? Firstly, the National Council of Justice, a few representatives present here, must make it obligatory the teaching of anti-discriminatory law, right, and law as a obligatory course of the graduation, of the course of graduation in law.
Isso vai eliminar esses problemas? Vai
Will
diminuir
this
demais.
eliminate the problems? Well, no, I think it'll diminish significantly, because a lot of individuals and judges decide cases because of lack of adequate knowledge of reality. That is a fact. So once people have a knowledge of this and other aspects of the anti-discriminatory right, of the right of cognitive psychology, that was the field that I used to structure this speech, we Black people will manage to be treated in a more equanimous way within the justice system. Thank you.
Mais uma palestra
Yet
brilhante.
another wonderful speech, this dialogue between psychology and judiciary, and the justice must be done, and I say for me, unknown, unfortunately. We have to talk about this and learn to study. Thank you very much, Professor. Now we're going to hear Dr. Gabriel Sampaio.
Muito boa tarde a todas as
Good
pessoas
afternoon
que
to
nos
all
acompanham.
here
Além da minha
and online. So my description was Gabriel Sampaio, black man with dreads up to his shoulders, black glasses, and a short beard, black suit, and a wine-colored tie. It's an honor to be here, and especially to be on a panel that brings a very big responsibility with it. So I want to greet Appellate Judge Marco Aurélio, Pires, Professor Judicial. It's a great honor to be able to be here. And the main challenge, as Professor Thula has already mentioned, is the challenge to honor our ancestrality, in this case, to honor the contribution of my colleagues, because it is the contribution that allows so much, as much for my speech as for our debate, to have a line of division when we treat equity subjects. For several generations, I think we managed, and it was possible from the speeches throughout the seminary, to reinforce and remove some myths, the myths of the racial democracy, and now to face the myth that the right, that the application of our legislation actually tend to our expectation in regards to Black population as to the rule of law, a state with rule of law. So let's do the conceptual defense and evaluate if the rule of law is giving the Black population that which is expected of it. I arrived to this debate marked with the experience of our states, and everyone saw, because the scenes go throughout the world, as we've had very serious ones of violent situation, of a Black man being thrown off a bridge in a given moment. Those things of our subjectivity, I thought, well, it's so absurd. It's as if you're throwing a bag of trash, but even that we wouldn't do. We wouldn't throw a bag of potatoes or trash as if it were nothing, but you would throw a Black body. What is the rule of law giving to our population? And this is not like an exception, as some authorities would like to say. If we take the same weeks, as they're very linked to advocacy of human rights, and if we take just 10 days in the state of São Paulo to leave the boy who was assassinated in the where his father assassinated a few weeks before, where he was denouncing an issue of human rights. The father died like that. The son, 4-year-old son, was assassinated. In this case, the police forces admitted committing that killing, that assassination. We can't even count tell how or what the mother is going through, but I tell about the brother that says he is feeling guilty to not telling his brother that they were together, that he had to throw himself on the ground because he saw that the police had arrived shooting in the community. That is the subjectivity of the brother that is slightly older. And a little later, we have these other images. The young person leaving the market that is killed with 11 shots, because what a horrible crime to have stolen some soap from a supermarket. And also the last scene that I saw with the man being thrown off a bridge. And so I corrected this subjectivity. No, he was treated as a Black body in our society that admits, and in this case, institutionality tried to organize its version to demonstrate that it was completely outraged, that you cannot do that. You cannot shoot someone in the back who is already surrendered. But the accusations that we've received in the beginning of this year have already had things like that. I cited this case of the father and the son. I can cite other cases of human rights violations and occurrences with this level of atrocity taking place in our state of rule of law. It's in this context I would like to place our debate, because we are in a place, and it was important what Thula mentioned here, that we advanced, and it's important to highlight this, we advanced a lot in our fight. And this is due to, we have to honor, if we take the picture, as Professor Thula said, what follows this dimension of a nation founded on this base of our Constitution, this fundamental alliance with the slave model, that if we compare with nowadays scenario, we're going to honor our fight to know that from the Constitution of 88, from our fight, we face of the big issues that from a normative point of view, it is necessary to say that racism did and is taking place. The legislation consolidated. Dr. Marco Aurélio talked about the law of lands. We can mention the way how between the Eusébio de Queiroz law and the previous law that was already forbidding the slave trafficking, what happened in the country, the legislation already said, we needed a new one, not to just consolidate the end of slave trafficking, but to insert in a normative framework and to actually establish this alliance of the elite in the slave model.
As we know here that some accountability measures will be taken in relation to the officers that committed these crimes that everyone saw. So it's important to often demonstrate that some measures are being taken to meet our demands, but at the same time keeping things as they are. And this is what we want to combat. If we want to engage in radical racial equality like Brazil deserves and we deserve, we also need to be radical in our actions. It is unbearable to have to say that structural changes will be left for the next generations. And that's why the data brought here by Dr. Adriana were so important, emphasized here by Professor Thula Pires. Is it reasonable that after so many years of fight, we have to consult data on the racial panel and for us to see that in Brazil, it is not in a northern country. The data on Black judges are the ones that were shown here. In the previous panel, we had a perfunctory research that gave the wrong data, but now with the precise data is even more concerning. And research that is published should be valued. Of course, the justices presented very important measures, and Dr. Adriana also presented important measures. But now our challenge is to look at that data and set this challenge for this generation, a challenge for every selection process, including the literature that is included in the process and also the results of the process. And like with every public policy, we need to have targets that are discussed by society, results-based targets. How can we look at that reality and still have a selection process to enter a career that still have vacancies open, We have the quota vacancies and the general vacancies. Are we supposed to uphold a discourse that says that the people, the Black people who are trying to become judges are not trained enough, or that we have a supernatural dimension? Because I think that the selection processes are drafted by very well-trained people, but who are people and humans that are inserted into specific contexts, people who are fallible, and who are fallible even in the application of the norm. I believe that this fallibility is also extended for everyone. If we analyze our national context, we are here, for example, at the National High Court of Brazil. How many appellate requests are made in relation to the selection processes or the interpretation of the Constitution? So let us not be fooled by the discourse that there is a metaphysical aspect in the evaluation of the quality of the Black people who are trying to become judges, and that they do not meet the requirements listed in the selection processes. The problem is not the people. The problem are the selection processes. All spots need to be filled for all selection processes, and this is the claim of our ancestrality and of the people who are here right now, and say there cannot be selection processes with open vacancies because of the lack of meeting requirements. We need to seek changes in this. In the current generation, 20 or 30% still does not represent our parcel in the country. So how long is it going to take for us to look at this panel and say, well, we are really in a state where the rule of law and where the legislation delivers on everything that was promised? We must have a sense of urgency and a real sense of responsibility with what we fought to build. Therefore, we have an endogenous and an exogenous challenge. The endogenous challenge is the internal challenge of the institution. We count on the leaders in these institutions to position themselves. When faced with these facts, it's the sense of indignation and urgency that should contaminate everyone who looks at the situation and cannot settle for it. I think this is very specific to lawyers always voicing our sense of indignation, but after doing that, I always think, am I coming on too strong right now? But please, don't get me wrong. I'm voicing my indignation here because I'm contaminated by the day-to-day life of a person who is engaged in the fight for human rights and in the anti-racism fight in the country. This indignation is contaminated by my own experiences. And like Thula said, it is important to have contact and to bring into concrete action what we experience in our daily lives with the people who are facing the challenges. And a very important challenge that I wanted to bring along those same lines is a challenge related to institutionality. And we also have a challenge related to social debate, the exogenous challenge. What has the judiciary been delivering considering racial inequity? And Professor Janeiro has also gone into important issues in our legislation. The war on drugs, for example, we went through 2 trials that I think are very important in our context, where this was very obvious. The racial profiling trial and the drugs RA trial. The racial profiling one was a drug-related case. And in the 3 minutes that I had to present my argument, I said, in what democracy in the world someone with 1.5 grams of an illicit substance would be arrested for 7 years of imprisonment? Because that was the case, and it still is. I ask that everyone here reads the proceedings because this is very relevant, and this was discussed in the country's Supreme Court as a racial profiling case, where the very approach shows that it was a racial profiling case. And some people said, well, this is not a good case. This is not a good case because, from a subjective standpoint, us lawyers always need to work with strategies that are related to our current context. So the discussion of it being a good or a bad case should be addressed from the standpoint of strategy. So I don't want to oversimplify this evaluation, but I also want to say that the evaluation that there may be a good or a bad case in that specific context, I can't imagine at what point in the rule of law this is a valid statement. 1.5 grams of any illicit substance, any illicit substance among the ones that we know of, can lead someone to 7 years and 7 months of imprisonment. Oh, but that person had priors. They had committed theft however many years ago. Well, it still doesn't make sense. That's not the rule of law.
In the
other trial, the drugs RA, and in this case, the court advanced in the discussion and the public debate after so many years. It's a case that it took us 18 years to reach trial. And in this case, it was a cause of concern for us because we have lived historic moments in these many years of fight where debating with society was easier. But right now, since we have gone through so many attacks, and even people who believe that the earth is flat, and people who are so racist and prejudiced, that is very much presented in terms of criminal justice, we thought that we could perhaps have an overturn in terms of those judgment. And in my opinion, the topic of racial discussion prevailed. When there was question, the justices presented the data. But it's not possible that in the seizing of this many drugs in one case has this consequence, and in the case of a black person has different consequences. So that trial has a decisive element, had in the position of the court to defend fundamental rights, the racial element. If the racial element was not part of the debate, it would not be a conservative decision. This was an important element. And the challenge for our debate is also to analyze and filter what's happening currently in our rule of law and in our country when it comes to the application of our legislation. If we move forward with the building of the normative construction, with several elements in the 1988 and several legislations and quotas and etc., we now need to go to the rule of law and demand for the effectiveness of the legislation that we produce in terms of its positive effects in the upholding of rights and a filtering of the legislation that has led us to mass incarceration and mortality levels that are unacceptable. We need to filter that. And if the Supreme Court has moved forward, for example, in the discriminalization of drugs to say that a certain amount of marijuana demands a new operation of the legal system to understand trafficking or the lack thereof, we need to, as a society, to analyze and filter the entire operation of the criminal justice system when it comes to this issue and also to others. And in relation to the drugs topic, it has been a trigger, both in terms of discourse and in terms of practice, of lethality levels that are unacceptable. I have been talking about this for ages, and I can't change, Professor Adjil. So something that is always repeating itself. I always look at the data, and the statistics are the same. What changes often is the amount of people killed, the amount of homicides in the country. With brackets that go between 40 something until up to 60. The level of representation of Black people killed doesn't really vary, and it's always above 70% of general homicides. And also homicides practiced by the state. This is our state, our rule of law, the one that we built, that we funded and debated, and etc., is always above 80%. If we make concessions, it's always going to be above 75. But the more recent ones and the more trustworthy ones are at 80%. Can we discuss racial equity without discussing this? Can we discuss the fact that the rule of law is in the right path, supposedly, to deliver to society racial equity? The data is there, and it is resilient. We have tried with public policy, we have put it in the agenda, we have gone to the Supreme Court, we have gone to the public institutions, we have plans. The Minister Adriana Franco leads a very important plan, the Black Youth Alive plan. But before going to my institutional space and looking at what is happening and what I can do to improve and what is going wrong for the data to happen in that way, well, we need to do that filtering. We only have elements to discuss the abuses that we discuss because of an antisocial and non-institutional technology. People can report these abuses and, with all due respect, rub it in other people's face that that abuse is happening. Before that, we had mothers going to the public and facing up to institutions, giving interviews, crying, and appearing in all institutional spaces saying that they were abused. And in that case, people in the institutions ignore their claim, or they give answers that are not really comforting for them. But when the images appear, the institutions need to provide answers. But we need to provide answers that are cohesive with what we want to build in the democratic rule of law. So we need to filter our legislation and the effectiveness of our procedural and penal legislation to contain abuse of punitive power. I have insisted when I was in law school and throughout my entire legal career in coexisting with the dilemma of law being an instrument for social transformation. This was a pervasive debate in our society and our study group that tried to give law a meaning of transformation. And at some points, we would not really believe that we could actually make law be a social transformation instrument. In human rights and in making the defense of human rights a mechanism to defend our dignity and control abuse. But I still insist. I still think that we can make law and the tools that we have based on it a tool to defend dignity and to provide for social transformation. But that is only possible if we honor our ancestrality and we give a sense of urgency to our claims, and if we guarantee through social debate and social transformation the change in the state of things. Thank you.
Parabéns, doutor Gabriel.
Congratulations, Dr. Gabriel. Rest assured, because your passion is very well appreciated here. And we're inspired by you. Martin Luther King was mentioned here, and I remember something that he said, which was, nothing is more tragic in this world than knowing what's right and not doing it. So everyone here in this panel is following these words. I wanted to very briefly say that the ratification of racism as a crime in Brazil, the ratification of racism in Brazil persisted with the criminalization of the capoeiras, the so-called blackguard of the Redeemer who wanted to defend Princess Isabel, and also the persecution provided for in the penal code of the empire of African-based religions. So currently we have an anti-racism position, including in the international sphere, but it is a counter-reform because we have always been on an absolutely racist path in this country. And we often speak more and more about the need to tackle with sincerity the reparation necessary to the Black population, a civil reparation that is owed to the Black population. And this is a topic that should be addressed. It is a serious theme. Reparation. Other countries engaged in that reparation, like in the US. And lastly, I would like to remember the figure of Luiz Gama. I have here three people who remind me of Luiz Gama, three intellectuals that are activists in law and that want to change the law system, using law, against the racist law that is imposed to all of us. So let us move on. In the magistrate school, we have done some partnerships and agreements with free of charge courses to lawyers of African descent, of legal language, of legal English, legal Portuguese, and we have Black professors, and we use Black literature. Professor Ulysses uses Black literature, and this has been a very interesting experience that the School of the Magistrate has doing with Educafo, and we have produced very good fruits. We have had some students approved, and now we have to fight and keep the faith that is renewed with everything we heard here today. So to conclude, we will deliver to Professor Thula her certificate. A round of applause. Professor Adilson Moreira. Professor Gabriel Sampaio.
Então, aqui é tudo solenidade, né? Dou por encerrado o evento.
Everything here is very solemn. I declare this event concluded for the morning. Now we're going to have a break and we will be back at 2:30, okay?
Bem, eu sugiro que nós
Well, I suggest that we begin this panel
certamente será
because, like the previous ones, it will certainly be
bastante
a very rich
informação
discussion
sobre esse
with a lot of information about
complexo
such a complex topic
que traz várias dimensões.
that has several dimensions. The panel
Tem como título
has as its
Estratégias
title
Eficazes para
Efficient Strategies for Racial Equity
e eu chamo
in the
atenção
Judiciary Branch. And I call your
a
attention
expressão
to the
eficazes, porque ter estratégias
expression
que sejam eficazes
to the term
é melhor,
efficient, because
nós somos nos
having
enganar.
strategies that aren't efficient is like having no strategies at all. We're just kidding ourselves.
Apresentar
We have the pleasure of introducing
a Maria da Purificação
Appellate
da
Judge
Silva,
Maria da Purificação da Silva,
uma
who is
destacada
a renowned
Tribunal
judge
de Justiça da Bahia.
in the Bahia
Nós
Court of
sabemos que
Justice.
o Tribunal de Justiça da
We
Bahia
know that
foi a
the Bahia
primeira
Court of
corte de
Justice was
apelação
the
das
first
Américas,
appellate court of the Americas in
1609.
1969.
Não é pouca coisa. Um tribunal que
That's
tem
no small feat.
uma história como instituição, mas
It
também
is
uma
a
história
court that has history as an institution,
de implementação
but
da
also as an implementer
legislação,
of the legislation.
mantendo a
Being
escravidão e
Actually, the
posteriormente
court was founded in the 1600s, upholding
contra o povo.
slavery and ratifying abuses against the Black population.
Para nossa felicidade, hoje nós temos um Tribunal de Justiça
But much to our
está ao lado
joy, we currently have a court in Bahia that is besides people,
eu
especially vulnerable populations. And I congratulate
Tribunal de Justiça,
the Chief Justice of that Court of Justice, my dear friend and colleague, Appellate Judge Sinchi, for the work she has been doing there.
são palestrantes,
We have panelists here
o juiz Fábio
like
Francisco Esteves,
Judge Fábio Francisco Esteves,
juiz do Tribunal de Justiça
a judge
do Distrito Federal,
in the Federal
presidente
District
do
Court of
STF,
Law and
terminou
an
a
associate
reunião,
judge
chegará em seguida,
in the Supreme Court. He's just finishing up a meeting, but he'll be joining us soon. Joaci Dias Furtado, a judge in the São Paulo Court of Justice and an associate judge in the presidency of the National High Court, like myself, and Professor Wallace Caldo, who is a professor of constitutional law at the University of the State of Rio de Janeiro. Thank you all once again, and I pass the floor to the mediator of our session, Appellate Judge Maria da Purificação da Silva. Good afternoon, everyone participating in this symposium. Initially, I'd like to congratulate Chief Justice Antônio Herman Benjamin for his initiative and for the content of this event, as well as everyone who participated in its organization. It is an event that definitely brings a content of the utmost importance and significance to our society. I would also like to say that the Bahia Court of Justice represented here by me is grateful for being present here and for participating in this symposium that has as a goal addressing very relevant issues for our societies, aiming at the awareness raising about the need for adopting actions, measures, and behaviors to combat inequality and racial discrimination in the justice system, demonstrating commitment in favor of a better society, a fair and more inclusive society. Racial inequality within the judiciary branch needs to be addressed on a daily basis, because it's not only a matter of social justice, much more than that. It is indispensable for the legitimacy and efficiency of the justice system in an authentic society that represents people. And our institutions have been actively acting on this matter, supporting decrees, projects, programs, and yesterday I participated in the first federal justice journey dealing with racial equity. And it was a journey that was very important in terms of its content and the discussion held, because we dealt with specific statements related to racial equity. A lot of discussions, several departments of public administration and society were present and discussed this issue, and we approved statements. So I was very happy to participate in yesterday's journey. And actually, Dr. Joassi and Dr. Wallace both as well. I would also like to say, Your Excellency, and emphasize to everyone the importance of the National Forum of the Judiciary Branch for Racial Equality, instituted by 409 Resolution of 2023, that has among its attributions proposing measures for the improvement, organization, and structuring of judiciary branch departments with the aim of guaranteeing racial equity in judiciary processes. And from its stand, the Judiciary Pact for Racial Equity, committing all national courts to equity and human dignity, in addition to the recent approval of the protocol, which is a landmark in tackling racial inequality. This panel has already been informed about the topic that will be addressed by our panelists, and so I inform you about the resume of Dr. Fabio, who's here with us. Judge Fabio Francisco Esteves is a judge in the Federal Court of Law of the Federal District and Territory and an associate judge of the Supreme Court. He graduated with the Federal University of Mato Grosso do Sul. He has a master's in law at the University of Brasilia, a doctorate from the University of São Paulo, and he currently acts as an associate judge in the office of Justice Edson Fachin of the Supreme Court. He is a professor of constitutional law and administrative law in the Magistracy School of the Federal District, former president of the Magistracy Association in Brazil, and president of the Meeting of Black Judges Enajô and the National Forum of Judges Against Racism. And I would also like to highlight that we were there in Bahia between the 21st and the 22nd of November for a meeting organized by Enajô and Fonajuri, which was also very perspicuous for everyone there. He's the co-creator of the project Speaking Law for Education and Citizenship, a member of the Committee of the House of Representatives for Anti-Racist Legislation. He is also a member of the Auditors towards Racial Equality in the electoral process and part of the Judicial Court of the Federal District between 2018 and 2020. You have the floor, Dr. Fábio. Thank you, Judge Maria Purificação. Thank you once again. I would also like to acknowledge Justice Herman for many reasons. Justice first for this House of Citizenship receiving an event of the magnitude of this international symposium. I have already participated, at least in the last 10 years, of dozens of events within the judiciary branch, and this is the biggest event, not only in terms of the lineup, so to speak, but for how symbolic this event is for us in this December post-Black November. So this House of Justice, as was the case for the Supreme Federal Court on November 13th, when we had the people who protested in ADPF 635, this court is also changing its face, its color, and this is very impactful for the Brazilian society. I would also like to acknowledge my colleagues and fellow panelists that were chosen for us to deal with the judiciary policies in the National Pact towards racial equity. Since we know that the three of us will talk about the same topic, perhaps we should give an overview of the history until we achieved this pact and how we developed it. And I'm very proud to be part of Enajô here. And there are many other people, members of Enajô here, in the person of our National Secretary of the CNJ, and so many others. We had, starting in 2015, Resolution 203 of the National Justice Council to deal with racial quotas for Black people in the magistrate selection process. And in 2015, we were initiating the decade of the people of African descent in Brazil, and that's why the Council thought that 10 years after we would have 22.5% of Black judges in Brazil. And of course, the numbers are not only elementary for us to work with public policies, especially anti-racist public policies. And at the time, we had a lot of action on the topic, and we started to get to know the judiciary branch in terms of numbers, because in the previous census, we had information that was not made official by the judiciary branch, and at that moment, for us to be able to develop affirmative action, we had to collect data. And this caused a bit of concern, since the initial number of 18.4% Black judges present in the judiciary in 2015, or in the census previous to 2015, was actually 12%, 12.8%. Therefore, the provision we had made for 22.5, which in 2020 proved to be impossible to be realized in the last 5 years of the target, we went up another 39 years. And with that drop in the percentage, we will need over 70 years to reach that target. That was very important that we did that after Resolution 203, so that we would become mobilized to think about the efficiency of that affirmative action. And then we started studying how this specific action was being implemented, and also the others that were necessary. In 2016, we had the opportunity of starting to build this national meeting of Black judges and then the forum. In 2017, after having the first meeting here in Brasilia, we did the first meeting in 2017. In 2018, we had the second. And that's when we wrote the Brasilia letter that was delivered to the then president of the National Justice Council, Justice Dias Toffoli, who then tried to raise awareness among the institution. And we had the creation of a working group to think about some suggestions for judiciary policies. In parallel, we also had interventions with the magistrate associations, with the courts, and at the time we were developing the councils or the committees for race and gender within our courts as well. And of course, Inform was not left out of that process of starting to think about these things. Moving forward, we focused on the specific action of separating vacancies for Black people to enter the magistracy, and we came across several obstacles for the implementation of that initiative, like the very methodology of the test, the selection of the content, and then we move forward in the building of this public initiative. And we then move on to the administration of Justice Fuchs, and then we get to the administration of Justice Rosa. And that was a very rich moment because that's when we started thinking and executing the forum and also the development of the Pact that, much to our surprise, had 100% adhesion by our courts. And here the Pact, I'm simplifying a series of other landmarks that happened together with this development. But like I told you, when I said that the courts started coordinating to include in its structures race and gender committees, diversity committees, this was a very important movement. This was a very complex movement of back and forth, of course, a movement that has a certain weight and that causes some tension. We can't say that all of these things happened in a very linear or easy or tranquil manner. Often, we had to rethink many things. But all of that, of course, contributes to the National Justice Council monitoring and getting to know the Brazilian reality. Like, for example, some courts that have a total absence of Black people, or a court that has 1 Black judge, 3% Black judges, courts, big courts with very few Black judges, and also some courts that somehow mobilized to perhaps create some obstacles for us to implement some things like, for example, the quotas, the racial quotas. It's no secret to anyone that every 5 spots offered for Black people in the magistracy to go unfilled. And we were helped by the CNJ in finding out why that happens. And there we started analyzing these obstacles. What happens with the implementation of this affirmative action? But at last, during the Justice Rosa's administration, we had the national Pact for Racial Equity in the Judiciary branch that had 4 axes. And of course, the most important axis, which is very open, is the promotion of racial equity in the Judiciary branch. And we see that the others really depend on this, like, for example, data. It's impossible for us to produce data without it's impossible for us to have this inclusion policy without data, like, for example, censuses and other surveys that are very important for us in the judiciary. And since I already took up half my time, we get to the main question here. How can we build effective racial equity practices in Brazil? We have several. We have one that I'd like to emphasize in Rondônia, for example, which reserves 50% of the vacancies, job vacancies in all public administration for Black people. And this is something that currently within the public administration is one of the most relevant actions in terms of numbers. 50% of the vacancies for Black people in the Rondônia Justice Court. And there are other courts with its committees. We have campaigns, we have a series of anti-racism practices. And far be it from me to be pessimistic, it's important for us to also remain critical. We are here as a Majiedt monitoring this for 9 years. Very hopeful, resilient, excited, etc., but also realistic. We're very realistic. And it is evident that the CNJ in the last 5 years has made a qualitative and a quantitative leap. Currently, we have a racial equity award within the judiciary branch, materializing many things that the Pact proposes to be implemented. But like I said, regardless of my joy and enthusiasm, I am a very realistic person, and of course, I need to tackle a serious issue, and today I will
asking for favors, so to speak. Thanks to the will of the President Hammond that is allowing and making this possible. And when we think of the public Brazilian funding, it would at least from a patrimonialist posture and comes to a more managerial one. The budgeting now is a planning one. We have an LDO and a budget law. This group of laws, they are so that the public managers, administrators can do everything that has to do with the public institutions and the state. And I ask, where does racial equity institutions and the state? And I ask, where does racial equity enter there? Because I know no budget that does that. So, where is the thing that we can produce something that is genuinely a need of the Brazilian state? The Brazilian state to recognize that there is a debt, not just historical, but current and present with the Black population. The Brazilian state has just been condemned for 11 Black people that disappeared by the Inter-American Court. And this Brazilian state does not include in their budgets, include this. Within the judiciary branch, which is here, and the judiciary branch certainly is at the center of this responsibilization, of this accountability of the Brazilian state.
A questão racial do Estado brasileiro e outros que vieram, não tem nos seus orçamentos.
It does not have within its budget a specific budget to promote inclusion, not just inclusion, because inclusion is only one of the policies, judiciary ones, for racial equity. Because depending on one administrator or another, and then we must recognize the posture of the administrates or manages to do something or another, but I'm not going to be okay with a judiciary public budget that has a commitment, and not just a public commitment, but a extensive one, to have 100% of the Brazilian judiciary that does not have the essential tool, which is the budget. So we went to Bahia. How do we do Bahia and organize things there? Is it possible? Can we organize? And we depend again on the goodwill of the public ministry, of the administrator. We have to go to São Pires to have the 7th meeting of judges. We have the 7th meeting of the 4th forum that are discussion spaces that are indispensable for this discussion. Brazilian magistracy has a series of segments and forums. One of them, I'm not saying the other four have sponsorship, but one of the places that we have to actually go in depth and discuss the proposals that we are discussing here is done, asking for favors. We analyze discussion place to deal with this, to put this into practice, thanks to the generosity of some people. So the challenge that I'm launching here is very simple. Budget, money, because... And I have been participating in the last 10 years. There are many things that are taking place in the judiciary to think, to reflect upon, to propose issues on racial equity. And I always think, I remember that we were at an event that we were trying to do an event, and we simply did not have a place to do an event. I'm going to be a little bit... The place where we had to have the meeting was simply not adequate for that. The institution that generates a more difficult proposal, and we just don't have budget for that. I'm not going to say that your reflection is this. I'm proposing that we demand this. Clearly, there is an unsatisfaction of my part, because it's very nice to look. We have a national pact. Yeah, it's very beautiful, wonderful. And all the people that have been involved in this, Minister Rosa, that led this entire task. And we recognize that is an extremely difficult task, counting with tens of courts. Now we have 92 courts in the country. To have all of them in this pact is no easy task. But that cannot be it. History is going to demand that we do more. And now we are in that situation. We can't go back anymore. So we created a pact of a huge symbology. This symbology now must become something concrete, and it depends on budgeting. Budgets. Just give me a budget, even if it's a tiny one. Please make real what our Constitution says when we're talking about public policy, and there cannot be public policy without a budgetary planning. So that is the challenge that I put forth, and I thank you, Appellate Judge, once more for this debate, so that we can truly take this on. I'm not saying here, look, no, that there not be resistance. Of course, there's going to be resistance, because we have very few resources, but this has to be debated. It has to be included in the debate, in this power dispute. We're talking about budget, we're talking about political disputes, and the racial question that is a political issue, because racism is a fight for power. So I cannot talk about something that is a fight for power that puts a hierarchy to people without doing this. I do not have real hope if we fight like this without a structure. If we want this to happen, we must have the necessary weapons for it. Thank you. I thank and congratulate Your Excellency for the issue that is being brought and that for giving the due importance in regards to the budget, question of budget. So I say to all that are here, especially to Your Excellency, that in Bahia, the Justice Court increased the number of quotas to 30% through the program that and the resolution that demanded that 20% be set. It's still not ideal, but it was already a step further. Also, the question that you mentioned of the prize and the court. Well, look, I'm just making advertising for the court that we won the second place of the National Justice Council for racial equity. So our president recently received that prize here in Brasilia. And this budget issue, it is problematic for all that are part of the judiciary, because it's the difficulties that the courts face, because the budget is always smaller than what is necessary. Because whenever we have the opportunity to do something more, we face difficulties. And we have to really fight in the sense that we have an improvement so that the ideas and the measures can actually take place. Otherwise, it's just on paper and we don't go anywhere. We have been walking towards little by little, even further, but we must go yet further yet to give bigger leaps, but in a way, we are walking slowly, more slowly than would be necessary, but we are. But we must be optimists. We will overcome difficulties. I would like now to announce Dr. Joaci Dias Furtado, that is our judge here of the court of the state of São Paulo, an auxiliary judge of the National High Court, postgraduate in civil procedures, postgrad in public law, postgraduate by the School of Magistracy, bachelor in history by the University of Brasilia with the UNB. Thank you, Judge. Thank you, Maria da Purificação da Silva. In your name, I greet all here at this panel with special warmth. Not that while this is not special, but Fabio, that was my professor in 2005 to 2007 in the magistracy school here of the Federal District, before a professor and now a bench colleague. Before starting my speech, I would like to comment that the Justice Court of Bahia received us at the end of November for the Inaju event. Why is that important? Because sometimes even the acronym itself is not well known. Inaju is the national meeting of Black judges, Brazilian Black judges. Perhaps this is news to you. Why? Because we didn't even have Black judges. So from 8 years back to now, it is that we have been having this. And this event is the most expressive presentation that a racial question in Brazil is something that subject must be debated. It's an international symposium. So it's not just the Brazilian vision on the affairs of South Africa. You've mentioned in here since yesterday, the vision of the US was also presented here in 2 different occasions. And now Brazil, that has a huge responsibility, Fabio, because I'm talking in name of the justice system and in command of my boss, Minister Herman, to look from within the justice system, a look on racial equity from within the system. I'm going to do my self-description because part of the protocol, and I've learned many new things. You will notice when I'll do it. I'm a black man, over 50 years old. My hair is a dark brown, already slightly white on the sides. I am wearing a black suit with a white shirt. I have a cufflinks so that I can be in better presentation, and a purple or wine-colored tie. I've brought some special invitees here. My speech starts with a question, Professor Pedro. You thought I wasn't gonna ask you or anything. So the question is the following thing: how to build effective promotion practices of racial equity in Brazil. Each of these words is important. So I start my question already trying to give answers. The special invitees here are already part of this attempt to answer. There is a part of people here that are almost everyone the same t-shirt, but it's on purpose. They are collaborators, service providers, third-party service providers in the digitalization process of the STJ. These people, I've already said this more than once, I know it's being repetitive now, but they have made a true silent revolution in the justice system. But an extremely loud silence. We changed the paradigms of the justice system with the digitalization of the process. Why? Because the previous physical processes or procedures where we used to cut our fingers on the paper or on the bailarina, which translates to the dancer, because it was made of metal, and so we'd cut ourselves. They managed to help us to get rid of the bailarina, of the paper. So I'd like to give them a round of applause, please. Since my speech deals with inclusion, I thought that it's very relevant with the recently Pact that has been promulgated, that has been approved by Brazil, including our constitutionality block, a pact against all sorts of discrimination. And there's an interesting expression there of multiple or aggravated discrimination. What does that mean? A woman, for example, that just because she is a woman is obviously already discriminated against, or is someone that does not agree with this, or she could be discriminated. And she's black, 2. If she has some hearing impairment, 3. And then you can add several other forms of accumulating discrimination that impacts differently with each person that is the objective of said discrimination. Also like to ask to be part of the table here. It's only figuratively, okay? The Commission of Racial Equality here of the STJ to help me create this work from the very start. When I arrived here at the STJ, they observed me from afar. And I am sure that they thought the following things. Who is that judge that arrives early at a court? Oh my God, 9 a.m. He's there. He goes to the library, requests books with different books that the people in the library don't even know what to do. So they said there's an interesting sense of the social movement I learned in some years in Belo Horizonte. Nothing about us without us. Nothing about us without us. And so here you can put any us within. The hypothesis is with a committee of a racial equality to have racial equity without the commission, without the black civil servants. There's just no use or effectiveness. They must be together. The black population, that is the receiving end of the policies and victims of this entire situation. Everything that is being said about black population, indigenous population, there is absolutely no sense to talk about it in our cabinets.
It just makes no sense. I know that I can be assertive, but you get used to that until the end of my intervention. The people at the journey got used to that very quickly yesterday. But it makes no sense to talk about the black population if they are left out of the conversation, because we will do completely baseless policies that are not effective. As it happens in the professional careers, where you define, oh, how is this person work supposed to be? But have you asked that person? It's like giving a child a medicine. Oh, take this medicine. It's good for you. Well, you tried taking the medicine then. And the Racial Equity Committee, presided over by Alisson and Jessica, I did my work trying to first understand what would be the design or an overview of the judiciary branch currently. And instead of one survey, I did two surveys, one of the academia and one of the judiciary branch. And the judiciary branch, I use a diagnosis by the CNJ, the racial equity diagnosis. And the other one was by the Getúlio Vargas Foundation. And especially the Getúlio Vargas study really caught my attention for several reasons. One of them is that it was drafted, and I checked with the researchers, only by women. And I knew that women studied much more than us, but this was very evident through this research. The people in public administration and constitutional law at the FGV did a very interesting research about the judiciary branch, and they made 250 complaints and demands. And one of them was, look, and they say it just like that. They say, look, you judiciary branch don't know who are your judges, your workers, where they are, what is their age, what is their gender, and if they effectively joined the career, if they remained in the career, if they advanced in the career, they retired, they left, you don't know anything. We were the ones who had to look for the numbers, and when we find the numbers, your numbers are a mess. And, well, their study is a bit dramatic. And I did somewhat of a lab with the workers here at the STJ, with Lugina and Walter. And we did a technique that in the public school, right, Adriana? I already mentioned him 3 times, called an active search. What is an active search? Well, when a student, especially in the public system, starts missing school or getting low grades, the teacher, they let the coordination or the principal know, and they go after that student to know what's going on, because sometimes that child is being abused, or they're going hungry, or they don't have the materials to attend school. Oh my God, Dr. Jaci, does that exist? Yes, it exists in over 80% of the population. They don't have comfortable chairs like ours here, the huge majority of the population. And our active search, what we do in the lab, we found the group of the first interns that worked in the STJ. And I found Dr. Ronald, I have to refer to him as doctor, otherwise you won't like it. Please stand up, Dr. Ronald. This is Dr. Ronald. He currently is aware that he was one of the interns here for the quota system. With the journalist archaeology that we did, almost like an archaeology, right, Maria Paula? After the first interns that worked here, and before the quota system, the STJ did an agreement with the University of Brasilia and hired these boys, and you're still a boy, okay, Arnold? And they worked here and did their time. In the case of Arnold, they took the bar exam, got approved in the bar exam, and when I took it back in the day, only 30% were approved in the bar, which is a huge achievement in the life of a lawyer, and he currently is an activist and a lawyer. And curiously, once again, the history of the girls. I wanted only one representative, and I got 5. And I interviewed them in my office because of the general data protection law and everything we need to request for informed consent. Can I state your name? Can I publish your picture? And they joined the STJ as technical workers. They participated in the selection process, and some of them continued working here. And we have one of them here. Can you stand up again? So, just to show you, of course, the laboratory was pretty simple, few workers, few interns, but it is possible for the judiciary branch to identify its interns, its workers, its judiciary analysts, its security staff, its judges who are Black, how they join the institution, if they remain in the career, if they made any advancements. And the lab has been created, and that's the challenge for you. And the diagnosis here are the ethnic racial diagnosis, and it's interesting to say that both for the judiciary power and for the Getúlio Vargas Foundation, both diagnoses are quite similar. What did they find in these diagnoses? A predominance of white judges, which is almost stating something obvious. And why is that? I'm not the one who said that. The justices here in the STJ have repeated how many Black justices do we have in the Supreme Court? 0. How many do we have in the National High Court? 1, Benedito Gonçalves. And in my group in São Paulo, we have 13. Similarly to my brothers here, we have other 2 here. There is a curious book which was called There Were 6. But the title in that case would be wrong. It should be called There Were 13. We were a pretty big group, 5 girls and 8 boys. And they had a low representation of Black people in leadership roles because it's not enough for a Black person to be a part of the structure or the institution. They need to be in leadership roles as well. And the challenge in data collection that the researchers mentioned, well, it's very hard. We can't find your data. And the advances, like Fabio just said, the advances weren't that substantial. At the time we drafted the Pact, the estimate is that we would reach 22% of the vacancies in the magistracy when in 2044, 22%. But why that assertive justification? The population that self-declares as Black in Brazil is between 55 and 56%. Is it reasonable for us to have a percentage that Fabio already mentioned of about 12% of Black magistrates? I don't think so. But it's just my opinion. Since our panel is a question, I don't have any deterministic answers for you. And the second panel, and I'll even give you some extra time to copy the name of the survey, Karen Luisa accompanied very closely this study that operationalizes racial equity in the judiciary branch, and the researchers in this case were very harsh with us. We reached several conclusions, like data scarcity, like I already mentioned, lack of transparency in the information, and this phenomenon that I'm going to mention of the de-racialization of the candidates to become judges throughout the selection process. And what is that? I know we have representatives from the US, and I hope I am not making an offensive joke here, but it's as if we were whitening as we move forward in the selection process. We become whiter, we disappear. But what do you mean we disappear? Well, after the first phase, where we have thousands of candidates that self-declare as Black or mixed in judge selection processes. And the selection process, if you don't know about it, it is composed by 3 phases that unfold into 7 phases, 3 phases, an objective and a subjective test, where you, and an oral test. And we also have psychological evaluation, a physical exam, and you can be eliminated in any of these phases. And as the selection process evolves, the thousands of candidates that had self-declared as Black, they disappear because the lists are not systematized to identify that, while Joaci joined between the 6,000, remain between the 1,500, and I'm repeating the numbers of my court in São Paulo, and he was positioned among 223, and then among the 126 for the oral test, and was approved between the 81 that were approved by the end. It is that history that the selection process uses. And the researchers looked all over the country, so it's not just a hypothesis, it's a fact. The courts have little knowledge about affirmative policies. And Fábio recently said in the Correio Brasiliense paper, if I'm not mistaken, that affirmative policies are not only quotas. It's not only saying in the selection process we have vacancies for Black people. It's not just that, but these affirmative policies are not really known by us judges. There's almost a lack of interest in that topic, affirmative policies. And this is a challenge to the academia, to the CNJ, to explain why. There's a resistance to inclusion upheld by a meritocratic discourse. And this meritocracy word always gives me the itch. And why is that? Because meritocracy, I usually believe that when people talk about meritocracy, not even the person who is saying that word knows what it means. People always said, and it's kind of something that is mixed with the theology of prosperity. If you make an effort, you're going to win. Believe in yourself. Look, this person was approved, but is that really the case? Are you sure that for 80% of the population, the Brazilian population, that has big families like my own, will they all have the same conditions to develop themselves? And I'm giving the example of my family so as not to point fingers. That so many others that were created with many privileges, like air conditioning, drinking chocolate milk, being driven every day to school in an expensive car, and I'm talking about my son. In the best schools, we have access to all training courses. I paid for training courses, 2 different training courses for him to take the exam to be approved in university. And while affirmative actions have not altered, very institutionalized practices that are ingrained in society. The strategies are here divided into four, and I'll just mention them briefly so as not to go over my time. Systematization of data, capacity building, and awareness raising, and the diversity and inclusion policies, in addition to partnerships and support networks. Very briefly, the CNJ has done a partnership with the private initiative to fund scholarships for the 100 best positioned people in the national Justice test. And I had a different opinion, but I was duly instructed by Alison and other colleagues, because these people, even though some of them already work, the competitiveness for the magistracy test is very aggressive. You have no idea, because I'm talking to people who are not initiated in this. I'm talking to the general public. In order for you to be approved in a magistracy test without fraud, let's not mention fraud, and that is fraud, actually. Well, there are some professors that say, oh, I went out drinking the previous night and I got a wonderful score in the test. Well, that's a lie. That's fake news. And I don't even like foreign expressions. It's a lie. It took me 10 years as a whole to be approved in this test. And telling someone, it's easy peasy, you can do it, don't worry, well, that's a lie. And you even diminish the quality of those who made an effort, a brave effort to be approved in that very hard test. Like the story in Fabio's book, it's there, it's written, and we see that our stories are intertwined, almost all of our stories here, especially if you're a bit older. Partnerships and support networks, and we can skip that one too here, capacity building and awareness raising. Can skip that one. We don't need to show the statistics because they already know that over 80% of state judges are white. This is self-evident as well. Capacity building, awareness raising, and also mentioning what has already happened in the justice system. We don't really need to go into detail.
Eu não estou conseguindo passar aqui.
I'm not able to go to the next slide.
Pronto. Política de diversidade e inclusão também.
Diversity and inclusion policy. Also, to exemplify what Fabio said, Equity Network has also been mentioned here, and suggestions. And I think this is interesting because the academia and the CNJ in its diagnosis have suggested some very interesting things. Others are suggestions by the Racial Equity Committee here in the CNJ. Suggestions, some of them are more radical. Monitoring Black judges throughout their careers, a softer suggestion, the application of quotas in all phases of the selection process with specific lists to know who these people are. The principle of publicity as well. Regionalized discussion about a minimum percentage. Appellate Judge Maria da Purificação said that in Bahia it's 30%, Rondônia it's 50%, and as a minimum limit, because the quotas law says that it's at least 20%. But where do we usually stop? At the bare minimum. We have standardized the discourse, and we don't even reflect. We don't think it's necessary to have a deep discussion. This is the minimum. Does it say that 20% will be reserved? No, the law says minimum 20%, because each state in Brazil is different from the next, especially in terms of racial configuration. I think Bahia has over 70% of its population as a Black population. And there are places where we have about 30%, like Paraná, especially in the Curitiba region. So it doesn't make sense for in Bahia having a 20% quota because that quota will be pretty much residual. The inclusion of the racial criteria in the requirements related to merit and gender. These are suggestions by the academia. Of course, we need to consider that the CNJ has worked very strongly. Regulation and the steps are small steps, slowly taken. We can say that it's quick, but in my opinion, the steps have also been firm because, especially when it comes to setbacks, we have not given in, especially because of the type of obstacle we're facing. Symbolically, the presence of this audience here in the STJ auditorium, it is an anti-setback obstacle. Of the qualified presence we have had here, and we still have the presence of Professor Thula, Professor Adilson, Professor Inae, who gave a master class yesterday. I thought no one else in the world like history. So, and I was very happy. It brought to the center of the debate the racial issue and in the court of citizenship, as has been mentioned here.
But this is effectively a barrier. So despite the steps having been slow, without wearing any rosy glasses, but ending, I had agreed with Fabio. Did you do what we agreed on? See, we agreed on everything beforehand. The following. You have 10 seconds, at the exception of those that are here at the table and their colleagues of the Black movement. Just the general public here. You have 10 seconds to tell me who this is. If you don't know who it is, that's fine as well. Just one person. You are from the Black movement?
Ótimo. O senhor acabou de ganhar livro.
Great, you just won a book.
Eu estou fazendo cortesia com o chapéu dos outros, com o livro dos outros. É o livro do Fábio. Eu comprei.
So, I'm giving presents that actually belong to other people. It's Fabio's book. So, Luis Gama, since we started with Bahia, I thought it was a good homage to pay. He was an illustrious Baiano person from Bahia. But why does only one person know his name here in this public? On purpose, his person, his history, and his work was erased. Well, thank you, Fabio. I'll pay you at some point. I'll put it on my tab. It was erased on purpose. I was interested in him, started being interested in him only a few years ago. I did a 4-year history course, and I only heard speak of him once in Boris Fausto's book. That's only for people who are actually in-depth in this subject. Professor Thula, you're there? Boris Fausto is a traditional historian here in Brazil, Brazilian history. It's as if it was vademecum in law. You just mentioned him. Luis Gama was a writer. He was a jurist, a patron of lawyers and of the abolition. If I ask here, Nabucco, how many have heard of? All of them. Why? Because it's the name of our Brasilia's University auditorium there. This is just one example of several people that have been erased in history. Why is his story really interesting? Is the example of an expression they use a lot, that knowledge frees. Luis Gama is exactly that. He was born free, was sold, was born free in the 1830s, was sold as a slave by his own father, was enslaved for about 7 to 8 years. was he learned how to read by someone that taught him in his owner's place, and then from reading on his own, he studied the norms and proved legally, through the judiciary, that his enslavement had been illegal. That trajectory is represented in the long work of Professor Ligia Fonseca, also represented in the more recent book I read by Bruno. He's just come back from Germany, from his Oxford. So I'd like to end here with a message from Luis Gama. I'm sorry, I was a professor for some while, so we see an audience and microphone and we get excited. So dear President, I have just read the issue against the citizen José de Patrocínio. In us, the color is a defect, the vice of an unforgivable origin, a stigma, a crime. There is no point in, it is important and even useless to say that this color is the origin, the riches of millions of people that insult us. I marked stigma. Why? Because I have to tell you another story. I was a teacher, a student at graduation. At the end of the day, you'll know everything about me. I was working on something in something English, and instrumental English too. And there was a selection for a teacher, a language teacher, and the teacher used as a lab its own class, her own class. So there were three teachers: a white teacher, Brazilian, a white, blonde, blue-eyed, very good-looking man, and the black teacher, really quite dark. The best class was of the dark-skinned teacher, because she requested that we also vote what the best lesson had been. So we all voted, and we all chose the black teacher. But of course, he was not chosen. Obviously, this was in the 90s. I entered the Brazilia's university in the 90s, and he was not chosen. And the class asked why. Why was such this teacher not chosen? And without, from the height of her anthropologic knowledge, she gave me a class on the stigma of black people. Look, his class was fantastic, but he has the stigma of the black person stigma. And I insisted. I was really young. I wasn't easy to appease. And I said, teacher, excuse me, the only black person in the class. I said, what is that stigma? He teaches upside down. Oh, he speaks inside. He doesn't really look at you. I continued not understanding. I said, teacher, I'm sorry. I still do not understand. She said, what do you mean you don't understand? You want to talk about the side that is left of the pen? Yes. Have you read this book? Yes. What does it have to do with this, with the black person? And I'm not like that. And I looked directly to her eyes. So this issue of the stigma is created historically, culturally, socially. It is not ontologic. I have to say some beautiful words, Pedro, otherwise they'll never ask me to come back. It does not refer itself to the person's essence. It is imputated in a draconian manner, put onto the person, the personality of black people in Brazil. So it's against this stigma that this symposium is also getting together with a message at Luis Gama that says like this: my dream is an American Brazil and the lands of the Cruzeiro without kings and slaves. That is my message for you.
Agradeço e parabenizo
I thank and congratulate Dr. Joassi for his information, for the manifestation. And Dr. Joassi, I'd like to give an information to Your Excellency, is that you concluded speaking about Luis Gama, that the Justice Courts created a medal called the Luis da Gama Medal that deals with racism as an institution, etc. You created this medal, but where we had an evaluation with a prize of institutions that signed up, that there was an institution, therefore, that was chosen to receive this medal.
Dando continuidade ao nosso painel, eu chamo agora o nosso
Continuing our panel, I call upon our Professor Wallace Corbo, Professor of Constitutional Right in the University of Rio de Janeiro and in the Getúlio Vargas Foundation, FGV. Doctor by the University of RJ, was a researcher at Harvard, Professor of Postgraduation Lato Sensus of the School of Magistracy of the State of Rio de Janeiro, of the Brazilian Institute of Teaching, Development and Research, and of the Superior Lawyer Advocacy School of Rio de Janeiro, Constitutional Professor and Administrative Law of the Rio de Janeiro University. Professor Wallace, it is a pleasure to count with your presence here at this panel. The floor is yours.
Não tem, não. Alô? Agora sim, muito bem. Muito obrigado, desembargadora Maria da Purificação. Eu quero agradecer.
Thank you very much, Dr. Maria da Purificação. Manifesting thanks in your person for the invitation to participate of this historical symposium, very exciting in many sense, and I also greet the members sat at this table. I promise I will be brief, which is the worst promise that you can hear from someone who promised, who just got up to talk. Listening to what Dr. Joassi said about Luis Gama, I remembered that I wanted to start talking about the enfiteuse. Enfiteuse is leasehold, is a right that is given through which the owner gives the other the use of their property. So they.
E apesar disso, por alguma razão que me foge completamente ao conhecimento, a enfiteuse continua
So they
sendo
prohibited any kind of emphitose. And so one was taking a lesson of real rights and civil rights.
Faculdades de Direito Brasil afora. O que não toma dia de aula é, por exemplo, tratar de
does not take long. An entire day is to deal with Luis Gama or civil rights of the best or even the less better Brazilian law faculties to deal with civil responsibility in regards to discrimination. What does not take time of the universities in the whole of Brazil is to deal with the penal code of racism, which is racism within the letter of the law. And as we continue believing that right is emphiteusis or land lease, we continue reproducing the same logic or ideas that throughout time allowed a continuity of discrimination. One of the aspects that came up in one of the points that were presented by Dr. Joassi about the policies implemented nowadays in the judiciary is that very often in the research of the FGV, the affirmative action ends up not changing the institutional practices. Because, by the way, in several hypotheses to think about this, one of them is that if we continue considering to admit people in the judiciary career, that the merit that needs to be evaluated, the success to be evaluated, is to decorate the Landleys and Fituses, which I admit I read the definition because I didn't remember anymore the definition because I'm a constitutionalist. But if this is the knowledge that we evaluate, it is not surprising that the candidates that do the work, do good work, well done, and when they enter, also do not have the necessary tools to implement changes of behavior, aside from other reasons that can imply the continuity of said behaviors. This is central to it because as we consider that the horizon that we're searching is a success, is a merit, defined from the legal perspectives that continually discriminate, we are not simply going to be able to alter the institutionality because only enter people in institutionality who have an institutional thoughts. So the successful CEO or magistrate, the rich and successful person, in reality, they are successful because they continue repeating the same thing, perpetuating the same things. Of a member of the court and say, of course, the 70% of people that die in conflicts, no, because of police or state agents are black people. At the end of the day, 70% of the people that live in favelas are black. It's justified. So why does this happen in these places? Why is 70% of people that are in the peripheries or in the favelas black people? We think and continue thinking of the discrimination as an external phenomenon to the institutions, as something that is just random or something sad. Racism exists, racism is bad, that's an inequality, inequality is bad, that's sad. Some of my students ask, let's think on strategies. It's something I always give them on the first and second classes. I would like you to think on strategies to fight racial inequality in the judiciaries. You always come back with the same answers. We have to change the public education. They're in the very first grade of public education. We have to sensitize people, raise awareness. Rarely do any of them give me legal answers. They give me answers for things that they're not even studying or not going to have a degree in to implement. They say racism is something external to institutions. So it is necessary as a central premise to think of these legal judiciary policies that transform and promote some idea of racial equality. We must leave aside the land lease. If someone likes FTOs, you can have with FTOs, but just cannot, it's as an exotic subject, but we must collectively leave that aside to deal with the problem as a legal problem, which is a legal problem to deal with racial discrimination, not as a fatality. Because for fatalities, us lawyers, professors, magistrates, we are not trained to deal with that, but with the law, we are trained to deal with. So the first premise I'd like to put forth is that the inequality in the judiciary and from the judiciary is not a fatality. It's a form of discrimination as already conceived. It was mentioned already in several moments here. I will use the Inter-American Convention Against Racism. It is a sort of racial discrimination, sometimes direct, sometimes indirect.
Se nós estamos tratando de discriminação racial direta,
If we're dealing with direct or indirect racial discrimination, we're dealing with the thing that is far more recent, more obvious in our realities. The last I'm going to talk about emphytesis or long-term lease, because if we search in the silence, we can find this, but we do not find it nowadays. With the normative designs, what are the racial barriers that are imposed, be it to enter the judiciary or to act within judiciary power or branch? But if we look at the numbers, we need yet another 60 years maybe to reach a percentage of Black people in the judiciary. If we look at the numbers, that we find out that judges are systematically discriminating against the Black population or decide this, that we are facing the idea of an act or joint actions apparently neutral in regards to race that produce a specific disadvantage to a protected group.
We are faced with a problem that is very well positioned in our constitutional system, and we are faced with a problem that has legal solutions and legal designs established within our constitutional system. The concept of indirect discrimination is over 60 years old in compared law and international human rights law, and the solutions to it as well. The solutions to indirect discrimination to public or private policies, affirmative actions, affirmative policies, the names vary, or special measures. They always touch on reasonable adaptation measures that may adapt the environment to the needs of a person or group that were not accounted for in the normative design. And of course, indirect discrimination also implies civil and criminal responsibility if there is the cause of harm. But what is the problem then? Why do we have that concept for 60 years, but we are still unable to implement it? Well, because we continue treating the right to equality or the right to not be discriminated or racial relations as something that is separated from law. There's a very famous anecdote of a student that comes to a symposium, a congress. She doesn't really know about what it is, but it is on some legal topic, and someone says to her, "Come over and I'm going to show you what's going on." And she goes through hallway number 1, and she looks inside the room and sees many people in the panel. And she thinks, well, this must be the gender panel. Moving on. Room number 2, she looks inside, Black people. Oh, this is the race panel. Room number 3, she looks inside, only sees white men in the room. Okay, so now we're dealing with civil procedure law. So dogmatic law is the place of white men. The other ones are just niches. And if we keep thinking like this, it will be hard for affirmative actions to be implemented and to create the transformations that we need to create. Of course, in spite of this, the action of Black people within and outside the judiciary branch is, as was well said by Dr. Fabio, found in the institutional gaps. Luis Gama is an example of an action in the institutional gaps. He acted in causes that we currently refer to. He acted in causes asking for the freedom of enslaved people in a country where there is slavery. And this wouldn't necessarily end slavery, but within the possibilities given by a racist legal system, he thought, how can I work with legal concepts, with real law concepts to recognize this person's freedom? And based on that, he explored these theories. But look, if we don't alter the premises of knowledge, the epistemological premises of law, there is a limit of what we can achieve. And once again, listening very attentively to Dr. Fabio, I think about how often any ideas to promote anti-racism or equality often goes against other ideas in vogue that present themselves as an obstacle. So everyone has heard the saying, the blanket is short. If I pull it, I will uncover my feet, and if I cover my feet, I will uncover my chest. And this is, in legalese, the reserve of the possible. The budget is not enough. We need to make tragic choices. And who's left out in this? Oh, well, the anti-racist topic, the gender topic. And the discourse is not necessarily contradictory with anti-racism. Actually, we use an aesthetic anti-racism. I project, let's all end racism, but in practice, I say, but we don't have a budget, but I have to make tragic choices. When in reality, that justification hides priorities in the allocation of resources. They hide priorities of what I understand as important in a magnificent auditorium. This auditorium was built, and it was definitely expensive. All the time, the public power makes choices on how to allocate resources. So there is a choice being made. Economists say that there are limits for the budget. That there is a question, which is, what do I prioritize? What's the use of adopting an anti-racist discourse if I don't recognize that where racism is substantially produced today in Brazil is in working relationships, which are informal, which are precarious, and have been increasingly treated as if they were contractual and egalitarian relationships. If I don't change the premises, and if I don't understand racism as also the basis of our legal logics that have normalized for 35 years that the citizen constitution, that the Constitution of Fundamental Rights should not protect domestic workers, if I don't change the premises that brings outside of the legal tutelage hundreds of young Arab black men that die every day. If I don't change the premises, I in fact can change, or I have an extreme difficulty in changing results. Therefore, we have many normative paradigms. We have a constitution that is normatively well positioned. We have an inter-American constitution that is very well structured, that is part of the Brazilian constitutionality. But the question is, how can we think about changes that are at the same time here thinking about the Pact for Racial Equity, thinking at the same time about a change on legal knowledge related to the continuous training of judges, in addition to the disciplines demanded in the public selection process. How can I change legal teaching, and how can I influence practices within and outside the judiciary branch? We need to stop thinking about criminal, civil, and then anti-discrimination law. It's not enough because this is just an added discipline in legal school, and the students say, oh, I need to memorize this to be approved in the discipline, and that's it. I go to an class, there are 5 to 6 questions about anti-discrimination law. I answer these questions, and then I answer a question about the tax law that Brazilian taxes unfairly impact Black people. But we don't look at tax law from a racialized standpoint. And some judiciary policies that have already been implemented will directly meet these goals. And here I'd like to draw your attention, obviously, to the protocol for a racial perspective trials. Because what does the protocol do? This protocol imposes a cross-cutting analysis of law and of the action of the judiciary branch in light of racism, instead of saying in a separate manner or something that is separated from the action of judges, that it's important to study about race in Brazil. The protocol says, look, at the moment when we are conducting a hearing or when we are collecting a testimony, you are following the procedures of the Criminal Procedure Code or the Civil Procedure Code. You need to be attentive to how the racial issues appear in that reality. And for a judge, in the day-to-day of their work, it's very scary because they will say, what do you mean? I am completely neutral. I was trained to be neutral. If I use the racial perspective, I stop being neutral. And then I can perhaps cause harm to people's rights. But when we racialize judicial action, on the contrary, the judge understands themselves, or may understand themselves as white, and even understanding themselves as white, they can understand how that constitutes their supposed neutrality, which is not neutral. And once they see themselves as white, the judges also understand the individuals they're making judgments on from their own racial perspectives. Perhaps distancing themselves enough from these people enough to perceive the need for special measures of tutelage depending on the person, or a differentiated manner of analyzing the evidence. And look, that's law. We're not saying the protocol doesn't tell judges to be philosophers or sociologists or anthropologists. Because in law, when we try and do philosophy, it usually goes wrong. One of the biggest tragedies has happened when we try to be philosophers. And that's not it. It's understanding that the application of law goes through the exercise of sovereignty in jurisdiction of the members of the judiciary branch, and this demands understanding who are the subjects of law and of rights who were not seen like subjects of right up to then. So first and foremost, the protocol, moving towards the end here, because I promised that I would stick to my time, the protocol, it meets a central goal of not separating the judicial action from a racialized perspective. The protocol is a judiciary policy for the promotion of racial equity. Its very existence can guide judicial action, because good judges, eventually, because the life of a judge does not allow, good judges who need that guidance on how to proceed now have a reference to follow.
Só que nem só, né, doutor Fábio, não só de bons magistrados, de bons
have good judges or good chief justices or people with good intentions, because our institution is very big, the judiciary branch or modern state. There are people who don't want that, who are not going to do that, who have no intention of doing that. And here it's necessary to think that if on the one hand, racial discrimination is institutionalized and it is institutional, if it operates through the functioning of the rules, it's not that things went wrong, like said Professor Thula. It works well for the purposes it was created. So if racial discrimination is institutional, the response to it must also be institutional. We need to implement measures that create specific rules to be followed by judges and by legal practitioners, whether they want to or not. And this can be done in two ways. This can be done through a mechanism of command and control that creates mistrials when a decision where an activity doesn't follow certain standards, it can also be created through incentives to which the institutions can respond. And this, also in the field of the judiciary, would be a performance indicator in the promotion of racial equity. So the idea of starting to quantify, and this work by the CNJ has a huge potential, start quantifying how much the courts are meeting that pact. Because if the person isn't doing that on their own because they have good intention, well, the Chief Justice of that court doesn't want to look bad if compared to other courts, right? So this moves away from that field of just saying, well, this is so nice, it's so fair, it's so beautiful. And going into the field of what is valid and what is not valid, what can be enforced and what can't be enforced. And the question that Herman Benjamin made in the beginning of the panel is about how can we implement efficient measures. And of course, the answer on how to implement efficient measures in general involves a compared analysis. First, to find out what is the country in which we implement an anti-racist judiciary. I haven't really analyzed all countries in the world. I will probably do that someday, but so far as I have evaluated, this is an enterprise that hasn't been successful yet anywhere in the world, which means, of course, that the search for efficient measures is very experimental. And the only way to find an efficient racial equity promotion measure is trying some measures, some of which have worked, some of which haven't worked, and monitoring the measures that are implemented. But it is also understanding, first and foremost, well, not first and foremost, because I've been talking for a while, but it was understanding a quote that was very much attributed to the economic analysis of law, which says, rights are not growing on trees, and we can't collect rights from trees like fruit because we can't find rights under a rock. Because like in Roman law, people searched in the nature the answers for people's rights, but the answers for our problems are not in Roman law and are probably not in Brazilian law that exists today. Everything that exists in terms of policies that have been implemented was created from a very relevant, collective, and historic action of concrete peoples and groups, which throughout Brazilian history have advanced as far as possible and even beyond that. And here I want to draw your attention, so as not to run the risk of forgetting history, that if today we deal, for example, with affirmative policies like we're dealing with today based on a perspective on how to improve them, this reality was very different 20 years ago. I am used to saying that the State University of Rio de Janeiro was the first university to implement quotas, but we forget that the first time the quotas were implemented, they were declared unconstitutional by the Justice Court of the State of Rio de Janeiro. Therefore, the judiciary power in the past has not been an ally of measures to promote racial equality. And if it is today, this didn't happen out of nowhere. A light bulb didn't go off in the heads of a group of judges that said, wow, we've been forgetting black people. It was actually flesh and bone black people that do this inside and outside the judiciary branch. So, beyond celebrating these people, I would like to say much more in terms of an agenda than anything else, the steps to be made, because the entering of these people in the judiciary branch, the formation of this panel and the very existence of the event says that we are living through another phase of the judiciary branch. Not to say that there is no promotion of violence in the judiciary branch, but I want to say that there are spaces in the judiciary branch where it is possible to implement dialogue and to seek out possibilities. So we must expand these spaces so that through these attempts, some of them will fail, some of them will be insufficient, others won't. But we need to effectively look for a society where law is considered based on its recipients, not to exclude or to subdue, but to recognize their condition as the subject of rights. And lastly, I need to say one last thing. We can't run the risk of saying that there's a treasure that is being denied to Black people. But Black people, everything that they want is being where we think is good for them to be. But Black people are marked by the lack of full citizenship. We need to think about this differently. There's a reason for the opening of the judiciary branch, and it's not because we need to deliver things to these people, but because these people have potential, their strategies and knowledge in Black people.
But when they do not enter the judiciary power, they make this judiciary branch of power even worse. So let's continue building a better judiciary power with Brazilians, that it's more than time to be part of this. Professor, thank you for this knowledge and presentation. Adding to the information that I've already handed to you in regards to what Dr. Jaci said in regards to Luiz Gama, I had the information here. What the minister that wasn't here, Dr. Jaci, mentioned regarding Luiz Gama, that the Justice Court created a prize in regards to Luiz Gama medal is going to be handed, and then so I looked for some information, received information. The Court of Bahia, Pina Rezende, has the honor to invite you to the solemnity of delivery of the prize Luiz Gama, the association, protectorization of those that are vulnerable. That is in the auditorium Eunice Una. So we have this homage that will be paid. The Luiz Gama Prize to an institution. And this was an institution that won from all that signed up. And this prize will be handed on the 18th of December at 2 p.m. So I take advantage to invite all of those here at this panel. Justice Benjamin, Benedito, all the panelists are here present. There's a big group of Bahia here. Those that can be present. The invitation is already, sent or made. We're going to announce to end our panel, since we spoke so much about budget. We announced that the courts must include in their yearly budget money pertinent to continual capacity building in ethno-racial subjects, which includes courses, cultural events, as well as bibliographic material academically indicated, so that this is supposed to be included in our court budgets. And to conclude my position, I'd very much like to the female Black participation in judiciary branch. The low representativity of women in judiciary is sad. Data presented by the CNJ talks about the question of underrepresentation in the spaces. It's not just a reflection of structural racism, but also of the historical exclusion of educational opportunities and economic opportunities. It shows that Black women is constantly relegated to the more precarious situation in society and in the labor market. The judiciary, these things perpetuate a cycle that dehumanizes and devalues their life. They say the Brazilian imaginary because of racism cannot recognize that Black women are intellectuals. So I think it is important and to say that it's important to change this reality. Without doubt, the judiciary has a fundamental role in the construction of a more just and inclusive Brazil. Our actions must reflect the commitment to eradicate all sorts of discrimination, guaranteeing that men and women, Black and other groups, be protagonists. And to conclude, I cite Nelson Mandela, that was already well celebrated these past days. It is not just our capacity to change the world that is important, but our commitment with that change. Let our commitment be with justice that respects the difference and the diversity of all people. Thank you very much.
Eu queria agradecer a desembargadora.
I'd like to say to Appellate Judge, representative of the First Court of Appellate Courts of the Americas, in 1609. So, Appellate Justice, Purificação, thank you very much for being present. I'd like to thank the speakers, the presence of my colleague Benedito Gonçalves.
Saí procurando onde está você.
I'm just looking for you.
Nós somos irmãos, então. Mas ele estava realmente com ocupações muito sérias.
He was really occupied with very important things and family demands, especially when it's the wife. There's not much you can do, or husband. Gender equality. So, thanking the speakers of this panel. It was also wonderful. That at the end is going to be to choose what the best panel is going to be. I think we're going to have a draw.
Queria fazer uma
So I'd
observação
like to just do a final remark in regards to everything that I heard from this panel and the period I was here. I was falling through the cell phone because everyone knows that this is being broadcast on YouTube. I think that what we really need in the magistracy isn't to pay homage personalities of history of Black people. What we truly need is to have Black people in the Supreme Courts. That is what we need. We obviously laud the homage of the heroes of the Black people cause. But if we looked at courts, big justice courts, regional federal courts that do not have a single % of Black people, it's best to not pay homage to anyone. It's important that we all show these statistics, because the change in the judiciary power is really going to be from the moment that our composition, the highest scales or levels, not just in the first instances, but that they reflect on the diversity of the Brazilian people. And nowadays we don't. Currently we don't. The STJ, the National High Court of Brazil, has only one Afro-Brazilian. And then some say, he is so good that he's worth 30.
Ele é muito bom mesmo. Mas nós
He's
queremos
good, but we want to have
representação
a
proporcional
proportional representativity of ministers or justices, rather, that have the face of and the skin of the Brazilian people, the thinking of the Brazilian people. The STJ doesn't have any. But our responsibility here at the STJ is even bigger because in the Supreme Federal Court, it's the president that chooses. Here, it's us. So we cannot impute the responsibility to third parties. It's us, ourselves. In the future, we will have open spaces in the OAB, the lawyers organization, and another organization. Then I think it is now that we have and start having institutions that are represented with far more or just black. We have nominations that are just black people. 6 names, 6 men and 6 women, actually. Because if we have few black people, we have even fewer black women. And I think that it's extremely important that the majority of the 6, I wouldn't say 6, all of them. If I were doing the list, I would put 6 women, black women. But I would already be happy in having 4 black women. But this movement cannot come just from me. It has to come from the black people. And it is a permanent moment. If we have a list made up of only black people, the STJ is going to choose, there's no option, a triple list with black people. And then we can gradually have a process that we're going to solve once and for all the issue of the identity of our court.
Sobre algo que eu também ouço com muita frequência.
Something that is about something that I also hear quite often. We have to defend the quotas, with basis on fraternity. Based on fraternity, it's not an act of charity. Here, it is an act of recognition that the judiciary nowadays is poorer than it should be, than necessary, or that of the judiciary that it could be, with an adequate representation, a proportional representation with black people. There is no fraternity involved in that. It's the very opposite, is utilitarianism. I'm sorry for saying this, but because black people are going to bring to the courts the competence, the knowledge, the diversity, the ideals of the most part of the Brazilian population. So I declare this panel closed. We're going to have another panel, all competing among themselves, but I think it most likely will be a draw. The next panel, and then we'll have the most important product of this event, aside from the Congress itself divulging the ideas, are the enunciates that are approved by the judges, federal and state judges, in the first days of racial equality of the Federal Justice Council. So I thank you, and we pass on to the certificates, to those who have to prove at home to their spouses that they were here. We'll dispense the formal delivery. There will be no formal delivery because we're more interested in using our time to debate the great subjects that we still have before us. The appellate judge is desperate to give these certificates. So let's deliver the certificate. It's a mission that they gave to me here. So I must do it.
Posso fazer aqui? Sim, vamos. Desembargadora? Pode entregar todos, que aí a gente segura. Tiramos uma foto.
Aqui só para comprar. Não entrega, tá?
Que bom, que bom.
Parabéns.
Obrigado.
Muito merecido. Parabéns.
Você, obrigado. Querida, obrigado. Obrigado.
Muito merecido.
Vocês orgulham a gente.
Quando se encontra, que coisa boa. Olha.
Vocês orgulham a gente.
Tá vendo? Olha aí. Não.
É o desembargador.
Da Paraíba. Da Paraíba, olha aí. Ó, olha. Mas ela que não. Trai. Oh, meu Deus do céu. Olha.
Já essa casquinha agora. Agora nós vamos passar, então, nas conferências de encerramento.
So we're now going to go on to the closing conference of our first symposium for racial equality. Presiding or presided
O desembargador João Benedito,
by Appellate Judge João Benedito, President of the Justice Court of Paraíba, of my state.
eu tenho muita alegria em recebê-lo aqui.
And I'm really happy to receive you here at the National High Court. It represents the state of Bahia very well.
Quem quiser conversar, pode conversar.
Those who want to talk, they can talk outside.
Nós temos como conferencistas a professora
Speakers, we have Professor Olita Inês, that is the director of the Faculty of Law of the University of Colorado in Boulder, the Rocky Mountains, one of the most beautiful places in the world. He is a well-known and recognized jurist or lawyer, legal expert with a dozen of publications about several subjects. She is a specialist specifically on racial equity, so we're really happy to have you here with us. in Brazil for the first time. We also have here the second speaker, and we wanted to end with two female speakers. Justice Edilene Lobo, substitute justice of the Superior Electoral Court. That is a great gift for her vast legal knowledge and for her the way she is. There's no space where Justice Edilene arrives. It might seem as an exaggeration, but there's no space that does not become brighter with her presence. With further ado, I hand the floor to Appellate Judge and President João Benedito. Good afternoon to all. I request to the justices, Edmund Benjamin and Justice Benedict,
for a leave for me to introduce myself. Both lectures were introduced very well, but I'd like 3 minutes so that I can introduce myself. Since I'm not going to be a lecturer, but I'll be a mediator, I guess I can have that privilege. My name is João Benedito da Silva. João Benedito da Silva says it all about my origins and my color. I am the 6th son of a family of 8, the first one to graduate, to have higher education, the first one among the 8. After me, the other 2 also graduated, following my example. I was approved in Paraíba. I was from Pernambuco, but now I'm from the state of Paraíba because I've lived there for 40 years. I am not from Catolé do Rocha, like the Chief Justice, but I am from the state of Paraíba. And when I was approved to be a judge, people really say that, oh, we're missing Black judges, women and men. And I did the selection process in Paraíba in 1984, and I didn't know how many Black people were in the selection process, but after some filtering, there were other 5 Black people with me, and out of the 6 Black people, 3 were approved as judges. And I thought, what's missing? What's missing? Should we have more Black people trying to become judges? Well, at the time, that wasn't the case. Should they be studying more? No, I think they all studied. But we have a lot of quality training that they do have the right to receive. And I didn't as well, but I have been helped by God ever since my childhood, and He gave me strength to access that knowledge. And here I see with a lot of joy that 1,600 people of color were approved in the last selection process. So I'm very happy that at least 1,700 were approved in the last selection process, or the first phase of that selection process, and let's wait to see the final result of that. And I would also like to say that when it comes to the time when I was approved to be a judge, I took office in the Justice Court. There were already some other black judges at the time. Currently, lo and behold, I was inaugurated as an appellate judge in 2010, and ever since 2010, I was the only black person in that justice court, and still am. And Justice Eva, Justice Benedito, I want to tell you that we had a meeting in the state of Paraíba of the chief justices of the courts, 27. How many black people were there among the 27? Who can take a guess? One. And I was telling a justice, I think Justice Luis Fernando Barroso, who was there to honor us in Paraíba. We had Justice Eva, we had Justice Mauro Campia, and Justice Barroso. The three of them came to Paraíba at that occasion. And I was telling Justice Luis Fernando Barroso, look, it's just me. He asked me, when are you gonna end your term? And I said, in the end of January. And he said, my God, so there will be no one left among the 27 chief justices, the courts of justice, no black people. It is flowing. But we move on. Naturally, with the help of Justice Herman, Justice Benedito Gonçalves, who writes Paraíba, and really is always in Paraíba. And well, I went over the 3 minutes I asked for, but I just need a couple more minutes. And I participated in a committee of legal practitioners that was assembled by the House of Representatives in 2021 under Justice Benedito. And presiding over that committee was Justice Benedito. And where we gathered on that occasion? Representatives, because of a situation that was very serious, they decided to create this committee of legal practitioners. I think Adriana Moreira was a part of that. Karen, who else here? We also had a couple others who were part of that committee. Well, in the end, after a year's work, we heard the Black movement, we heard people from the private and public sectors. We delivered a report to the House of Representatives with proposals for improvement so that this gap between the resources that are offered to the Black population and the resources that are offered to white people can be filled. This gap can be filled so that there is opportunity for equality and for equity for all. And this report was delivered to the House of Representatives, and when Justice Benedito Gonçalves visited us, I asked him to refer a couple of copies of this report to the courts. And why was that? I am taking advantage of the fact that I'm still visible because I'm the Chief Justice of the Justice Court of Paraíba, and I'm taking these copies of the report to the universities, and I am also going to bring that report here and present it to Justice Benedito. I'm taking the report to public libraries and always recording that period and time and telling people of the importance of that report to the Black population in our country. Because if there is a force of the university, of public schools, of the National Bar Association. The National Bar Association in Paraíba was very joyous in receiving the copy of that report. One of the lawyers even said, I didn't know we had a Chief Justice in a Court of Justice who was Black. So it's also good to give visibility to our work and also enable for all of these people who are representatives to take to the House of Representatives the need to read the bills of law and present new bills of law on this topic. And that was just what I had to say. Appellate Court Judge and Chief Justice Majiedt. I felt the need, after I read the report, I felt the need to publicize it. And I've taken it to the institutions that I already mentioned. And I'll do that more and more. Wherever I go, I have it with me and give the institution a copy. And well, thank you very much for hearing me out. And I'll now. Yes, of course. And I'll pass the floor to
Doutora
Dr.
Lolita
Dr. Did I say that right? Lolita Dr. Innes.
Excelência
Your
tem.
Excellency, you have the floor for 30 minutes.
Thank you.
Boa tarde, senhoras e senhores.
Good afternoon, ladies and gentlemen. Thank you.
However, I've been listening a lot and trying to pick up every single word in Portuguese that I can. So the next time you see me, I'll be able to have conversations with you all. I want to tell you what a tremendous honor it is for me to stand here before you today, and I want to offer great thanks to Justice Benjamin for inviting me here today. I stand here before you as the Dean of the University of Colorado Law School, where I am the second woman and the first Black person in the school's 132-year history to serve as Dean. And I must tell you, as I remind many of the faculty who serve in my charge, that I am now the Dean at a place that would not hire me 30 years ago when I began in this profession. I want to say that. I want to say that because that plain fact is part of what brings us here today. In the United States, as is true in Brazil and in South Africa, we still have a long way to go when it comes to racial and gender equity. I also stand here before you as someone who is a law professor and a legal historian, and I've spent a lot of time studying the meaning of Blackness in the United States and in the Americas. I stand before you as a Black woman who is a multi-generational citizen of the United States. And the word citizen I use because I suppose it's the right word. However, please do recognize that in the over 400-year history that I've traced my family, most of that time we were not citizens of the place that we call home. And yet I feel, thank you, a deep sense of belonging. And so I emphasize our long presence in that country because I think it is so very important for all of us here, those in the United States, those in Brazil, those in South Africa, especially to recognize that it's a deep sense of belonging that makes these conversations about Black equity imperative. We are not talking about the need to incorporate people who are not part of the polity. We are talking about the need to recognize Black people, in many cases, as the very earliest and the original inhabitants. I also come before you as the first person in my family to achieve a regular primary school education and higher education. And that is a fact that I now share with pride, but I must tell you that in my early years as a lawyer and as a legal academic, while it's clear that I'm a Black woman, I rarely discussed my class background because, interestingly enough, at a time when intersectional identities are much more recognized, that was one identity that I found it deeply inconvenient to acknowledge, because I think as many speakers among us at this conference have acknowledged, very often when Black people get opportunities, they're not the people who come from the least privileged, the lowest echelons. And that was certainly the case for me. I was often alone among my Black peers as someone whose family had not achieved any regular education in their background. And so I share that with you today. I also tell you that I am descended from people who were enslaved in the United States for longer than we were free. I am a student of the intricate and painful histories that have shaped our present realities. And most importantly, I am a citizen of our joint human enterprise. That is what brings us all here together for these days of the symposium. Now, I must say to you that I am someone who, if you read my biography, you might note lots of what people would deem accomplishments. But I have to say to you that starting in my very early youth, and it's still true today, the most common refrain when anybody asked me anything was to say, "Yo no sé," I don't know. When I was lecturing, that's the first thought in my head, even when in fact I do know, or I did know. And you know, when I was very young, because I often said, I don't know, when people ask me questions, was put into what we in the United States call the slow group. That's for children who persistently, and it was for me, it was pretty woeful, who persistently did not know or refused to demonstrate knowledge. It was only as I got a little bit older that I came to recognize that you've heard the expression, knowledge is power. Even when I was very young, I understood that it was actually something to the contrary. Power is the willingness to acknowledge an absence of knowledge. It's a willingness to fill that gap. Even when I was very young, and it's certainly true now, I knew a lot more than I did when I was about 5 years old and I started saying that. But the more that I know, the more I recognize that I don't know. And that is where true power lies. That is the source of the importance of symposia like this. No matter who we are in terms of our backgrounds or expertise, we all come with a willingness to say, I don't know, and I don't want to learn. And in fact, a funny story, when Justice Benjamin contacted me to invite me, my first question to him, as you might recall, is, I don't know why you're inviting me. Because that is typically my first response to anything. And I must say to you that the willingness not to know is what is going to bring us ahead. At this time we gather, at this vital conference, to share what we know and to talk about what we don't know as we examine the divergent and shared paths of Brazil, the United States, and South Africa, three nations that are bound by legacies of enslavement, colonization, racial oppression, and yet at the same time also bound by the resilience and the brilliance and the beauty of African-descended populations. I am, as I've stated, an academic leader, and I've spent almost my entire career in the legal academy. However, one of the most important things that my work has taught me over the years is that meetings like this, they are far from only academic or juridical exercises. In spaces like this, in places like this also, where we've confronted hard truths and exchanged transformative ideas, the most significant thing that we do here is to imagine a future where justice and equity are not just aspirations, but lived realities. Let's talk for a few minutes about the role of law in shaping racial equity, or I should say, in shaping racial inequity, because far more often that's been the case for Black people in the United States, in Brazil, in South Africa. In these three nations, law has often been a tool of oppression. In the United States, law has been a tool of oppression. It's also been a measure for resistance. The U.S. Constitution, which I've studied fairly closely, interestingly enough, is what some people have said is the very first document in U.S. history that enshrines slavery without ever saying that word. And in fact, I almost hate to acknowledge that it was not until I was on the law faculty and I began to very closely study the U.S. Constitution that I realized that the Constitution went to great pains to talk about enslaved people as persons held to labor without ever saying enslavement. The U.S. Constitution had mechanisms returning escapees from slavery back to slavery. Without ever saying the word slavery or enslavement, the U.S. Constitution had provisions that ended the importation of enslaved people from Africa, which ultimately meant that because there could be no new bodies brought from abroad, we had to find a way to maintain those who were currently enslaved, and hence going along with the ban on importation, the mechanisms to return people to slavery who were already there. We talked about this in all of my years of education. Nobody talked about this. The United States, therefore, I would say, is it a place where slavery was deeply codified? It was written through and through the Constitution, one of our earliest documents, and yet it is entirely unspoken. Blackness, or membership in the sub-Saharan African diaspora, has often in the United States had a negative weight in meaning in legal contexts and in other world contexts as well. And because of that, people in the African diaspora who've been brought to the United States or who've migrated there after the general emancipation of enslaved people, they suffered grave social and legal inequities, and those inequities have been created and maintained through the operation of law and law-like systems. I'm going to point to what we in the United States think of as a landmark case. Some of you may have heard of Brown versus Board of Education. It was a United States Supreme Court case. It came down in 1954, and it was a pivotal moment because it was the first time in the United States history when our highest court held that segregation in the provision of public education was impermissible. It was unconstitutional. We in the United States, however, came to understand that dismantling this systemic racism, especially in the arena of education, was far more complex. One of our greatest legal scholars and philosophers, the late Derek Bell, once said that one of the best things and the worst things that happened to Black people in the United States was Brown versus Board of Education, because we announced formally, publicly, officially, that segregation and the provision of education, especially and in other services, was over. And at the same time, that public announcement was accompanied by numerous, prolific, private efforts to resegregate education. And in fact, data has shown that in 1954, when this decision was declared, there was pervasive segregation, racial segregation in schools in much of the US South, and indeed in much of the United States. By 1964 or 70, things were better. By 1980 or so, public education was more segregated than it had been in 1954, because very quietly, there were unofficial, what I call sub-legal norms to resegregate or to maintain privileges, white privilege, that had never gone away. So yes, achieving victories at law is complicated. Structural inequalities in housing, in education, in criminal justice, these are manifestations of a society that grappled with, but not just in the past tense, that continues to grapple with the long shadow of slavery and Jim Crow. Since I've become a law school dean, that is, that I haven't taught as much as I had over most of my 30-year career, I have had the opportunity to do, when the time permits, more thinking and some writing. And I started to write something that I would not dared have written, much less thought about, when I was a very junior law professor. And that is the reality of the fact that there is a plural legal order in the United States. Now, for those of you who are academics, judges, when we talk about plural legal order, I know at least in the United States, the first thing we think of is, oh, that means that there's an interplay of federal and state law, or that means thinking about indigenous legal systems, or that means thinking about comparative law, the law between and among countries. But the plural legal order that I think about, that I'm starting to write about, is not the diverse presence of various legal norms. The claim that I am making invokes something that's far more challenging and open to, I think, far more critiques. And that is that in the United States, and indeed many other places, there is law for white identifying people and law for Black people and those deemed Black. And that seems obvious, but it's really rather difficult to say. I think largely because we who are lawyers or law trained have been taught to believe that there is a truth, that there is universal justice and fairness. And indeed, I would say that in large measure, I believe that. It's funny, sometimes my students say to me, how can you preside over an enterprise that in many respects is deeply unjust, deeply unfair? And my answer is, it's because I'm a skeptical optimist. Meaning my first thought is to not believe that there can be progress, and yet I do law because I think there can be legal progress. However, at the same time, part of the skepticism requires acknowledging that there are dual legal systems in the United States. The law, in its formal, in its jurisprudential manifestations, does not work, or at least it does not work the same way for Black people as it does for white people. I would also say that neither does law in its less formal, sublegal regulatory norms, the things that govern the practice of everyday life. That law doesn't work the same for Black people as for white people either. And I want to pause for a moment here to talk about what I mean here. In a setting like this, where we have esteemed jurists, lawyers, and members of the public, when we say law, we usually mean the formal law, the things that happen in legislatures, courts. But law is also what happens on the ground. In fact, one of the things that I used to most frequently teach when I regularly lectured law to students is that it's tempting to think of law as coming from the top and trickling down, but law comes from the bottom and moves upward. Law is the codification of what we believe to be right and necessary and just on the ground very often. And the example that I used to give was having to do with how we allocate rights to property. I taught property law for most of my career. And so the students would come in on the first day of lecture, and I had to talk about the theoretical foundations of how we allocate rights to things, whether they're personal property, things, or land. And personal property things are those that are most familiar to all of us, because many of us, some of us may never own land, but everybody has things. Everybody has things. So I would look around and I would find a likely student, usually someone who didn't look too outgoing, who seemed kind of shy. And I'd say, "Excuse me, you there, sir. I see you have a computer there. That's really attractive." He'd say, "Yes, thank you." We'd talk about the model that it was. And I'd say, "Is that your computer?" And taken aback, he'd say, "Yes." And I'd say, "How do you know it's your computer?" At this point, the student's blushing, he's getting really confused. "Well, because I bought it," or sometimes the answer is, "Because my grandmother gave it to me." "Oh, okay. So you purchased it and you made it your own." "Okay. It is yours for purposes of this example." "Well, sir, if you decide to get up and go get a glass of water in the hallway, in your computer, because that is a really attractive and quite heavy-looking machine, you probably are not going to take it with you. You're just going to step right there. That's right. No, he says, "I'm not going to take it with me." "Okay, fine. You're not going to take it with you." "Now, sir, how would it be if when you stepped out into a hallway, you decided to take your computer and bring it up here with me at the podium? Would it then be mine?" I'd go, "No." Let's say, "Why not?" And this is where we begin the discussion of one of the most esteemed norms in the common law, and that is the allocation of property rights based on prior possession. He who has it first. So he'd say, "Because it's mine." Okay, we talked about how I'm not so sure about that, but I think we're all acknowledging this room that you had it first. I said, "But that's a norm that we all agreed upon. We didn't go to court. You don't have to litigate. Now, if you litigate, yeah, you'll probably win, but forget that. The sub-legal social norm, real law, is we believe that because you came in here with that computer, because you had it first, and because you went to get water, it's still yours after you left." And I said, "But think about it. It's a social norm," he had it first, "that we codified into formal jurisprudential law," meaning all of us in this room are going to get angry if I take it because you had it first, it's yours. And if you sue me in a formal court, I'm going to lose. Because that is the law in the United States and in a lot of places. Just to make students understand so much of what happens in law happens at the bottom. It is part of the social compact. It is an agreement among people. And then I say, "You know what? When I was in law school, they taught me that one reason we make laws is so that they are easy to apply and adjudicate. I said, now think about it. If you walk away from that computer when you get water and you talk to your friend and you stay out there 10 minutes, let's say you were the first one in here and no one saw you leave it. It's going to take a lot of fact finding to show that you were here first and you left it and you had it first. But think about it. If the real norm is the person who has the computer owns it, it's a lot easier to apply. There's only one question to ask. Who has it? Who has it? So it's not better rule. It's a reminder that the laws, the rules, the norms that we make first and foremost are about agreements among people on the ground, number one. Number two, about morality and justice as groups of people understand it to exist. So everyone in the classroom thought it would be outrageous. If the whoever has the computer owns it, things would change hands a lot. But think about the litigation costs. It would be really low. Because there's only one question, who's got it now? She has, all right, done, goodbye. But that's not how we do things, because part of our understanding of law is justice and morality and understandings on the ground among people. And so when we talk about racism and anti-racism, I'm here to tell you that laws that govern racism and anti-racism, yes, we need legislatures, we need courts, we need lawyers, but at the same time, and maybe primarily, we need people to understand anti-racism as a justice claim, as a morality claim among people on the ground. That's what law means. And so I can't believe that in my years of working as a law professor and now a dean, I'm suggesting that the law that is meaningful, the law that we really need, is happening right in our streets among people. These sub-legal norms, when we talk about racism and anti-racism, often come down to the fact that Black people, because of their Blackness, consistently receive fewer benefits and overall less redress than similarly situated white people in legal or law-like settings. Because remember, as I just said, law is not just happening in our courts and our legislatures, law is happening in the streets, law is happening in the stores, law is happening when you go somewhere and because you're Black, they ignore you and go to the next person. That's a form of law. Anti-racism at its best and at its finest does not just make lofty pronouncements. Anti-racism at its finest makes law happen in the streets and everywhere. Now, some people may argue, in fact, they have argued at times, that claims about disparate treatment of Black people versus white people under the rule of law has to do with the personal perceptions of people claiming to be victims. However, data shows that there is a substantial overlap in that perception and in actuality, especially in contexts like criminal justice. Speakers here at our conference have talked about the fact that in the United States, in Brazil, in South Africa, the incarceration rate of Black people typically far outstrips their percentage in the population. That is about an absence of justice. That is not about the proliferation of criminality among Black people. Now, in Brazil, racial inequity has sometimes been obscured by a broader desire for a racial democracy, and the idea that the absence of formal segregation in law translates to racial harmony. And this narrative has long obscured the realities of Afro-Brazilians who face entrenched socioeconomic disparities, disproportionate police violence, and underrepresentation in positions of power, as we've just discussed. It wasn't until the early 21st century that Brazil began to take significant legal steps toward addressing these inequities. Policies like affirmative action in education and employment have opened doors for Afro-Brazilians, and yet resistance to these measures underscores a broader reluctance to grapple with history. In South Africa, we see the unique case of apartheid, a legal system explicitly designed to institutionalize racial segregation and subjugation. The dismantling of apartheid in the 1990s, culminating in the election of Nelson Mandela, was a testament to the power of collective resistance and international solidarity. The Truth and Reconciliation Commission that followed was groundbreaking, but it also exposed the limits of reconciliation without substantive redistribution. Land reforms in many cases remain incomplete, and economic disparities between Black South Africans and white South Africans persist as stark reminders. Now, despite the differences between the United States and Brazil and South Africa, there are still some striking parallels. In each case, law has been wielded as both a weapon of oppression and as a tool for liberation. So going back to my assertion that I am a skeptical optimist, the skeptical me sees and knows that law can be a dangerous weapon. But the optimistic me knows that there are opportunities for advancement in law. Our task as scholars, as practitioners of law, as citizens working in all disciplines, is to interrogate all of our histories, not merely to recount them, to uncover their lessons. Let's take the case of affirmative action in the United States. For those of you who follow that discussion, you may be aware of the fact that affirmative action is responsible for the advancement of a number of Black people, including me. I am a proud beneficiary of affirmative action in the United States. And yet, recent US Supreme Court jurisprudence has set some stringent limits on the possibilities for affirmative action. One of the reasons asserted for more limits on affirmative action in the United States is that, well, so many Black people have gotten opportunities. We don't need that anymore. We especially don't need that for people who are termed second generation Black people. I always, this is part of the skeptic me, I always smirk when someone says second generation. Now, I just told you a few moments ago that I'm the first person in my family to have anything that resembles regular education, much less higher education. I'm proud to say that the last of my 3 children recently graduated college from a very fine school indeed. But you know, as I told the presidents of those institutions, and they hated to see me coming, my children are not second generation. To put it in terms of a software update, they're more like version 1.1. Why is that? Because while it is true that I and my husband are privileged to have received very fine educations, as did our children, we still stand out among our families. I have nieces and nephews. My children have cousins who have been incarcerated, often under very unjust circumstances. We stand alone. I am fearful, and other speakers have pointed this out, I am fearful that the few Black people who succeed in places like the United States or Brazil or South Africa may be held up as shining examples of what is possible. Indeed, they are sparse tokens of often what has been very grudgingly given. And when I say that, that does not mean that I and others have not earned these opportunities. But we must recognize, just as the story that I just told about how you allocate property rights, there are justice claims, and then there's what somebody else says is the rule or the norm. We hear a lot in the United States, and I certainly hear a lot of it as the dean of a law school, about merit and excellence. It took me a long time into my adult life to understand that merit and excellence are moving targets subject to definition and redefinition, just like anything else. We are living in a time when merit and excellence are wielded as weapons against Black people and those coming from marginalized communities, when our very existence in the places where we live, that is the definition of excellence. The fact that we have survived and thrived, that is merit, that is excellence. And only when more of us, some of us, get into places of power where we can rewrite those definitions, will that be acknowledged. And again, I want to go back to this whole idea of privilege. I used to resist saying that I and my children were privileged because I know what my life was like as a young child. And indeed, for my children, growing up among cousins whose lives were not like their own, it's very difficult to call yourself privileged. But I think it's important for all of us in this room and in places like this to understand even a little privilege goes a long way when it comes to moving forward and trying to reshape norms. Especially when you're talking about law and Black people. And it's funny, I say Black people a lot these days, largely because in the United States, I don't know if you're familiar with it, there's a Don't Say Black movement in a lot of the southern US states. That is to say, there are actually laws, believe it or not, where you're not supposed to say Black. You're supposed to say marginalized people, people of other backgrounds. Don't say, I mean, those of us who are Black laugh at it. And I laugh at it too. Because again, when it comes to law, Black people, and this goes back to the idea that there's different law for Black people and white people. I think it's apt to say across the nations under discussion in this symposium, Brazil, South Africa, and the United States, Black people, we are some of the most ardent, what I call legal monists. That is a term that means people who advocate for a single, pervasive, fairly uniform applicable system of laws. That's us. Black people want, we don't want to be a Black law. We just want to be fairly informed in the justice-based law that exists. We often, perhaps ironically, ask the most of law, seeking inclusions in its promises and protections, but at the same time, we often receive the least. A key undertaking of this symposium has been to name this absence of rights, because once again, as I said, and I have to say I have a terrific sense of humor, which is partly why I can be the dean of an overwhelmingly white law faculty. Not that I think it's humorous to be so, but because I understand that humor is at the heart, once again, humor is at the heart of power, just like acknowledging the lack of knowledge. You must be able to laugh. And again, I would say if someone were to ask me what explains the existence of Black people, those in the diaspora, and those who remain in their own homelands, what explains our continued existence, it is probably humor. It is understanding you must laugh at the situation, you must laugh at yourself, and that is what undergirds you to go forward. So yes, there's an absence of rights, and that means that the work that we're doing here is in some respects, and I hesitate to say it in such an august setting, this is dangerous work, because we are, even in the 21st century, trying to reshape and upset norms that we are told have changed. But yes, they have, okay. Be optimist me, yes, absolutely they have. I could not have done what I'm doing 30 years ago, or 50 years ago, and certainly not 100 years ago, nor could many of us in this room. Things have changed, but if we continue, and we shall, if we continue to press justice norms, then we might undermine what philosopher W.E.B. Du Bois has called the greater idea of the American Republic, that the United States ethos, even if not its impulse, is towards a colorblind equality. That's what we say we want. That's who we say we are. It is dangerous and disruptive to remind people that that is not who they are. And in the United States, once again, at a time when explicit references to race and the difference that race makes are avoided and downright barred in some places, it seems especially perilous to engage in such discussions. And so I go back to my deep gratitude to Justice Benjamin. I thought, this is tremendous. I'm being invited somewhere to talk about something that increasingly nobody wants to hear about in the United States. Now, following the national and international protests against anti-Black racism in the summer of 2020, some of you recall that, George Floyd, the protests, the riot, and then coming on top of COVID, was, to put it colloquially or in a single few words, it was a mess. Conservative US factions came together to oppose and dismantle a lot of anti-racist norms. Between January 2021 and December 2022, officials at all levels of the country introduced hundreds of bills, laws, regulations, resolutions, and policies to restrict teaching about and training on contemporary racial injustice and the effects of historical subordination. They made laws to stop us from talking about this kind of thing. Even more obvious and alarming, at the same time, examples of unjustified police and vigilante detentions, assaults, killing of Black people, they became more horrific, and yet there's less and less redress for victims. Now, mind you, the absence of redress was happening at the same time that we were ever I would say, the beneficiaries and the victims of what I call the surveillance, not surveillance, surveillance state. That is to say, surveillance is when people are looking at you. Surveillance is when we're looking out at other people. Everybody's got a cell phone now. That meant that we were seeing more examples of vigilante and police violence than ever before. And the shock was, even when you get it on camera, you still might not get redress. Some of us thought, I'd rather you didn't know, get them on tape. And there is still no redress. These tragedies crossed class and gender lines as Black people, regardless of their socioeconomic status, age, geography, didn't matter. They're still under assault. Racially motivated injustices, whether they were attacks or changes in laws, often ignored, hastened into obscurity by the combined effects of abstract neutrality, and more importantly, studious silence. It's not so much when people say things that oppress others. It's when you are oppressed and people see it and they say nothing at all. That is the power of law. That is law too. When people see and say nothing. So, this conference challenges that kind of silence. And in this respect, and in other ways, it's a radical act. And let me just say, when I say radical, I know in the United States, if you walked into an event and you said radical, many people would flinch. Radical just declares that the experiences of African-descended people are not peripheral. They're central to the quest for justice worldwide. This conference is a place where law meets culture and where history informs the future. The value of this gathering lies not only in the knowledge that we exchange, but in the connections that we build. And I'm so pleased and proud to have had a chance to speak with and know many of you. Together, we are creating a network of scholars, activists, and policymakers who understand that the fight for racial equality is a global struggle. It is a legal struggle, but it is legal in the sense that law, as I said earlier, begins from the ground up and not only or at all from the top down. So a few words before I close. This conference, let us carry with us the conviction that history is not destiny. And I must say, without being more precise, I have to believe that history is not destiny, or I could not go on and do the work that I do. The systems of oppression that our ancestors endured were human creations. And what humans have created, humans can and will dismantle. Let us also remember, and I have to think about this every day, progress is not linear, no matter what they told us. It is not. The backlash that we see against racial equity measures, whether it is in Brazil, the United States, or South Africa, that reminds us that our work is never done. But history also teaches us that resistance is powerful and that the efforts of a community few can transform entire societies. So, in closing, I leave you with the words of the esteemed Black United States intellectual Frederick Douglass. The whole history of the progress of human liberty shows that all concessions yet made have grown out of tremendous struggle. The conflict has been exciting, agitating, all-absorbing, and for the time being, it puts all other conflicts into silence. If there is no struggle, there is no progress. This struggle is one that belongs to all of us collectively as we strive for an inclusive, just world that shines all the brighter because we are able to deploy the talents of all. And so, in closing, I ask that we all leave here vigilant, emboldened, fewer, and united in our shared commitment to justice.
Agradecer a ministra.
I'd like to thank Justice Lolita. I won't say the rest of her name because I might pronounce it wrong.
Foi só para isso mesmo.
I'd just like to thank her, but also acknowledge her for drawing a parallel between the system of norms and the penal system in the United States, which allows us to have clarity and draw comparisons between their system or their systems in the US and our system here in Brazil. Thank you, Your Excellency, for your clarifications, and I'll leave Justice Benjamin and the other justices to make their final considerations in the end. I now pass the floor to Justice Adriana. She has a doctorate and a master's in law. She's a guest professor at the University of Sorbonne with a postdoctorate in new technologies. Oh my God. It's hard to read.
Bom, foi na Universidade de Sevilha. Ela fez
The University of Sevilla. I read it wrong. So please, Justice Good afternoon, everyone. Thank you very much for the opportunity of seeing each other, of sharing our energy today. And whenever I find myself amongst people like yourselves, and I'll ask the leave of my dear Master Herman Benjamin to speak more plainly and informally, whenever I come across people like you, I remember words that paved my entire life. I need to talk about affection, I need to talk about gratitude, and I need to talk about recognition. So that's why before I start, I must acknowledge Justice Herman, Dr. Lolita, Appellate Judge Majiedt. I need to acknowledge very important women in my life who give me support and who guide me and who encourage me. I'm tired because of the violences that we suffer throughout our lives at all times. It's hard to enter spaces, it's hard to stay in spaces, it's hard to get out of spaces. So I need to talk about these people like Adriana Cruz, my twin sister, if you haven't noticed. I need to mention Maranhão, my dear friend from the state of Bahia, from the surroundings of my homeland. I need to talk about Adriana Meloni, this young sister that life has given me, who gives me such support and tells me to raise my head up high, to rest and resist.
Woman from Bahia that is so energized and that received us so well, so long ago. And I have to talk about Dr. Rosilene, that after a tiresome walk or journey now has a function for which her expertise, intelligent capacity adds to very much and improves, I am sure. Talk about Karen Louise and this person who is a true flower. Talk about Valeria Pais Landim here, a friend, a lawyer that debates, that listens. I talk about the Professor Gilson Moreira, a dear friend from the Federal University of Minas Gerais, Professor Gilson, that all know and such from the University of Minas Gerais, the most unlikely place for a poor woman such as me to actually be, but a place that I said is mine. I should enter it, and I should exit only if I thought I was ready to exit it. Because the money of the people, the public savings account has to be destined to the people. That it must be destined to the majority that needs foremost of this collective effort. So this friend of mine that circulates in so many places and minds, and to look at a relatively recent past and say that we need and deserve more. That the places of academia, there is place for people such as us, that the academia must improve with people such as us, that we must come with intelligent figures such as Dr. Gregorio, that is just a judge in Minas Gerais, that is a dear friend but a terrible photographer. He sends pictures of this beautiful place that are just horrendous. I have to say also of this dear friend that greets me, that inspires me, that guides me. By the way, I am going through a really pleasing process of reading all of his processes, that is that of Chief Justice Herman Benjamin. The energy of a man such as this, with this understanding of the transcendental question of so many things that we've talked about and will continue discussing, that has this dimension. Chief Justice Herman is a really important ally to debate and make that meetings such as these be common and continue. I'm going to end referencing my dear friends here, of people that inspire me, excite me. André Mara, another one from Bahia, that I hope to continue having as a friend for a long time. So I came to share with you, I'm a Black woman. I have curly hair that I took much care and have it as it is currently. And especially so that Dr. Gregorio's pictures do not look so horrendous. I came from the far north of the state of Minas Gerais. I am the 17th daughter of a family of 20 children. So I have belonged to battalions, a big group from the very start. I am the daughter of a poor Black man, barely literate. I am wearing a red shirt that is the same color of the people that resist, but that is also that also bleeds, that we see every day on the screens. As Elza Soares said, it's the cheapest meat in the market. I come with this red shirt to say that this is exactly as we go, rigorous, resistant, but also a bit tired, because it has been a long time now, and we are in a hurry. And I want to talk about this a little bit today, here, if you'd allow me. I brought forth this conversation inspired by Gilson Moreira and many others. Doutora Thula, that for many years I have met at a Comparative here in Brasília. She probably doesn't even remember, but I've always followed her work, of Dr. Thula Pires and many others. I met here this promising young person such as Corbo, Wallace Corbo. I even asked him how old he was to know if perhaps he wasn't one of these children of mine that I dreamt of having, but my life did not allow me to have. And so I brought the speech that I called Racial Equity, Always, Parity in Everything, the hermeneutics of inclusion to abolish racism and make Brazilian society to show up to the meeting that we have with equality in all its dimensions. When I bring this talk to this place, I highlight the works of Adilson Moreira, this expression, hermeneutics, constitutional hermeneutics, as a specific objective, the fight against all the kinds of subordination. The invitation before with Adilson, that gave all of us here with those words that revealed just a small part of his big work. Part of it built in the best state of the world, which is Minas Gerais. I also say the vast majority here would probably wish they were born in Minas Gerais. But I still greet you as my fellow people. So he says of this necessity of overcoming the legal hermeneutics, us that are here in this environment, among academics, magistrates, the justice system, although I feel I miss the Ministry of Public Ministry. I see some other people here, but not from there. To overcome this construction as a tool of exclusion and oppression, and I call hermeneutics of inclusion to say that the first biggest enunciate of this event, forgive me, and I want to greet all the people that work very hard to deliver today a joint of enunciates. But I think the very first big one that must be representing here this event is equity always and parity in everything. Talking about the enunciates, by the way, I would like to highlight that the Prize Novari must get to know about this parity, and it will soon be public knowledge. I was talking about Judge Arnold, he who, by the way, has already been a prize winner and other opportunities too. People know it's such an important thing we're building, Justice Herman, and I'm sure that this initiative and an event such as this that is very surprising and very soon going to talk about the time. This is the first time that this event is taking place, this event such as this taking place. This initiative truly does reveal a proposal of breaking the cycle and walking towards the parity, equity and everything, parity always, especially to make this, to use this fraternity so that our brother and sister people, black people, including the US, and so propose of the enunciates here and the inauguration of this symposium that it be submitted to the Novari Prize. I am certain it will easily win. If anything, we're not going to take long. We'll just ask Wallace to discuss FTOs or land lease again. Well, so it's the first time at the National High Court that we have an international symposium for racial equity, trying to look for comparative points of view. And it's surprising because the foreigners that arrived here said that our story, our fight, our path, our pains are the same. Comparing our lives. One professor and Dean Lolita was here talking about her life. I was thinking, sounds a lot like mine. I still have brothers that are manual laborers without access to formal education, for example, should they want to make a leap in the other direction. So to compare here rigorously, and I went to search affirmative actions, part of which few I will mention. I went to search in both models, and it's surprising that what seemed to be an advanced order, it actually went backwards in this field, and the indicators that we have, we advanced in these. We can talk about this paradox, such a well-designed legal framework, such a good legal framework with such sad numbers and statistics, and I support myself on a word that our dear Dean said. We must talk about radicalness. So parity in everything and racial equity in everything. We'll have to reaffirm the impossibility of talking or dealing with this subject in any other way. So this fact is marking because notes, and in an impressive way, because we have been for 136 years since the declaration of when we intended to abolish slavery in Brazil. 36 years since the Constitution of '88, perhaps the only one that has put these two subjects, parity and equity, with the vigor that I'm invoking here for the first time in 500 years of domination and occupation of this territory, this country. We're also talking about 35 years of the establishment of this court. It is the first time that a symposium such as this takes place. It is also impressive because said it's the first time that we have an event such as this in this court, and we look at this court from the numbers that Justice Herman brings forth, and you can just have a look at them. It's all you need is eyes to have a look, open the door, open the window, and we'll see that this court, any country that has over 100 million black women in this court, there is not a single one within the justices. But we need not go even further. There is even older one, which is the Supreme Federal Court, which is the highest court that should keep this document that is so important, this constitution, this disruptive constitution. there as well, a court with centuries since it was established, there is yet again not a single black woman. We're talking about 100 million of black women. Sorry, 100 million women in Brazilian population, with over 50 million black women. There's yet not a single one, such as us, all of us here, in these courts. When we look at the other courts throughout Brazil, we also do not see our face. If we advance to the political power, we are not represented there neither. Women in Brazil, for the foreign people here, in the federal chamber, for example, occupy no more than 18% of the chairs, of the 513 chairs in the federal chamber. Less than 12%, 18% for women, and black women less than 6%. And when we go to the executive branch, we had here the brilliance of Aniele, the technician of Ambassador Laura. We will see that the numbers there are slightly better when we talk about ministers, so the high administration of Brazilian executive. We are almost at equity between men and women, but and with black women in a very important number, but it's still not close to the number that we occupy in Brazilian society. When we go to municipal elections now in Brazil that just took place 4 years after the pandemic that we forgot about so quickly. In the elections of 2020, in over 500 municipalities in Brazil, we had 12% of women mayors, and in the municipal chambers of the country in 2020, we had 16% of women, 6% of black representatives in the municipal chambers. In many obstacles, when we have 60% of the public savings to campaigns, and important that the foreigners here understand that the electoral campaigns are majoritarily financed with public money. Even with 60% of this money, at least 30% for women and 30% for black people, this percentage of 2020 have almost not changed at all. From 2024, we have black women that I still sorting through, but I bring here through the open data of the Electoral Superior Court. We have gone forth 0.5% in the occupation of the chairs of black women. We went from 4% to 4.5% in 2024. The black councilwomen increased 1%. 4 years later, even with the 60% of this budget allocated to this, we observe just a 7% of black councilwomen elected in 2024. I went to look for the South African data that apparently, it seems that also had some setbacks, but currently when we talk about gender, in particular observing South Africa, if I'm not mistaken, is in a position of close to 22%. Oh, sorry, in the 22nd position of almost 120 countries. Brazil cannot go over the number 170. It does not move. And when we talk about representativity, especially of black people, and considering this public budget for the financing of electoral campaigns, we're going to see that black women, as the big philosophers already told us a long time ago, and I highlight here the speech of Sueli Carneiro, reprised by so many people that were even here, stood here. Black women are twice oppressed, twofold, because a fourth of the public campaign, it seems, I still don't have the precise numbers. I'm still examining them. We must finish looking into them. But it seems that the money to finance women's campaigns financed men's campaigns with the deputies or vice, with the women behind the men in the executive, justifying the money for women to actually finance the men's campaign. And the money reserved for Black people majoritarily distributed for Black men. So here we can notice the twofold oppression applied once again every day, all the time, under our eyes. That is why it's parity in everything and racial equity always. We must talk about the delivery of resources for the double reparation of the double oppression, because Black women suffer in Brazilian politics. This money that I referred to, it has to be delivered in twofold also to Black women. And we talk about the, quote, fourth part of women, the race marker must be present, and the quarter that Black women, at proportion of their registries, must be delivered. And when we talk about money for Black people, gender has to be dealt with. We therefore must once again talk about the fourth part of Black women in distribution of budgets for campaigns. When we deal with this subject, it seems as if we've already had another time. Yes, another time that was far worse than this. It's not to, it's so that we don't say that the past was better. It's to say that we, as a matter of fact, must continue looking forward and continue walking forward firmly. But it's also true, looking to this past and also facing the present, that this reality in Brazil for Black women is impressively excluding, unloyal, and oppressive.
It's enough for us to see that highlighted in the history of Brazilian constitutionalism, we had only one congresswoman who was Black and participated in the drafting of the 1988 Constitution, Congresswoman Majiedt. And she said the following at the time: if my presence here is an exception, this means that there is not social or racial democracy in Brazil, and it also means that many people fought to elect a Black woman. Our work now with women, Black people, and everyone who's marginalized is to end this exceptionism by achieving equality of conditions in all fields of public activity, parity in everything, racial equality always. And that's the point. I want to tell you that what so many important people that have participated here in this event have already said is that without Black people, and especially Black women in spaces of power, in the same proportion of the force that composes wealth in this country, we're talking about the eighth economy in the world, without the participation of Black women in equality of conditions, this means that this democracy is a fallacy. It means that there is a path, and here I have learned that part of this trajectory is actually naming things as they should be named. We need to unveil this apparent democracy and this apparent social and racial democracy. We need to name things at the risk of never being able to go to bed again, of never being able to sleep a peaceful sleep, because every day we need to look for alternatives, every day we need to find new possibilities, but we need to talk about this. We mention here very much the anti-discriminatory systems that are in place right now, starting with the Constitution that safeguards equal rights and obligations for everyone. I wrote down many laws. I brought many of them here. For example, Adriana Cruz and Adriana Melo mentioned to me the protocol for racial equality, and so many documents that I myself wrote, or documents that I myself wrote, judicial decisions that were made in the electoral court. We have a very technological and a very well drafted legal system. But the numbers are still impressive, and we need to investigate where we have to act to change this reality, and it needs to change soon. Because it's not possible to keep seeing the scenes of exclusion, of murder, of violence, of all types against Black women and against Black people in this country. We can no longer coexist with the numbers of rape, of murders, of exclusion, of violences that are considered part of daily life. It is impressive how touched we are by the deaths of our brothers in other countries, and we should be touched. But we normalize officials shooting young Black men.
Uma idosa em Barueri, em São Paulo, cenas de hoje,
has to go in front of a camera with a bloody face because instead of being heard while protesting, she was hit. We need to wonder why we are in this situation and what we must do. Many people here before me presented these numbers and mentioned the topic and highlighted the issues. And one of the most brilliant women that I know, like I told you, my twin, Adriana Cruz, highlighted these numbers, and also made a remark that we have very important public policies in place to try and change this reality. And I have to say, and I mentioned it briefly, the legislation that allocates public money for electoral campaigns, we have an anti-discriminatory electoral law. We have a court that is specialized in acting in the electoral field, the electoral justice, fighting to protect democracy in Brazil, fighting to uphold democracy in Brazil, even though we must say that democracy in Brazil, in addition to traditional politics, must be social and also economic. It must encompass the appropriate sharing of wealth. Therefore, we must talk about economic democracy, especially so that Black women are not left behind, so that we can talk about sharing the wealth as it should be shared. Therefore, I must tell you that we have very important rules, and that Brazil can, in this field of elaborating an anti-discriminatory system in the electoral field, we can present good practices to our other two countries here. But what we do not have are the appropriate numbers that should be the result of these affirmative actions, because the affirmative actions are sabotaged on a daily basis. Fraud is pervasive, including fraud related to registering ghost candidates and defrauding the campaign funds. And we have verified with the execution of these affirmative actions in Brazil, at their core, the quotas for campaigns of Black women and the quotas of time of exposure on television and in the lists for the registering of candidates. And we see that these actions,
nós vamos precisar de mais 200.
Where they are, it's going to take us another 300 years to mention something that Justice Barroso said yesterday, where he dreams that quotas will become unconstitutional. We need 2 centuries, and we don't have that time. Climate change shows us that the world is coming to an end, and if we don't start sharing our wealth and goods in an equitable manner, there will be nothing left for anybody, not even for rich people. If we don't talk about sharing spaces like the judiciary, like the corporate world, I repeat, nothing will be left for anyone. Justice Herman opened this event saying that racism kills. It excludes, hurts the body, erases the soul, destroys the future and the present. And Alves dos Santos, that wonderful young woman in that master class that she gave us, because of technology, and one of the cases where technology serves society and not the opposite, allows that many young people will be able to watch this master class and be introduced to the Brazilian reality. And now to see, and also Cardinal Jackson, and taught us that racism was silenced, that a lot of money was involved in the erasing of the past, the present, and the attempted future of the Black race. And she unveils that by unmasking the invention of social democracy and social peace. We live in Brazil in war of extermination of Black people. And in the center of that war are Black women. The dean just said that we are talking about a reality where erasure is the system that is being implemented. So we need to have mechanisms to tackle it. We need events like this one. But we need more than anything, like Judge Fábio Esteves just pointed out, we need money to talk about economic democracy and to fund inclusion and promotion of Black people. We need public policies, but public policies without funds don't have any density, and without density, we don't have any practical need for them. So we need to talk about the sharing of wealth. We need to talk about economic democracy. We need to talk about applying the money that Black people give and delivers on a daily basis to make up public savings. We need to give that money back to its true owners. And I disagree when I hear people say that, in fact, we have lacking resources, because we have many resources. Just look at where the resources are going. Funding, for example, interest for many debts that were not undertaken by us. It's enough when we see that the proposal is implementing austerity plans when the world knows that austerity leads to fascism, to exclusion, to extremism. We need to talk about money in the bank for Black people so that they can build their present and their future. We need to talk about sharing wealth every day in the field of politics, education, culture. We need to talk, therefore, like Judge Stevan Arnold said, we need to talk about this. In fact, that people try and escape from the actual enactment of abolition in Brazil. And I paid a lot of attention to his lecture when he said that inequality impacts us, brother nations, pretty much in the same way everywhere. In the United States, in South Africa, and Brazil, we build the wealth, but we don't take part in it. We don't have a place at the table for that banquet. Imagine the banquet where everyone has a seat is where we should be, because we cook the food, we play the music, and we need to enjoy the banquet, to enjoy the music, to enjoy the food in equal conditions. We deserve the same respect and consideration. So we need to talk about sharing. We need to talk about delivering the public resources to these populations. We need to talk about love and this beautiful word, love to the people who are closest to us. Loving one another is looking beside you and seeing that that person is right beside you. And this means that over 50% of the Brazilian population should have access to good things. Dr. Stevan Arnold also said that policies and laws are good when the people who follow them are actually committed to transforming reality. And here I ask the question that he asked in his lecture, and that I have been thinking about ever since yesterday. Do you really have a commitment to changing that reality? The Brazilian judiciary branch, is it willing to invest in changing this reality?
Thula Pires,
Adilson Moreira, Gabriel Sampaio. In the previous panel, we talked about strategy. They said exactly what we should do and how we should do it. So what are we waiting for, really? And here the question is, what is the role of justice that also goes by another name, which is equity? Another name for equity is justice, or the first name given to justice is equity. So what are we delivering in terms of results in accelerating solutions? The audacity of Carolina de Jesus, reminded here yesterday by Minister Aurélio. I wanted to tell you that it seemed very appropriate for me more than ever, and I have been on this journey, I think like most of you, for quite a while, but it's very evident that we need to move from words to action. We need to stop engaging in discourse, which is important and stimulating, but we need, as the judiciary, to talk about the hermeneutics of inclusion on a daily basis in each one of our decisions, in each one of our opinions, in each one of our petitions. We need, as the justice system that does not exist for our own benefit, but for the benefit of the people, we need to remember that the center of gravity is that very same people that complain that the hermeneutics of inclusion needs to include this huge majority and not expel them from the justice system. So we need to look at justice like social justice. We must remember, and often it is important to engage in that exercise because our memory fails us, we need to remember always that the democratic rule of law that we dream of, and not the one that we apply, as shown by the numbers, is structured into essential, undeniable foundations. We're talking about the sovereignty of the peoples, the dignity of the human person, in pursuit of the very raison d'etre of the state and that structure and this republic. The Constitution of 1988, a product of the struggle of many people, some of which are not amongst us, and let it delineate as an objective the building of a free, just, and solidary society. I always like to remember two of the objectives of that Constitution to uphold the argument that I bring to you from the main title of the symposium. I remember the first goal that seems to be highlighted here in the third article of the Constitution, the eradication of poverty and marginalization, and the second one, which seems like the first, the charter within the charter, which is the promotion of the well-being of all without prejudice of origin, race, sex, or other forms of discrimination. Well, if we carried racism as the ideology of oppression for the capture of political power, especially through the subduing of women, carefully built within this perspective, which the leader mentioned that if we built, we need to destroy, and more than ever, which has become a very tired model. And this is visible how tired this model is, which challenges the idea of a society that is minimally fair for all. And that is why I will emphasize that the word of the day is parity in everything, in racial equity always. The extractivist structures are crumbling and they must disappear. And I will emphasize here that there will be nothing left for anybody, not even for those who are privileged, if we don't change this reality. First, my friends, it seems to me, and when I look back, when I look at the young girl that I was back in my hometown that dreamed of an opportunity to study, to change my reality and the reality of my family, and to dare to dream of the possibility of a better future beyond working at a supermarket. And yesterday I heard Chico Cesar singing that song, and I got very emotional because my first job was at a supermarket, and we know how hard it is to work throughout the day and study at night, and then go home to take care of your brother, your sister, your family, yourself. We need to talk about the sharing of good opportunities amongst all. I want to say that especially Black women in this country need to be included in the justice system. They need to be included in political power, in public administration, in the corporate world, because we are good. We know how to do things. We can deliver results and collaborate to change reality. And I conclude by saying,
de uma mineira maravilhosa.
the words of a wonderful musician from the state of Minas Gerais, like myself. I'm sorry if I'm not being modest. Ferreira, and she says, quotas are not charity. Quotas are not charity. And lastly, Bia Ferreira says that the game is only fair when all parties can play it. And that's what I dream of. I hope this comes soon with parity in everything and racial equity always. Thank you very much.
Muito obrigada. Thank you. Thank you.
Wonderful. What a gift. I even forgot that I have to catch a flight in this bit. I'm gonna see Princess Isabel. I'm going to Princess Isabel. The city, which is quite far. So, I'd like to thank Justice Edilene Lobo for her lesson on courage, resilience, the opportunity that she has just given to us here this afternoon. Thank you very much, Justice. I would like to say, when you spoke about the difficulties, I was quite, emotional. I said from the beginning that I had difficulties to study. In truth, my father was in agriculture in Caueiras, a very small villa. Does anyone know Caueiras? It's in Pernambuco, state of Pernambuco. Well, I went from Caueiras to Aliança by foot to study on a daily basis. I'm not going to talk more than that because I'll end up crying, but my wife said I have recently been much of a crybaby, so I don't want to cry more. So thank you very much to both speakers. Do you still wish to say something? Yes, in that case, please, the floor is yours. No? I want to thank Justice Herman and Justice Benedito, both who invited me to be to preside this panel. I think that just because he was being nice, because I don't know, I'm just here listening. The same here as I would if I was sat in the public. So I am very thankful. It's an honor to have you here among us. So no, I thank you both. I'm very grateful for this speech. Justice, you can close the table here. And we still have here the president of the Court of New York. Is he still here? No, he's no longer here.
Então, antes de encerrar então esse painel, isso. Antes de encerrar esse painel,
closing this panel and delivering the certificates, the president of the court requested that I hand this to the president of the court of in New York, who's not here, but our Dean Lolita, a book of the work that was done in the Chamber of Deputies with 20 black jurists, of which we have here Professor Thalita and Professor Adilson, our president here of the panel. Among 20 jurists, after a tragic case, the chamber created this commission to study the modernization of the laws to fight racism. So we hand this book to you. So I hand the floor now to the president of the chair here, to our chair. So I consider this panel closed, and let's take the picture of handing the certificates. If I do not arrive in João Pessoa with it,
existe em direito duas coisas. Antes de acabar um julgamento, enquanto não proclama, pode-se modificar o voto. E existe ainda um embargo para suprir a omissão, embargo de declaração. Então, vou fazer aqui de ofício e corrigir o nome, não é Thalita, é Thula.
Muito bem.
Tchau. Uma foto. Presidente, tira essa foto também para levar para casa. Claro. Não vai ter que comer esse pão nem. Sim.
Oh, thank you very much.
Thank you so much.
Volta para Paraíba. Chamar já para o próximo painel, que é a apresentação dos enunciados da primeira jornada da equidade racial. Chamarei, então, o presidente desembargadora Rosimeire Gonçalves para presidir os trabalhos. Em seguida, quem vai apresentar os enunciados é o juiz federal Erivaldo, faz favor. Os debatedores são os grupos de trabalho. Eu pediria agora ao juiz Erivaldo para me ajudar nessa questão da mesa. Vamos chamar mais do gênero. Vamos lá. Conto com a sua ajuda. Vamos lá. Posso? bom.
Variedade.
Sim. Juíza Maralina, por gentileza.
Bom.
A juíza
Mais uma vez.
Adriana Meloni, por favor. Frei Davi, não sei se está presente, ele compõe a mesa.
Está lá, olha lá. Olha. Ele que vai muito bem, vamos ver. Quem mais?
Elaine Portuária, compõe a mesa.
Não, eu sento no meu lugar. Eu sento, não, por favor. Eu fico aqui atrás. Não, por favor. O EMA vem depois, só no encerramento. Deixa eu tirar esse daqui para vocês terem mais espaço. Espera aí. Ó, mais espaço. Pronto.
Ele foi embora? Foi.
O ministro Ema não foi embora, não. O ministro Ema foi no trabalho no gabinete e está voltando para o encerramento. Enquanto vamos fazer, então, nosso trabalho dos nossos enunciados, é isso? Mesa composta,
Isso, vamos aceitar aqui.
Então,
Acomodar todos, né?
também, presidente, desembargador Rosemary, esse presidência do presidente Erma. Foram aprovados 49.
So 49 enunciates were approved. They created one here for me to announce.
Em base à declaração, meu amigo. Acabou, tudo definido.
Tudo definido. Minha querida amiga juíza de direito na Bahia.
Tá? Vamos lá. Vamos fazer mais uma cadeira. Já está chegando.
É que nós aprovamos o enunciado toda vez que
Deu certo?
Podemos começar?
Nossa presidente, dos 49 enunciados.
President, of the 49 statements, he came here and started listening to these speeches here. So he said he wanted to announce the first statement, and paraphrasing one of the speakers of today, that was equity always and parity everywhere. I think that is going to be our motto, Justice.
Boa tarde a todos e todas. É uma alegria.
Good afternoon to all. It's a great joy, and the apologist that was here before me, he said it was because of kindness that we're invited to be here. When I received Justice Herman to be here, I also had the same feeling that he wanted to give me some recognition beyond what I myself imagined. Thank you very much, and I thank here publicly for this recognition. I want to greet everyone in the name of I would like to greet Justice Benedito, and I thank as well. I could not forget to. I always have the feeling after I hear Justice Edilene that I wanted more and more, have more, drink more from this water. And as someone from Minas, I said, oh my God, what joins us aside from us being from the same Minas? And then I noticed that because I'm from Taiobeiras in the north of Minas, a more agrarian area, that she was born in that huge family, certainly with many challenges. Perhaps that's the big difference. I was born in the northeast of Minas, in conditions to transform myself in that quiet person from meanness, more traditional one that everyone knows.
Honrar, né, essa mineirice e trazer aqui algum comentário sobre
So I want to honor our state of meanness and just to mention all of this that we heard so eloquently, that made us think so profoundly about what we are debating, what it means for the legal framework, what the symposium represents. Justice, Benedito.
algumas referências, né, jurídicas para
I was searching for some legal precedents so that I could add something to what was already said.
resolvi recorrer por constatar que já
Noticing that the subject has already been approached with what was proposed during this event, I went to look to the literature where I always go when I'm lacking words in moments of great emotion and satisfaction.
Bom, para conduzir essa mesa, portanto, que tem como propósito apresentar
So to conduct this table, that has to announce the statements of this journey, but all have already been presented very wonderfully.
Então, recorro-me à
So I recur to the literature of Jefferson Tenário to just reinforce the importance of this event. When I'm reading the book, Skin Inside Out, it speaks exactly of the things that put inside out to remind us that we're more than the skin. We are that we think or feel and what is inside. Because of a police violence that his father suffered, his father also said because that the black people must fight because the white wealth has removed almost everything from us. It is necessary to preserve the inside out. Because it doesn't last long and the color of our skin goes through our body and determines our being in the world. As well as reading the book Skin Inside Out is still necessary in our country, still structurally racist. Something that we must make an effort to do the just and fair reparation, historical reparation with black people of this nation.
Estamos aqui plantando as sementes para uma mudança histórica.
Many important reflections were made, and now it's important to receive the result of this work, a work that was developed by many hands, representatives, and with the objection to have a firm path in the sense of racial equity. At the end of the day, we all look for a judiciary. I had said something else, but I removed it after Adriana's speech. We all look for a judiciary where we have parity in everything and racial equity always. So now, after this, I pass the floor to my dear Erivaldo, that was the organizer.
Boa tarde a todas e todos.
Good afternoon to everyone. I would like that Dr. Joaci feel himself as part of this table as well.
Dos enunciados. Uma metodologia e uma organização que me encheu de inveja, né? Porque sou
speech that an organization that I was very really envied, and also with the appellate justice here that was very important in the construction of many statements here. Also Douglas Melo. And all that were part of the group of statements here. I would like to thank personally dear Justice Benedito, since October that this group has been put together discussing the statements. Justice Alves gave the start. We said, yes, you can start discussing this. We get together virtually, and in 14 virtual meetings, I ended up having more than 40 hours of discussions. Few of them were in person. Justice actually, they were yesterday, 9 in the morning. We ended almost at the ending of the opening of the symposium. And they were very rich discussions. We imagined I in my innocence, arriving with 53 pre-approved statements for the discussion. Everything would be solved in half an hour. We would perhaps proclaim the result. I was mistaken. Because the in-person meeting, I think this exchange of energy that is so necessary and important to have this this contact meant that we had several adjustment proposals, and I would like to thank everyone that contributed intensively to improve the writing of these statements, very close to what we hoped and wished for them to be, but obviously always there's always space to improve. Justice Frei Davi, Friar Davi, with intense participation in the group of the statements, he said, Edivaldo, do you think it's possible to bring a group of young Black people from Bahia just to listen to the statement? And so we agreed. Friar Davi and I agreed on that. And so we already knew we weren't actually going to respect that pact. Just as listeners, Black people in their space of speech, no. The first statement that we started discussing, someone already raised their hand and said, I have suggestions. Over the group of Friar Davi, the pact was broken, and so we opened up so that everyone could make their suggestion. I would like them to please stand up so we can have a round of applause for them.
Justice, they made comments that were very important for the amendments to the statements. And I'll never forget the adding of the word religious and ethnic racial. Guys, thank you very much for that. You have corrected our path. Thank you. And thank you very much, Friar Davi and Educafo, for allowing us to have this beautiful moment for reflection, with whom Justice Edilene, Justice Benedito, and all of us, Black people, with the people who feel on a daily basis the pain of racism. We built these statements knowing what we're talking about. But I also have to mention and express my gratitude prior to the judges who, even though they don't feel the pains of racism themselves, they made wonderful contributions to these statements. And here I would like to highlight the participation of Federal Judge Clarides. I don't know if she's here. Judge Clarides is a scholar of the topic. She's a sociologist, and she provided very valuable contributions to the amendments of the statements, and my sincerest gratitude for your participation. Thank you very much. And in honor of the Black Bar Association of Bahia, I'd like to share with you the statements that you helped to create. So the first reading would be statement 1, and I'll ask Costa to read it, please.
Pode ser aí, pode ser lá.
You can do that from where you're standing, wherever you want.
Boa tarde a todos e a
Good
todas.
afternoon, everybody. First, I ask leave to speak to my elder with whom I own my work, and to the people who are younger than me, to whom I own to be an example. I'm from the state of Bahia. I'm a retired judge, and one of the things that are most gratifying for me is knowing that I'm always accompanied by young people and always learning. And we went to that space of the first equity journey in federal justice with the idea of only listening. But the environment was so democratic and welcoming that we felt comfortable to speak. And we almost took a vote, because by the end we were raising our hands when it was time to vote. And I remember very well the very welcoming attitude of Dr. Joaci and Edivaldo. They did the following: they would read the statement, and then they looked at us, rated our comments, and then he would address the peers, saying, you have 10 seconds, you have 5 seconds, 15 seconds. So we come here with the experience that we have and the journey that we went on to contribute, and to say that these statements are not only statements by the National High Court. These are statements made by lawyers, by the Bahia Bar Association, and we will defend it like we defend everything, like we defend our clients and the people we want to help. And we always try and break the rules, or at least bend them, because we understand that what the courts need to know can be discovered in traditional communities, in popular movements, in the streets. And since I'm referred to as the deacon because I'm always among young people, I say that institutions must learn from the solutions that have been invented inside these communities, these associations and organized societies that live on a daily basis, producing and keeping themselves alive. Because if the institutions have grown old and obsolete, society hasn't. And I'd like to take advantage of this moment, because we just lost a great leader, a very wise person who came to the University of Brasilia to produce science, popular science. Nego Bispo, he passed December 3rd last year, and I would like to bring a contribution from him. I apologize, Dr. Edivaldo, but I think it's essential for me to do this. He says, fire. They burned Palmares, and Canudos was born. Fire. They burned Canudos, and Caldeirões was born. Fire. They burned Caldeirões, and Pau de Colher was born. They burned Pau de Colher, and so many other communities were born, and they will grow tired of burning us, because even if they burn our writings, they will not burn our words. Even if they burn the symbols, they will not burn the meanings. And even if they burn our people, they will not burn our ancestrality. And with that, I like to say that we are alive and we will keep on fighting and transgressing. And we had agreed with Dr. Paulo that we would bring all of the participants and please, I'd like to ask everyone to come up here because you all collaborated. And the first statement is the following. Judges must judge from a racial perspective, guaranteeing that racist practices are recognized and corrected through reparation measures that are appropriate for Black people to be treated with respect and dignity, considering the material, moral, economic, and psychological impacts of all forms of racism on the victim. Thank you, Clara. Roberto Oliveira. Statement 2. Good afternoon, everybody. First, I'd like to say it is a pleasure, and I'd like to thank Friar Davi for trusting the Bahia delegation. And we organized this delegation in less than 24 hours, if you can believe, and we're here in a group of 23 people, and it was very enjoyable. Like Justice Herman Benjamin said, it would be very important for the courts to send the lists and the Bar Association to send the lists, including the equity issue. And I'd like to say that Educafo, the entity we're here representing, is fighting so that the National Congress approves a bill of law to change the Constitution so that for specific positions in the courts to be exclusive for Black people. And that's the only way in which we'll be able to burst the bubble and change our racist system. I would also like to acknowledge our appellate judge from the state of Bahia, Maria da Purificação. We're very proud of her, our representative from Bahia. Statement number 2, for an anti-discriminatory, intersectional, and inclusive perspective, the jurisdictional action requires that the control of conventionality is observed considering the national legislation, considering the normative structure of the international universal human rights system, and this includes the jurisprudence of the Inter-American Human Rights Court according to the principles and norms recommended in Recommendation 123 of 2022 CNJ. Thank you, Roberto. Duane Bonfim.
Boa tarde a todos. Meu nome é
Afternoon, everybody. I'm Duana Bonfim, and I will read statement number 3. The vulnerability of Black people in Brazil, stemming from historical conditions of discrimination and exclusion, constitute a factor that has impact in legal and social relationships and should be addressed specifically by the state through the adoption of affirmative measures in all social spheres and spheres of law. Thank you very much, Duane. Paulo Andrade. Statement number 4. I'm sorry to break protocol, but we have a rule that we go together, we do everything together, and we go back to our land together. So I will read something that speaks a lot about our journey. In some, well, it has It's not long, but it really addresses the Black journey. And I'm going to sing it.
Neste chão, nesta terra de meu Deus, quem falou que eu ando só?
And
Basicamente,
who says I'm walking alone? And basically, this chant expresses the idea that all Black people, even though we are an individual, we are never alone. And I will read the fourth statement now. Statement number 4. Police approaches based on racial profiling practiced to the detriment of Black individuals or communities translate institutional racism that should be addressed by the state and held accountable for psychological and physical individual or collective harm. Thank you, Paulo. Jessica Coimbra. Statement number 5. Good afternoon, everybody. Here today, this afternoon. Statement number 5. In the cases of racial discrimination, indirect racial discrimination, the civil responsibility of legal practitioners of public or private law is regardless of the show of intent or guilt. And I will ask your leave to break protocol, but this, which is happening today, is a revolution for someone who has lived throughout their lives in a constant struggle, which is being Black. I really doubt that someone who doesn't have the experience of being Black, even though we see discussions that say this is not important, want, for example, their children to be stopped by police and treated as if they were Black. If no children by non-Black people has their parents wanting them to be treated as Black, you can see why we're doing all of this.
Eu vou prosseguir, ministro, com a leitura.
Continue, Justice, with the reading of some of the statements that were chosen by our colleagues who will do the reading, because we have many statements and we can't read all of them because we don't have time. So I'll ask Andremara to read statement 40. Please, Andremara.
Mas não está funcionando, não. Esse está. Sendo obediente pelo menos uma vez na vida.
I'm obedient at least once in my life. And after everything that has already been said, I will now read statement 41, which was created based on an initial suggestion by our colleague Melo, a judge from the court of Maranhão, who's here today. It is the duty of digital platforms to safeguard diversity and to comply with the current legal norms under penalty of being held accountable. The discrimination of algorithms due to the biased contextualization of computational systems by humans and machines violate the principles of equality and dignity of the human person, structurally contributing to the differentiated treatment pre-trial that is not justifiable of people based on their race, color, ethnicity, sex, disability, and other situations protected and safeguarded by the federal constitutions and international treaties of which Brazil is a signatory. Andremara, I would like to make an acknowledgement of your contributions to all of these statements. Andremara
quando se inconformava com a redação. Ela
when she was dissatisfied with the text, she called upon everyone to engage in the discussion, and she really spearheaded this reflection, and the product that is being delivered is very much the fruit of her refusal to settle.
Adriana Melônio, eu quero fazer
Melônio, Justice Majiedt, labor justice, our specialized labor justice, it awarded this journey with several labor issues that were so sensitive that us, federal and state judges, couldn't even touch on or alter. And more than that, they were very generous. In some parts of the text, they agreed that we would expand the scope so that we could also allow for interpretations in the other fields of justice. And this shows how wonderful were the colleagues who contributed. Manu, who isn't here, Adriana Melônio, who isn't here. I'm here. Oh, sorry, Adriana Melônio is here. And I know that in parallel to the journey, you discussed the statements. So I would also like to register my gratitude, which is extended to everyone in labor justice for working in these statements. Thank you. And you're going to read 1029. I let him know, don't ask us to do anything because we are always very present and very aggressive. So don't call us if you're not able to deal with that. So some of the statements were initially written by me, but some of them were discussed in the race committee of the National School of Labor Justice. So in addition to my and Manu's work, we also had the work by our race colleagues. And I will read 1029, which says, the judge must recognize and consider intersectionality of the discrimination faced by Black women in the labor market, paying attention to the combined and aggravated impacts of racism, sexism, and homotransphobia in their trajectories and professional opportunities, and also the use of gender and race stereotypes in the processes of hiring, promotion, remuneration, and evaluation of performance, which constitute discriminatory practices to be considered in their action and judgment.
Muito obrigado, Adriana Melônio.
Thank you very much, Adriana Melônio. And once more, our sincere thanks to the labor justice. So that's not the only one. There are many other things I'm working on. And broadly discussed, Justice Herman, who is already present here. So, my dear friend Maralina, the statement 1038.
São 50 no total.
50 in total.
Boa tarde a todas as pessoas.
So good afternoon to everyone here.
Não vou me alongar e nem falar mais nada, mas eu não posso
I'm not going to take too long, but I cannot not thank you all for the invitation and the partnership. So much learning that it was with all the contributors, not just that were in the working group, but those that came from the capital. Fantastic contribution, very enriching. I learned a lot in this journey and in this work to write these statements with colleagues, Mônio, Laci, Rivaldo. So the statement I'm going to read is the 1038. And that is, the statement is very much linked to the question that was asked. What are the the efficient methods to actually get equity in the legal branch. And without money, we're not going to be able to do anything. It's necessary, be it more or less resource, but it's always necessary. So the statement says the courts must include in the budgeting, yearly budgeting, and destination of resources to do pertinent actions to the continued capacity building, magistrate service, and third parties members, which includes courses, seminaries, cultural events, among others, as well as for the acquisition of bibliographic material academically referenced to make part of their respective libraries. My dear Rosemary, that presides this panel, is also gonna read the statement 1010. So I'm going to read here, but first to mention that they are so impactful, these statements, and so much depth, that it's the result of a very big labor. That took some time to diffuse and do, because each and every one deserves analysis, study, and education, so that this can be transformative. The 1010 has already been the subject of comments and sums up a very important idea, which is the presence of Black men and women in spaces of power and leadership, including the justice system, or I would say especially, which is essential. Since racial democracy is a myth, as the power structures that exist contribute for the aggravation and to perpetuate the racial issues, which makes us already think a lot, because it makes us face reality. Thank you, Rosemary. My dear friend Elaine Cantuaria also would like to mention the thanks for the contributions, the many contributions that she gave us with these statements. So 1019. First of all, I would like to thank the invitation to be part of this study group, this valuable study group, and participate of this historical moment for us, Black people in the Brazilian society and in the judiciary. It's a moment that is unlike any other. Very soon we will be seeing the fruits in the judiciary and public policies, because this was our big objective, to, in reality, look at this, and this reality become also a practice at the tables of the magistrates and in the Brazilian society. The statement I'm going to read to you has to do with this practice, which has to do with the hetero identification and the public exams, because recently we have had a lot of fraud. People print themselves, they present themselves in the public exams bronzed, and remove the space of those who actually deserve it historically. And so we reached to the conclusion that when, in the case of insufficient photos collected to confirm the self-declaration of the candidates, there is the investigation foreseen in the paragraph of the resolution 551 of the CNJ must take place preferentially in person to ensure the efficacy and the impartiality of the administrative process. Thank you very much, Elaine. It's a joy to know that we also have the reading of the statement that she herself chose, 1048. Thank you, Justice. I'm the one who thanks you. Thank you once more. The statement is written as such. Environmental racism is characterized by the unproportional distribution of risks and environmental damages and territorialization of those that are racially marginalized, or the non-participation of these people in the planning and execution of public environmental policies. It's facing demands affirmative action from part of the public power and civil society, aiming to promote environmental justice together with the block of constitutionality and the international engagement undertaken by Brazil in fighting racism and racial discrimination, including the Inter-American Convention Against Racism, Racial Discrimination, and correlated forms of intolerance. Thank you, Justice. And thank you very much for choosing this statement. We have recently had in 2023 a journey of the cultural heritage, and Clarice and I are trying to approve a statement that would be tangential to this environmental racism issue.
Eu prefiro estivéssemos preparados naquele momento, né, Clarice, para aprovar
A gente estava
com esse conteúdo. É verdade, Clarice, que aquele enunciado ele não é tão didático quanto esse, não é? Esse enunciado. Perfeito. Então, de lá para cá, amadurecemos, propusemos e temos uma alegria muito grande de aprovar esse enunciado, que é confirmado pelas estatísticas do próprio IBGE. 70% das pessoas que moram em favelas são pessoas negras. E, obviamente, que qualquer desligamento de um morro, uma favela, vai atingir mais pessoas negras. Não dá para negar essa realidade. Eu acho que o enunciado está estruturado didaticamente para explicar essa situação, exigir políticas públicas que invertam essa estatística. Foi, Davi, está pedindo a palavra, por favor.
Ministro presidente, já me está aqui na casa nesse momento ainda, muito significativa, uma ajuda, um favor. Ministro, a fala da ministra Edilene no tribunal foi muito forte, mostrando a maldade do sistema com referência ao desvio das verbas destinadas a mulheres e negros. A nossa entidade do CAF Brasil, ministro, abriu a ADI 749, lógico, usando o nome de partidos políticos. A ADI 749 solicita ao STF que determine aos partidos que devolvam o nosso dinheiro. E aí, ministro, infelizmente, o ministro me falou, não vai te dar cuidado, eu já vi, o Senado contra nós está tão grande. Se eu exigir isso agora, nesse exato momento, talvez eles mandem quebrar o STF esse segundo 8 de janeiro. Mas aí, ministro, para nossa dor, a gente fez várias ações positivas de levar núcleo, como tem irmãos negros, para dentro da Câmara, quando estávamos votando a PEC 9. Que talvez desviar o dinheiro das mulheres e dos negros para os brancos e os mesmos de sempre. E aí, a gente não conseguiu deixar votar a PEC 9. Mas um monte de maldade desculpa falar abertamente assim, do presidente Arthur, então pegou a PEC 9, como esperava, em meia hora, botou votação e transformou, a PEC 9 transformou em 633. E nós entramos no STF com a ADI 7706. E essas são unidades. E o STF obriga os partidos na forma da Constituição e esse dinheiro, as mulheres e os negros. São duas ADI com o mesmo objetivo e com detalhes diferentes. está parado lá, porque os nossos irmãos do STF entendem pode gerar o maior conflito com essa. Até quando nós devemos pagar a harmonia dos brancos? E o que eu peço ao senhor de coração sincero, como o senhor é um homem do bem, que dê um toque com o nosso querido irmão Barroso, que é irmão nosso também, que é o autor da ADI 749, e dê um toque no nosso irmão Zanin, que é o autor da ADI 7706, para que eles botem votação e tenham coragem de melhorar o Brasil. Só isso.
Ministro Herman Benjamin, eu quero fazer um registro e não posso deixar de fazer esse registro. O senhor já queria fazer esse evento ano passado, né? E fez esse ano. E eu sou testemunha do seu esforço, da sua combatividade, da sua sensibilidade, de quanto o senhor nos moveu a isso, com uma sensibilidade que em muitos momentos me tocou e me emocionou. Esse evento, ele está acontecendo, obviamente, com essas entregas, pela qualidade desses participantes, dessas pessoas, desse povo negro da Bahia, que nos brindaram com belíssimas contribuições, mas nós não podemos deixar de agradecer ao senhor por esse empenho, por essa dedicação que moveu a equipe do STJ, a equipe do Conselho da Justiça Federal e do Centro de Estudos Judiciários. E se empenhou de maneira tão linda, tão emocionante, que o senhor realmente fazia a gente trabalhar e fez por esse evento, em qualquer hora do dia ou da noite. E nós fizemos isso com muita alegria. Giovana, que está aí ao seu lado, foi uma guerreira na organização desse evento. Joaci, que está ali mais atrás, ministro, esse juiz, Joaci, ele tem uma metodologia para conduzir os debates da jornada que é impressionante. Nós somos e seremos eternamente gratos ao senhor ministro Herman Benjamin. Mas eu ainda quero fazer um outro registro. O senhor trouxe Chico César. E trazer Chico César, esse pessoal tietando Chico César, estava lindo de ver. O senhor trouxe Chico César, que para nós tem uma representatividade incrível. E Chico César é seu amigo, né? E cantou lindamente para nós, porque a música de Chico César expressa as nossas dores. Respeite meus cabelos. E ele fez questão de dizer ontem, vírgula, brancos. Muitíssimo obrigado. Eu não tenho palavras para agradecer. E antes de encerrar, ministro, o senhor aprovou também que nós fizéssemos uma carta de encerramento desse evento. E aí, Adriana Meloni e Maralina, desculpa, Adriana, Maralina e Elaine Cantuária, fizeram uma divisão do texto e farão, então, a leitura da carta, se o senhor me permitir agora, ou o senhor prefere mais em outro momento, o senhor quer fazer agora? Então, por gentileza, vocês farão a leitura da carta do evento.
Tá. Carta de encerramento da primeira jornada da Justiça Federal pela Equidade Racial. O grupo de trabalho que participou da primeira jornada da Justiça Federal pela Equidade Racial, realizada em 4 de dezembro de 2024, no Superior Tribunal de Justiça, após intensos debates e reflexões, reafirma o compromisso com o enfrentamento das desigualdades étnico-raciais no âmbito do Poder Judiciário brasileiro. Os participantes reconhecem que, 1. A desigualdade étnico-racial, enraizada em condições históricas de discriminação e exclusão, requer uma atuação estatal efetiva e contínua por meio de medidas afirmativas e ações antidiscriminatórias. 2. O direito, historicamente, foi construído em bases racistas, perpetuando desigualdades e negando às pessoas negras dignidade e direitos fundamentais. 3. A formação inicial e continuada de magistradas e magistrados é essencial para capacitá-los na aplicação do direito antidiscriminatório e no julgamento com perspectiva racial, conforme estabelecido pelo Protocolo para Julgamento com Perspectiva Racial, Resolução CNJ 598 de 2024.
4. O controle de convencionalidade e a adoção da jurisprudência nacional e internacional antirracista são indispensáveis para decisões judiciais alinhadas aos princípios de igualdade e não discriminação. 5. A aplicação da Convenção Interamericana contra o Racismo, a Discriminação Racial e formas correlatas de intolerância, integrada ao Bloco de Constitucionalidade brasileiro, é imperativa em todas as decisões envolvendo pessoas negras. E o combate aos estereótipos e vieses cognitivos no sistema de justiça é crucial para garantir julgamentos justos, especialmente em litígios que envolvam questões étnico-raciais, considerando os impactos material, moral, econômico, psicológico e intergeracional do racismo estrutural e institucional. Elaine vai ler o resto.
Acho que não está agora. Delibera, então, o grupo de trabalho propor ao Superior Tribunal de Justiça e ao Conselho da Justiça Federal a instituição de um grupo de trabalho interdisciplinar e interinstitucional de atuação permanente para estudos, discussão e elaboração de enunciados e a realização de jornada anual sobre equidade racial, preferencialmente em novembro, com os seguintes objetivos: fortalecer diretrizes de formação de magistradas e magistrados, promover capacitações regulares em direitos humanos, direito antidiscriminatório e letramento racial nas escolas judiciais e de magistratura, produzir conhecimento técnico e científico, estimular estudos e pesquisas para subsidiar ações concretas que identifiquem, previnam e superem a discriminação institucional no sistema de justiça. Promover efetiva igualdade e diversidade, remover barreiras para a pauta antirracista em todas as esferas do Poder Judiciário, fomentando a diversidade em suas relações internas e externas. Fortalecer o combate à discriminação, estimular a implementação de políticas públicas e ações afirmativas que promovam equidade e justiça racial em todas as esferas do sistema de justiça, englobando áreas judicial e administrativa. O grupo de trabalho reafirma que a efetivação desses compromissos é essencial para a construção de um sistema de justiça mais justo, inclusivo e comprometido com a equidade racial. Brasília, 5 de dezembro de 2024.
Bem, eu peço que os integrantes da mesa sentem, porque essa é a mesa mais bonita que nós já tivemos em eventos do Superior Tribunal de Justiça. Eu comentava isso agora com o presidente Tribunal de Justiça de Nova York, porque nós temos o dobro de homens e uma divisão perfeita entre juízas e juízes federais e estaduais. Esta é a magistratura brasileira. E eu peço uma salva. Aí é para todos nós. Eu queria agradecer ao ministro Benedito, ao doutor Erivaldo Ribeiro, que é o secretário-geral, e aqui você veja que eu estou usando o tom formal, porque agradecimento tem que ser assim. E na pessoa dos dois e do Tiago, que é meu principal assessor, está sentado ali. Tiago, levante, por favor. Tiago está em tudo que eu faço. Aí ele consegue estar em tudo com... Às vezes eu acho que ele levita, que a gente não percebe. Não percebe porque tudo ele faz com muito prazer. E ontem prestou concurso para o Superior Tribunal de Justiça. Eu não participo da organização do concurso, já quero explicar, porque se ele passar, e se não passar nesse, passará no próximo, eu não tenho nada a ver com isso. O concurso é feito por um setor próprio do STJ, eu não sei nem quem está organizando, quem é a banca. E agradecer também, então, no nome do Benedito, do Erivaldo, do Tiago, eu queria agradecer a toda a assessoria do STJ e do STJ. Precisaria muito tempo aqui para nomear a todo mundo. Mas há duas pessoas que ajudaram muito. E ajudaram não é porque são assessores, é porque entendem a importância da temática. O diplomata ministro que está aqui sentado à frente discretamente, mas não é tão discreto, porque é um pouco alto, e ele está aqui, o ministro Arnaldo Baena está aqui no STJ, veio de Roma, onde eu o sequestrei. E ele achava que vinha para Dolce Vita. E não parou de trabalhar. Mas está muito feliz, ainda rindo, e mais ainda com os resultados do nosso evento. Ele foi muito importante na parte internacional deste encontro. Juntamente com a doutora Giovana Carneiro, que está sentada ali. Esta eu sequestrei de Harvard. Fui dar uma palestra, ela era aluna, e eu já fiz uma oferta. Eu nem presidente era, nem sabia se ia ser eleito. Eu disse, olha, você tem planos para depois do curso? Não, eu estou pensando em ficar nos Estados Unidos, não quer voltar, não quer ir para o STJ. E ela trabalhou muitíssimo nesta organização. Mas, ministro Benedito, o mais importante mesmo são, além dos conferencistas, palestrantes, foram tantas palestras boas, eu aprendi muitíssimo. Mas o mais importante mesmo são os participantes. Porque a energia boa, a energia que nós tivemos aqui, energia de energia de mudança, de transformação, sincera, era evidente foi evidente durante todo este evento. Então, a vocês, eu agradeço muito. Haverá outros, porque a carta faz um apelo, o apelo já foi aceito, deferindo aqui. Só não sei se novembro é o melhor, porque eu já quero fazer em março. Que é para poder influenciar o ano inteiro. Senão vai ficar como coisa do ano passado, e nós, no direito, temos essa coisa, tem que ser o mais recente. Não, já vamos fazer em março, no começo de março, e aí vai ser uma oportunidade para nós revisitarmos os enunciados, fazermos comentários sobre os enunciados, trabalharmos vídeos sobre os enunciados. E quem sabe, ministro Benedito, com a Infam, fazer um curso sobre os enunciados. Tudo isso para dar vida aos enunciados. E minha última palavra é sobre aspas, agradecimento que o Erivaldo fez. A gente agradece algo quando é feito por favor ou de favor, mas não quando se faz por dever. E o que eu fiz aqui, nós todos, nós fizemos por dever. Não há o que agradecer. Agora, a presença do Chico César, sim, aqui, sim. Este agradecimento, em nome dele, eu aceito, mas é o único. Eu passo, então, por última palavra ao ministro Benedito para encerrar este evento. Não sou eu que devo encerrar, é ele, o nosso querido ministro afrodescendente, que vai fazer o encerramento.
Muito obrigado, presidente. Eu estava aqui conversando com o nosso juiz, Erivaldo, sobre o evento. É assim, aqui a jornada, e claro, é a primeira de várias, já foi a proposta aqui, produz. E a Infam vai aplicar em diversas formas. Curso, modalidade, seminário, aqui você vai sempre produzir. E a Infam sempre com as portas que nunca fecham para transformar em efetividade na formação dos juízes.
E há um aspecto, veja que já virou diálogo. Ele ia fazer um encerramento. Há um aspecto... há um aspecto que eu estou autorizado também pelo ministro Luiz Felipe Salomão, me deu carta branca, é um risco enorme. Não, ele não sabe. Carta branca como diretor do SEG e corregedor da Justiça Federal para aceitar tudo que propusesse. Eu disse, você tem certeza? Você não conhece o grupo que está preparando esta... Então, aqui, em nome dele também, eu já digo que está aceito, não é? Mas, desculpe, eu interferi e fiz um... Mas está aceito também.
Mas é importante para saber que não vai terminar num relatório, numa carta de intenção, não. A intenção vai se efetivar. É isso que é importante, né? Mas, presidente, então, chegamos ao encerramento do primeiro simpósio, vão ter vários, internacional pela igualdade racial. Um evento que demonstra a importância de nossas discussões sobre justiça social e igualdade. Quero, antes de mais nada, expressar minha profunda gratidão a cada um de vocês que contribuiu para a realização e para o sucesso deste evento. Toda a equipe, todos aqueles que ficaram aqui. Achei interessante que ontem acabou mais ou menos que 10 da noite, e esse auditório cheio. Hoje continua. Quer dizer, todos têm isso a fazer, mas fica ali. Dá a impressão que alguns vão lá e voltam, porque a expressão facial que eu vejo aqui parecida. Registro meu agradecimento ao ministro Hermes Benjamin, de forma muito especial, pois sua liderança e visão foram fundamentais, tanto para a realização quanto para o enorme engajamento, já foi aqui testemunhado, dos participantes de sucesso do simpósio. Ministro Herman, sua liderança e compromisso com a promoção da equidade racial são fonte de inspiração para todos nós. Em nome de todos os presentes, registro novamente aqui nosso enorme agradecimento. O inedismo desta iniciativa representa um grande passo na luta pela equidade. Ministro, este simpósio foi muito mais que um marco no calendário do nosso STJ, do nosso Judiciário. Ele foi um verdadeiro farol que iluminou os desafios que enfrentamos e os caminhos que precisamos trilhar para construir uma sociedade verdadeiramente justa. Expresso também minha gratidão a cada um de vocês que trouxe sua voz, sua experiência, sua paixão para este espaço de inestimáveis aprendizados e trocas. Nesses 2 dias, ouvimos relatos, aprendemos lições e compartilhamos, sobretudo, esperança. fomos confrontados com a realidade de que, embora tenhamos avançado, o racismo ainda é uma força que opera nas sombras e, às vezes, à luz do dia. Ele afeta vidas, limita sonhos, enfraquece as estruturas de uma sociedade que pretende ser democrática. Como vimos aqui, o racismo não é apenas um problema individual, ele está embutido nas estruturas do poder, nas instituições e até nas narrativas que muitas vezes naturalizam a exclusão. Por isso, combatê-lo exige mais do que intenções, exige coragem, ação e comprometimento em 3 níveis essenciais. No Estado, por meio de políticas públicas que enfrentem a desigualdade de forma direta e decidida. Na sociedade, ao reavaliarmos nossos valores e abraçarmos a diversidade como uma força transformadora. E em cada um de nós, reconhecendo e desconstruindo preconceitos, para que possamos ser agentes de mudança em nossas esferas de atuação. Tivemos ainda o privilégio de aprender com as experiências dos Estados Unidos, da África do Sul. Países assim como o Brasil carregam as marcas do racismo, mas também histórias de resistência e superação. Essas trocas reforçam que o combate ao racismo é uma luta global, uma luta que nos une pela humanidade que compartilhamos. Nesse ponto, precisamos enaltecer quão importantes foram as vozes femininas negras, ao trazer reflexões importantes, demonstrando um profundo conhecimento histórico e cultural, histórias e narrativas marcadas por resistência, luta e protagonismo. As mulheres negras têm sido centrais na denúncia e na busca por justiça e igualdade, moldando o panorama da luta antirracista do país. Encerramos esse simpósio com a aprovação de 50 enunciados. Já ia errando, 50 enunciados. O primeiro qual é mesmo, hein? Igual colégio. Qual é o primeiro? Igualdade sempre, paridade em tudo. Esses enunciados são mais do que diretrizes, eles são promessas de um futuro em que a justiça será verdadeiramente para todos. Finalizar um evento tão significativo é um momento de profunda emoção e inspiração para as ações que precisam ser efetivas no combate a qualquer tipo de racismo. Que possamos, em nossas diferentes esferas de atuação, ser agente de transformação, garantindo às próximas gerações um mundo onde os sonhos sejam realizados em condições iguais. A luta contra o racismo não é apenas uma questão local, mas um compromisso global. As experiências compartilhadas entre nossos países demonstram que os impactos do racismo são interconectados e que combater a injustiça, onde quer que ela exista, é essencial para construir sociedades verdadeiramente justas e igualitárias, como já foi dito aqui alguns das palestrantes, contemplado no artigo 3º da nossa Carta da República. Se há algo que espero que todos levem daqui, é a certeza de que a luta pela equidade racial não é apenas necessária, ela é possível. Não é um sonho distante, é uma responsabilidade coletiva que começa aqui e agora. Se há uma mensagem que desejo registrar, é esta: a equidade racial não é o ideal distante, ela é uma tarefa urgente e inadiável, que começa com cada um de nós. Não podemos mudar o passado, mas precisamos agir para que a luta pela igualdade não seja adiada para o amanhã, porque ela é necessária hoje. Para cada criança que sonha, para cada jovem que busca oportunidade, para que cada adulto que enfrenta o dia após dia os desafios impostos pela desigualdade. Permito desafiar as palavras de Martin Luther King Jr., que nos lembrou, aspas, a injustiça em qualquer lugar é uma ameaça à justiça em todo lugar. Fecho aspas. Que essas palavras sejam o nosso norte enquanto seguimos adiante. Que elas nos inspirem a transformar este momento em um movimento, essas reflexões e ações, este compromisso em resultados concretos. Saímos daqui, desse simpósio, com a certeza, o caminho é longo, mas juntos somos mais fortes. E com essa força coletiva que construiremos um mundo onde a cor da pele não determinará mais o destino de ninguém. Muito obrigado. Cadê o presidente? Peraí, cadê ele? Peraí, é onde? Temos que tirar as cadeiras.